Admission. Admission.
Adjournments. Page wise. Page 1, cell number 1. Page 2, cell number 2 to 4. Page 3, cell number 5 to 8. Page 4, cell number 9 to 12.
10, not serial number 10. I have to produce not the documents. If it is ready not today, we will serve the copy and file it in the office. Or tomorrow or day after next week.
Yes, who is for the other side? They are there. Kritika Raghavan, third party.
We will serve a copy.
Appearing for next week. Anytime next week. As requested, right? Who has to file? Appellant, some documents.
Yes, ma'am. 50.
As requested by the appellant, list in the next week. Yes. Page 5, seal number 13 to 15.
Lord 15, serial number 15.
Huh.
Lordship recollects, this is the matter after remand by the Honorable Supreme Court. They have served us the.
I filed the paper book. It's Mr. Mahadevan is not in town today. He's appearing for the official liquidator. And therefore, we would request for 18th if possible, if convenient to this honorable court.
Compliance of office subsection. as per
Second
the
set has
order.
also been filed, my lord.
Hmm?
The second set of the paper, the first set, only first set was
Copy
available.
not served on the other side. That is synopsis copy.
La-
Who has
uh,
filed?
That they have served.
That-
I have received the synopsis yesterday.
So, no, what is that office subsections by learned AAC ಅಂತ ಬರ್ತಿದಾರಲ್ಲ ಅದೇನದು? Alright, some at least the synopsis along with list of dates filed counsel for R2.
I have served the copy on the other side.
Non-filing of synopsis by counsel for R1.
That is Mr. Mahadevan.
So these two will,
One and
hold
two
that
has
there.
been complied.
One ಏನಂತ ಗೊತ್ತಾಗ್ತದೆ?
ಅದು non-compliance of office objection.
Non-compliance, what is that non-compliance?
I think legible copies, there was an office objection, but now I have filed a paper book,
Paper book have filed.
respondent number 2.
ಏನದು office objection number 1 AAC ಇದೆ ಏನದು?
They have filed paper book like this for the convenience of.
That is, we will clear them, at least
In it,
step will go
Yes.
ahead.
in it.
Legible copies. ಅಲ್ಲ ಪೇಪರ್ ಸ್ಟಿಚ್ ಮಾಡೋದನ್ನ ಮಾಡಿ ಲೆಸಿಬಲ್ ಸೆಕೆಂಡ್ ಸೆಟ್ ಅಪೀಲ್ ಮೆಮೊ ಕಾಪಿ ನಾಟ್ ಫೋರ್ತ್ ಕಮಿಂಗ್ ಸಿನ್ಸ್ ಮ್ಯಾಟರ್ ಪರ್ಟೇನ್ಸ್ ಟು ಡಿವಿಷನ್ ಬೆಂಚ್ ಪೇಪರ್ಸ್ ಟು ಬಿ ಸ್ಟಿಚ್ಡ್ ಪ್ರಾಪರ್ಲಿ ಅಂಡ್ ಲೆಸಿಬಲ್ ಕಾಪೀಸ್ ಟು ಬಿ ಫರ್ನಿಶ್ಡ್ ಕಾಪಿ ಟು ಬಿ ಸರ್ವ್ಡ್ ಆನ್ ದ ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಇಸ್
A
ಸರ್ವ್ಡ್
copy,
ಸೆಕೆಂಡ್ ಸೆಟ್ ಆಫ್ ಅಪೀಲ್ ಕಾಪಿ ನಾಟ್ ಫೋರ್ತ್ ಕಮಿಂಗ್ ಅಪೀಲ್
Lord,
ಕಾಪಿ ಸೆಕೆಂಡ್ ಸೆಟ್ ಬರ್ತಾ ಇದೆ
Second set copy ಕೊಟ್ಟಿದ್ದೀವಿ ನಿನ್ನೆ. It has been filed on 1st of July.
ಅದೇನಿದೆಯೋ ಒಂದ್ಸರಿ ಚೆಕ್ ಮಾಡಿ
ನೋಡ್-
ಬಿಕಾಸ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಇಷ್ಟು ದಿಕ್ಕಿದೆ ಇಷ್ಟು ದಪ್ಪ ಇದೆ ಅಲ್ಲಿ ಅಷ್ಟೇ ಇದೆ ಕಾಪಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ
It will be done.
Leonard AAC submits that part of the objections are complied. Submits that legible, office objection is furnishing of the legible copies. Since the paper books are filed, the said objection does not survive. Paper, as the paper books are filed, the objection regarding legible copies is overruled. The other objections pending a finish shall be
Yes.
complied within next week. It is submitted that the synopsis filed by counsel for respond number 2 is served on the other copy.
Yes.
Therefore, that office objection overruled. 1 week time granted to file synopsis of respond number 1. Date. you want
Maybe
a date?
request on 18th.
18th,
if it's
Lordship.
Convenient to the court.
18th is Thursday. Hello, Thursday, criminal appeal antana.
May I request for
Can't you have it?
Your Lordship, 19th or the 17th?
Supreme Court direction. in
ಅಲ್ಲ
this matter.
2:30 18th fix
No, no,
ಮಾಡ್ಬಿಟ್ರೆ I'll go ahead with.
No, he said one next week ಅಂತ ಹೇಳಿದ್ರು.
Illa, Mr. Chinnappa also has some difficulty next week. He's traveling from 10th to 14th. So may I request for either 16th or 18th?
Lordship, the
Subject to
16th
your
we
order.
prefer.
Expeditiously ಮಾಡ್ಬೇಕು.
Indeed.
You paper book, you took this much of time to file a paper books and even there are some compliance. When is he available?
I'll leave it to the court.
Any date after 14th, Your Lordship. Either 16th or 18th, if Your Lordships may have it.
Then we'll have it on 15th.
15, yes. May I
Because
request at 2:30, madam?
Also can go through the records.
May I request at 2:30, so. Okay, specifically so that it can.
I'm grateful.
Yes,
See,
your
we have-
lordship.
see, whatever objection is
ಇಲ್ಲ
there,
ಮಾಡ್ತೀವಿ.
second set. ಅಲ್ಲಿ-
Now ಮಾಡಿದೀವಿ, but again we will ensure that it is compliant.
Ma'am, serial number.
I'm grateful.
Serial number.
Objections
Next week.
Yes, next.
Page 6, seal number 16 to 19. Page 7, seal number 20 to 22. Page 8, seal number 23 and 24. Page 9, seal number 25 and 26. Page 10, seal number 27 and 28. Page 11, seal number 29 to 35. Page 12, seal number 36 to 41. Seal number 41, my lordship. For appellant in this matter, my lordship. Press for weeks time, my lordship.
Serial number 41.
Yes, my lordship.
Both of you are seeking adjournment.
No, on last date, they seek time for filing objections regarding that application, one of.
Correct, you are also in 41, no?
Yes, my lordship, I'm for the
As
appellant.
requested by both, I'm sorry, adjourned at the request of both sides. Yes.
Much obliged. Page 13, seal number 42 to 46. Page 14, seal number 47 to 51.
48, madam.
Appearing for the appellant.
Yes, what is adjourned at the request, as adjourned, you are for? Adjourned at the request of counsel for respond number 1. Yes,
48, my lord, I pray for 2 weeks' time, I am for the appellant.
adjourned at the request of appellant's counsel. Yes.
Page 15, seal number 52 and 53. Broadus, seal number 1, Sangmeshi Patil, Government Advocate for R1, Prashant.
I am for the appellant, my lord. We served a copy to the respond to advocate, my lord, yesterday morning. Our clerk has served.
Against
So-
R2. What was the order dated 26/6/2020. Copies of the appeal memo and judgment are not served on copy shall be served after 5 days. Taking which appeal against respondent. Who is for respond number 2?
Prashant.
Prashant, my
Prashant.
lord.
Where is he? Acknowledgement there, file ಮಾಡಿದ್ದಕ್ಕೆ. You say he was served, but he is not here.
Yes, my lord.
You have to file here your acknowledgement.
Yesterday only we have served. We'll file it in the office.
But it's already dismissed. ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ. ಪ್ರಶಾಂತನ್ ಕರೆಸಿ ಅವ್ರು ಬೇರೆ ಅದಕ್ಕೆ ನೋಡೋಣ.
Please.
Passed over.
ನೀವು ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ we can
Seal
pass
number
on
2,
that.
KP Bhuvan, KG Sadashivaya.
Respondents in this matter, my lords.
Kindly pass over the matter.
Non-filing of memo of acknowledgement for having served the copies on the appellant. Non-filing of memo of calculation with regard to arrears. Appellant and respondent shall present before the court. Yes, oh, in the last time, when a settlement.
my
ಅಂತ
lords,
ಹೇಳಿದ್ರು. ಎಲ್ಲ ಆಗೋದಿಲ್ಲ, ಇವಾಗ party
No, my lords, my party was present, my lord, and the instructions from their side is that, my lord.
ಹೇಳಿದೀವಿ, party
Please,
shall be
please, ma'am.
present ಅಂತ, both shall be present ಅಂತ ಹೇಳಿದೀವಿ.
Pass.
Then why you want a passover? Why you want passover?
Senior has to be appearing.
Your party has not come.
No, my lord, he has not come to.
Settlement ಆಗೋದಿಲ್ಲ, ಇದು ಸುಮ್ನೆ adjournment is settlement. Senior passover ಮಾಡಂತ ಹೇಳ್ತಾರೆ. You should make a submission that you are instructed by your senior to seek a passover, already, passover ಮಾಡಕ್ಕೆ. Ask him to come.
Seal number 3, Subramanya Hegde.
Pray for a week's time may be granted. A week's time may be granted for complaints.
27 day first time ಬರ್ತಾರೆ, yeah. Furnishing PF etc. At request 10 days time is granted to the 2020. ಇನ್ನು
Bill number
notice
4.
ಬಂದಿದೆ.
Jagdish CM.
I appear for the appellant,
Good time.
my lordship.
Door lock ಅಂತ ಬಂದಿದೆ.
My lordship, there are two cases in this MFM, my lordship. First, I have filed an appeal.
There somebody
in
has
MFM.
appeared, SV Prakash, same party.
Yes,
ಅದಕ್ಕೆ
yes,
this-
my lord.
Where is
Yes,
Mr. Non-filing of statement of objection? IA 2018 for stay. SV Prakash ಬರ್ತಿರ್ತಾರೆ.
appear.
You can take notice in the connected matter also. In one case you have appeared, your party has appeared. First, second case, but in the first case though, ಅದೇ ಡೋರ್ ಲಾಕ್ ಅಂತ ಬರುತ್ತೆ, ಸರ್ವ್ ಆಗೋದಿಲ್ಲ.
Directed to some.
You take instruction from her. We direct you to accept notice now. We direct you to accept notice. ಕೊಡಿ ಇನ್ನೊಂದು ಕೊಡಿ.
ಸೇಮ್ ಪಾರ್ಟಿ ನೀವೇ ಫೈಲ್ ಮಾಡಿದ್ದು, ಇದ್ರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ಇದ್ದೀರಾ, ಒಕ್ಕಲತಕ್ಕಿ
ತಗೋತಾರೆ ಡಾಕ್ಟರ್ಸ್. ಹಾ, ಕಲ್ಲಹಳ್ಳಿ, ಶಿವಮೊಗ್ಗ, ಮೈಸೂರು. In the connected matter, the respondent in this case is a respondent in MF number 9272 of 2018 also. In that matter, she has appeared through her counsel SV Prakash. Therefore, Shri SV Prakash Learned Counsel is directed to appear, requested to take notice in this matter also for the respondent. He is permitted to file the wakalat in the registry within 10 days. Registry shall show his name in the causes for the response accordingly. Okay. There is 420 days delay. ಅದರ ವಕಾಲತ್ ಹಾಕಿ, ಯಾಕೆ ನಿಮ್ ಕ್ಲೈಂಟ್ ಬರೋದಿಲ್ವಾ?
ಅದು ಬರ್ತಾ ಇಲ್ಲ ಮೇಡಮ್.
ಕನೆಕ್ಟೆಡ್ ಕೇಸಲ್ಲಿ ಅಲ್ಲಿ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದು ಫಸ್ಟ್ ಮುಗೀತು. ಸೆಕೆಂಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನ್ ಹೇಳ್ತೀರಾ? ಸ್ಟೇ. You have any objection or not?
Objection ಆಗ್ತೀವಿ, ತಗೊಳ್ತೀವಿ.
2018 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. You contact them, otherwise we'll grant a stay, proceed with the matter. 2018 ಅದ.
ಅಡ್ವೊಕೇಟ್ ರೆಫರ್ ಮಾಡಿರ್ತಾರೆ, ಕ್ಲೈಂಟ್ಸ್ ಸ್ವಲ್ಪ ಫೋನಿಗೆಲ್ಲ ಸಿಗ್ತಾ ಇರಲ್ಲ. ಅಡ್ವೊಕೇಟ್ ರೆಫರ್ ಮಾಡಿರೋ ಕೇಸಸ್ ಇರುತ್ತಲ್ಲ, ಕ್ಲೈಂಟ್ಸ್
ಅವ್ರ ನಂಬರೇ ಕೊಡೋದಿಲ್ವಾ ಅವ್ರು ನಿಮ್ಗೆ?
ಬರೋದೇ ಇಲ್ಲ.
ಅಲ್ಲ,
ಕೆಲವೆಲ್ಲ RSA ನಲ್ಲಿ ಹಂಗೆ ಆಗಿದೆ.
ನೋಟಿಸ್ ಕೊಡಿ, ನೋಟಿಸ್ ಅಲ್ಲ ಮಜಾ ಅಲ್ಲದೆ ಯಾರು ಫರ್ದರ್ ರೆಸ್ಪಾಂಡ್.
ಲೆಟರ್ ಎಲ್ಲ ಬರೋದ್ರೂ ಕೂಡ ಎಲ್ಲ ವಾಪಸ್ ಬರ್ತಾ ಇದೆ.
ಇಲ್ಲ ಎರಡರಲ್ಲೂ ರೆಸ್ಪಾಂಡ್.
10 days ಟೈಮ್ ತಗೋತೀವಿ.
At request finally 10 days time is granted to file. ಅಲ್ಲ ಅದು ಇನ್ನೊಂದು ಸ್ಟೇಜ್ ಇದರಲ್ಲಿ ವಕಾಲತ್ ಅಪ್ಲೈ ಇರುತ್ತೆ. To file counter to I2 of 2018. List on 10 ದಿವಸ ಆದ್ಮೇಲೆ ಡೇಟ್ 15. Still number 5.
Lordship, I
Bharati
appear to the
Patil.
respondent. It's been more than 4 years that these appeals came to be filed, Your Lordship. Previously, there were orders passed by this court that if the office objections are not complied, to be dismissed without notice to this bench also, Your Lordship. But still, the office objections has not been complied, and it's only an attempt to harass the respondents, Your Lordship.
2020 both.
It's been more than 4.5 years. It was filed in March 2020, Your Lordship. They have not complied with the office objection, and where the amount is involved monetarily.
Just we'll see. What are the office objections? In view of filing of wakalat, necessary corrections to be carried out in the entire appeal.
The petitioner has
And
been changing the advocate's time and again, Your Lord.
The appeal memo and IAS since wakalat file. Again, not necessary. See, office objection is that after filing the appeal, another advocate has appeared. He should sign.
Even last year in February, there was an order made, Your Lordship.
Of wakalat, necessary corrections to be carried out. Entire appeal memo. IA counsels to sign. ಯಾರೋ ಒಬ್ರು ಹಾಕಿದ್ರೆ ಇನ್ನೊಂದು ಬಂದು ಇನ್ನೊಬ್ರು ಹಾಕಬೇಕು.
Even last year, 8th of February, there was an order made, Your Lordship, that the appeals will be dismissed without further reference.
Madam, office objection is appeal was filed by one A. Rajesh.
Yes, Your Lord.
Now who has come on record? Bharati Patil.
Originally, the petitioner itself had filed as a party in person, Your Lordship. And where the monetary amount is involved.
The office objection, have you seen the office objection?
Yes, Your Lordship, I understand.
The advocate has filed, he
yes.
has to sign the appeal memo.
Yes, Your Lordship, but it's actually only an attempt to harass the petitioner, respondent in these matters.
This is harassment idu. If the advocate is another advocate appears, why should he sign the wakalat?
I understand.
Appeal memo.
I'm not talking about the office objection, Your Lordship. I'm talking about the conduct of the petitioner in these matters. She has appeared in the other matters which were there before this court where the monetary amount was involved, Your
The
Lordship.
appeal was filed by party in person.
Originally, it was filed by party in person, Your Lordship. And actually, the divorce was granted on the basis of cruelty. And where the monetary amount was involved, they have appeared and they have filed it in November 2023, and they got the matter disposed in the very next year also, Your Lordship. It is already disposed. She has received huge amounts of money just last month, Your Lordship.
Much.
And
How much
only-
was awarded? Permanent alimony ಕೊಟ್ಟಿದ್ದಾ? No.
no, Your Lordship, the arrears of maintenance, she has filed multiple cases against the respondent, and even this is only an attempt to harass the respondent, Your
Office
Lordship.
objection is that you have appeared subsequently, you have to
And
attach the
comply.
appeal memo. That is one.
Okay.
ಅದನ್ನ ನೀನ್ ಕಂಪ್ಲೈ ಮಾಡು. She has filed party in person. ಅವ್ರಿಗೆ
That is the case then.
Your Lordship, the appeals may
he
be.
has to conduct the case, that's all. ಇನ್ನೊಂದೇನೋ office non-filing, another one is
I was subsequently appointed by the HCLS.
ಇವ್ರ ಬಿಟ್ಟು ಇನ್ನೊಬ್ರು ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರೆ ಮತ್ತೆ ಅವಾಗ ಅವ್ರು ಮಾಡ್ಬೇಕಾ?
Your Lordship, I request the court to dismiss these matters, Your Lordship.
He has filed wakalat. He will stand by what is stated in the appeal memo.
The objections may be overruled to that effect.
The office objections are that as a new advocate has appeared with office objections. What is your name?
Ashwin.
No, who has Ashwin Jaistan? Earlier, this Bharti Patil and A. Rajeshwar,
Yes, sir. I was. I'm appointed through.
he
the-
shall sign the appeal memo, HCLC.
Yes.
He shall file the appeal memo and he shall sign the appeal memo and the IAS. Yes. He only the subsequent advocate has only argued based on the records, based on the appeal memo filed and IAS file. He need not file, he need not sign the appeal memo filed by another advocate or the party in person. ಅಲ್ಲ another advocate ಬೇರೆ advocate ಬಂದ್ ಹೋಗಿದ್ದಾರೆ already record.
2-3 times the advocates have
Office
been
objections
changed, Your Lordship.
are wholly unsustainable, hence overruled. Okay. Now, ಇದು final. Since ಯಾರು ಅಶ್ವಿನ್ ಜಾಯ್ಸ್ಟನ್
Ashwin Kutina.
Kutina
Okay.
has appeared, registry shall show only his name for the appellant henceforth. Okay, ಇದರಲ್ಲಿ ಏನಿದೆ office objection, counsel to sign the entire appeal memo, form A and form B to be not pressed since wakalat filed, in view of filing of wakalat, necessary corrections to be carried out. ಏನಾದ್ರು corrections, ಏನಾದ್ರು correction, just to check if there are any correction. ಅದು first matter. Second matter ಅಲ್ಲಿ office objection for the reason stated above, office objection number 1 and necessary corrections ಅದು ಏನಂತ ಹೇಳ್ಬೇಕಲ್ಲ ಅವ್ರು necessary 1 and 3 overruled ಅಷ್ಟೇ ಅದರಲ್ಲಿ. ಅದು form number A and B does not survive now because party in person.
Yes.
Form number A and B do not survive for consideration as the party is represented through advocate Ashwin Jaistan Kutina. Therefore, the same is disposed of accordingly. Idral registry shall show only the name of Ashwin Jaistan Kutina for the appellant henceforth in the cause list. Idralenu you are ready for admit ಆಗಿದಾವ?
ಇಲ್ಲ ಮೇಡಮ್.
No, Your Lordship.
Any delay is there?
Yeah, it's admitted, Your Honor, already. TCR call out ಮಾಡಿ.
ಡಿಲೇ ಏನಿಲ್ವಲ್ಲ, ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಯಾವ್ದು ಇದ್ದಂಗಿಲ್ಲ ಅಂದ್ರೆ.
No
TCS received ಅಂತ ಇದೆ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ
Yes,
ಬರ್ತಿದೆ.
admitted.
ಯಾವಾಗ ಅಡ್ಮಿಟ್ ಆಗಿದೆ?
Your Lordship, it was pending for office objection compliance from the time it was filed, Your Lordship. It has not come up for
But
hearing.
called for.
It was, it had not come up for hearing as such.
Since it's a common judgment, Your Lordship, TCR is placed only on 3470.
ಇರಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. No IA is pending, no?
No IS.
For delay condonation, etc.
Filed within time, Your Lordship.
In time. Delay ಇದೆ. ಇವ್ರು ಎಷ್ಟು ದಿವಸ ಟೈಮ್ ತಗೊಂಡಿದಾರಲ್ರಿ ದಿಸ್ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್?
It's been 4.5 years, Your Lordship, that the petition appeals came to be filed March 2020.
ಸರಿ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ತಾನೆ ರೆಕಾರ್ಡ್ಸ್? ಅದು ಬಹುಶಃ ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಆಗಿರ್ಬೇಕು. ಯಾಕೆಂದ್ರೆ ಇದು ಕೋವಿಡ್ ಪೀರಿಯಡ್ ನೋಡಿ ಅದು ಬೇಕಾಗಿರ್ಲಿಲ್ಲ 15/3/2021 ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಅಂತ ಕಾನ್ಸೆಪ್ಟ್ ಅಲ್ಲ A1/2021 ಅಡ್ಮಿಟ್ 3472 ಅಲ್ಲ 3472 ಆರ್ಡರ್ ಶೀಟ್ ಯಾವುದು ಇಲ್ಲ ಹಿಂದೆ ಯಾವಾಗಾದ್ರೂ ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ ಆಗಿದೆ ಫಾರ್ಮ್ ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಆಯ್ತು Form A and B with IA for condonation of delay to be removed since wakalat filed. There is one application that they have not shown. Delay condonation application ide ondu in this 3472 of first one will condone the delay in ishtu varsha ishtu
Your Lordship, it's been
probably those IAS ಅಲ್ಲ ಅವಾಗ ಇದು ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಇತ್ತು ಅವಾಗ ಎಕ್ಸಂಪ್ಷನ್ ಇತ್ತು ಎಲ್ಲಾದ್ರೂ ಮೊದಲು ಇದನ್ನ ಹಾಕಿದಾರ ನೋಡಿ ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ ಏನಾರ ಮಾಡಿದಾರ ಅಂತ
Your Lordship, the petitioner's conduct may be observed only in the cases where amount is to be received, she is very agile and she has proceeded the matter, she has finished the matter within the span of 6 months.
Visitation
In these matters where she doesn't have any monetary benefit, she has taken more than 4 years time, Your Lordship. It's a matter of convenience for the petitioner to engage the counsel, change the counsel as per the whims and fancies, Your Lordship.
IA1 wakalat necessary correction to be carried out. ಈ party in person, if they come, this is all the problem. ಏನಮ್ಮ ನಿಮ್ಮಿಂದ ಕೋರ್ಟಿಗೆ ಎಷ್ಟು ಅನಾನುಕೂಲ ಆಗ್ತಾ ಇದೆ ನೋಡಿ ಯಾಕೆ ಅಷ್ಟೊಂದ್ ಜನ ಅಡ್ವೊಕೇಟ್ಸ್ ಚೇಂಜ್ ಮಾಡ್ತಾ ಹೋಗ್ತೀರಿ
It's not properly guided, Your Lordship. Now, once it's on,
She appears
before-
even before the lower court party in person.
Yes,
let me submit my.
Yes.
Your Lordship, once she came before the High Court Legal Service Committee, thereafter, there are like 4 petitions before the Honorable Court. 2 over here, Your Lordship, one was RPFC, which is already disposed, and there's one criminal petition which is pending, Your Lordship. That's why, as far as all these 4 assignments are consigned to me, one is already disposed of. This is the second assignment assigned to me, Your Lordship. I'll look into all these office objections and comply wherever necessary changes are required to be made.
how many 7 days and ಬಡಸನ number 2 this was covid period ಅವಾಗಿಂದ
But a lot of time has been given, Your Lordship. More than 4 years it's taken. Even after COVID, 2 years it has been, Your Lordship.
no application when this appeal was filed it was a covid period.
Yes, I'm not talking about the objections, Your Lordship, not about the delay,
severe financial problem.
the general conduct of the petitioner.
But ಎರಡರಲ್ಲ orders are number 1 of 2021 ಅದು they have not filed it along with the appeal, subsequently they have filed it.
That is why the same papers are missing on my file as well.
There is 7 days delay in filing these two appeals. Considering the reasons assigned, they have 7 days in filing the appeals is condoned in the interest of justice. Usually, IA1 of 2021 is disposed of accordingly. Usually, TCRs received and they that admit post for final hearing.
Also, if a date is fixed, I'm ready for the hearing. If a date is fixed,
22 sir.
much obliged.
Obliged.
27. Hearing on IS number 6, Kumar Balakrishna, SPP.
Challenging the judgment and order passed by the Honorable Trial Court for the offences punishment under section 302, 324, read with 34 IPC, my lord.
Please.
There is lot of delay, my lordship.
ಅಲ್ಲ ಅದೇನದು ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ನೊಳಗಿಂದ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಸಾರಿ ಜಸ್ಟ್ ಬ್ರದರ್ ವಾಸ್ ಪಾಯಿಂಟಿಂಗ್ ಔಟ್ ಸಮಥಿಂಗ್ ಯಾರು ಟೈಪ್ ಮಾಡಿದ್ದಾರೆ ಕರೆಕ್ಟ್ ಕರೆಸಿ ಅವರದ್ದು ದಿಸ್ ಇಸ್ ಏನು ಸೇಮ್ SC number and which is in another case is pending.
Yes, accused number 1 already been acquitted by the sound court.
Yes, sir.
And the appellant is accused number 2, my lord.
Yeah, produce the copy.
Yes, already produced, page number 51,
52.
52.
He is in judicial custody. Now your party.
Now, my party is in judicial custody.
Only
They already served 14 years and 3 months imprisonment.
Correct. ಅವ್ರಿಗೆ acquittal ಆಗಿರೋದನ್ನ ನೋಡ್ಕೊಂಡು ಅದು but that was in 2015.
Yes, my lord.
What was the role assigned to?
And he is entitled for remission under section 433 of the CRPC.
ಈಗ ನೀವು ಅದು ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೇನೋ ಕೊಡೋದಿಲ್ಲ ಅಂತಲ್ಲ ರೆಮಿಷನ್. ಎಷ್ಟೊಂದ್ ಜನ they were not pressing. Their policy is if they are on bail they will not.
Under the code, under section 433 of the CRPC. Because he has served 14 years of imprisonment. So he is entitled for remission. And in the latest judgment of the Apex Court says, one accused cannot be convicted, another accused cannot be acquitted if the evidence is the same. And the Honorable Apex Court acquitted the persons who did not file the appeal. That's a reported judgment. Totally, sir. Doctrine of,
Without filing the
doctrine
appeal
of-
we can't.
yes, sir, doctrine of parity is applicable in the facts and circumstances of the present case, my lords.
No, was it under article 142? That was under article 142.
Yes, my lord.
Then whether that is available to us.
Yeah, now para 15 and 19, it's a reported judgment. Relevant para 15 and 19.
Justice and peace. Just a minute. At least against PW1 there was evidence. No? Accused number 1 was not justified in convicting accused number 1 anta ಹೇಳಿದ್ದಾರೆ.
PW 8 and 9, the trial court relied upon the evidence of PW 8 and 9, my lords. They partly turned hostile. And this court observed that the evidence of PW 8 and 9 are contradictory each other and acquitted the accused number 1. That is the specific observation made by this court in the
In this
judgment.
sorry, in this statement, which paragraphs you are referring? 19, para 19. Huh?
Yes, para 19 and 20. Para 15 and 19, my lord.
Same or similar role anta ಹೇಳ್ತಾರೆ.
Similar. Here also, the evidence is same. The doctrine of parity is squarely applicable to the facts and circumstances of the present case, my lords.
We'll consider your application for
Yes.
3006.
Delay
Yes,
may
ma'am.
Only countdown.
Condonement, please.
What is this?
ಅದನ್ನ madam. We said I didn't notice the delay. ನಾವು ಅದನ್ನೇ consider ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
So when the substantial justice and the technical considerations
Fine.
are pitted against each other,
Why your client did not approach the.
yes, substantial justice would prevail.
Why is not filed appeal?
Yes, sir, ಮಾಡಿದೀವಿ ಅಂತ ಗೊತ್ತಿರುತ್ತೆ.
So after the judgment and order,
This
was
is
completely abandoned by his family, number one, and due to acute poverty, he could not approach this court.
And what is his occupation? Why the family abandons him? ಅಲ್ಲಿ ಏನು useful ಇರ್ಲಿಕ್ಕಿಲ್ಲ. Accused number 2 na?
Accused
Accused
number
number 2, my lord.
Aged 25 years in
Yes.
2010. ಈಗ ಇನ್ನೊಂದು 14 years. No, he was an elderly person, 41. ಅವ್ರಿಗೆ ಯಾರೋ ಇರ್ತಾರೆ. Heard, Madison in 1/2024 and 2024. Under the above applications, the appellant is seeking condonation of delay of 3,677 days and suspension of impugned order of sentence and grant of bail. By the impugned judgment and order, the appellant who was accused number 2 and accused number 1 were convicted for the offense punishable under section 324 ಇದೆ ಅಂತ ಕಾಣಿಸ್ತಾ.
302, 324. 30.
Not to read which accused number 2 further convicted for 324. What is that 324 of PW8 ga? Not to read with section 35.
Assault.
Stone ಅಲ್ಲಿ
Assault.
assault ಮಾಡಿದ್ದಾನೆ.
ಆ PW8 ಗೆ
8
present appellant was assaulted for the offense under section 324 IPC also. He was in judicial in accused number 2 further convicted. ಅವ್ರನ್ನಿಬ್ಬರನ್ನ ಮೊದಲು not to 34 ಮಾಡಿದ್ರು, ಇವ್ನಿಗೆ ಇನ್ನೊಂದು ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಇತ್ತು. Since custody, ಅವಾಗ್ಲೂ ಕಸ್ಟಡಿಯಲ್ಲೇ ಇದ್ರ ಟ್ರಯಲ್ ಅನ್ನು
Since 13/3/2010, my lords. 13/3/2010.
So right from the date of arrest, he is.
Yes, my lord, yes.
Accused number 1 preferred criminal appeal number 640 before this court challenging the very same judgment and order. This court by judgment dated 16/4/2015 allowed the appeal of accused number 1 and acquitted him. The appellant was in judicial custody all along. Considering the aforesaid facts and circumstances, the delay of 3,677 days in filing the appeal is condoned. The impugned order of sentence passed against the appellant accused number 2 is hereby suspended and is granted bail in the above case. ಈಗ ಇದರಲ್ಲಿ ಫೈನು ಕಟ್ಟೋಕ್ ಹೇಳೋದು ಬೇಡ ಹಾಗಿದ್ರೆ, because
He has already served
that order has certain finality.
penalty.
Subject to the appellant depositing executing personal bond in a sum of 50,000 and furnishing 2 sureties in the like sum to the satisfaction of the trial court for his appearance before the court whenever required. IA 1 and 2 of 2024 are disposed of accordingly.
LCR may be, TCR may.
Admit to call for TCRs. Communicate a copy of this order to the trial court and the concerned person.
And it may be heard for once for all. The admission.
ಬರ್ಬೇಕಲ್ಲ, ಯಾವ ಕೋರ್ಟ್ ಅದು? ಪೇಪರ್ ಬುಕ್
Bangalore.
ಬೇಡವಾ? ಬೇಕಾಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ ಪೇಪರ್ ಬುಕ್. ಅದೇ 676 of 2010.
Paper book not required, my lordship, only TCR is sufficient. Paper book is not required, TCR is sufficient, my
ಅಲ್ಲ,
lordship.
ಬಹುಶಃ ನಮ್ಗೆ ಯಾವ್ದೋ ಹಿಂದಿನ ಕೇಸಲ್ಲಿ ಮಾಡಿದ್ರು ಇರ್ಬೋದು. ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇಬ್ಬರದು ಸೇಮ್ ಓವರ್ ಟ್ಯಾಕ್ಸ್ ಇದೆ ಅಂತ ನೋಡ್ಬೇಕು ಅಷ್ಟೇ. 2 weeks.
Date may be.
19/7.
ಇಬ್ಬರದು ಓವರ್ ಟ್ಯಾಕ್ಸ್ ಒಂದೇ ಇದೆ ಅಂತ ಅನ್ಸುತ್ತೆ.
Much of.
ಓಲ್ಡ್ ಟ್ಯಾಕ್ಸ್ ಒಂದು ಚಾರ್ಟ್ ತರ ಮಾಡ್ಕೊಡ್ತೀವಿ. ಓಲ್ಡ್ ಟ್ಯಾಕ್ಸ್
Because he was
ಎವಿಡೆನ್ಸ್
sentenced, convicted for another additional offense.
Yes,
and binding on that by the court.
Adil
and bench of
yes,
the
yes, my lord.
Shall be
Yes.
prepared within 2 weeks.
court ನೋಡೋದು.
Seal number 7,
Much of.
Tegdayan, R. Shashidhara.
For appellant.
Lord, as for information, my lord, before trial court, my lord, both husband and wife have
They are going to compromise. Husband and wife, my lord.
ಕರ್ಸಿ ಅವ್ರನ್ನ ಇಲ್ಲ ನೋಡೋಣ. ಈಗ ಇನ್ನೊಂದ್ ಯಾವ್ದೋ ಕೇಸಲ್ಲಿ ಹೇಳಿದ್ವಿ ನೋಡಿ, ಇವಾಗ ಬರಕ್ ರೆಡಿ ಇಲ್ಲ ಪಾರ್ಟಿ. 2017 ಅಲ್ಲಿ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗ್ತಿದೆ ಅಂತೆ. ಐ ವಿಲ್ ಗೆಟ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ my lord.
32 days delay. Will condone it and call for the records. ರಾಜಿನೇ ಆಗ್ತಿದ್ರೆ ಅದಕ್ಕೇನಂತೆ ಈಗ? This is ಡಿಗ್ರಿ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡೋದಾ? ಕಾಂಪ್ರಮೈಸ್ ಅಂದ್ರೆ ಏನದು? What is the compromise?
My lord,
Ex parte decree ಇದು.
ex parte degree in 125. The husband is already married, my lord. There is 1000 something days delay in filing the appeal. Husband is
ಎಕ್ಸ್ಪರ್ಟೇ ಡಿಗ್ರಿ ಆಫ್
ಆಗಿದೆಯಲ್ಲ ಮತ್ತೆ ತೋರಿಸ್ತಾ ಇದಾರೆ. ಅವಾಗ ತೋರಿಸಿರ್ಲಿಲ್ಲ. ಇದು ಲಾಸ್ಟ್ ಟೈಮ್
delay condone ಆಗಿದೆ 7/6.
ಸಾರಿ
7/6/2024 my lord, delay is condoned. 7/6/24.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ 7/6/2024
ಹೌದು.
7/6 ಗೆ ಇಲ್ಲ ಅದು ಏನು
7/6
ಇಲ್ವಾ? ಸ್ಟೇಯಿಂಗ್ ಸೆಕ್ಯೂರ್ ಇಲ್ಲ. ಡಿಕ್ರೀನ್ ನಾವು ಅದು IML ಆರ್ಡರ್ ಸ್ಕಿಪ್ ಆಗಿದೆ. ಅದನ್ನು ಮುಗಿಸ್ಬೇಕು. ಡಿಸ್ಕೋರ್ಟ್ ಅದು ಬಹುಶಃ ಒಮಿಷನ್ ಅದು ಆರ್ಡರ್ ಅಲ್ಲಿ ನಾವು ಆರ್ಡರ್ ಮಾಡಿರ್ತೀವಿ, ಕರೆಕ್ಷನ್ ಮಾಡೋವಾಗ ಗೊತ್ತಾಗಿಲ್ಲ ಅದು ಇಲ್ಲ ಅಂತ
My lordship condone the delay in last date.
ಮಾಡಿದ್ವಾ ಡಿಕ್ಟೇಷನ್ ಕೊಡೋವಾಗ ಇಲ್ಲಿ ಬಂದಿಲ್ಲ, ನಾವು ಅಲ್ಲಿ ಫೈನಲಿ ಆರ್ಡರ್ ಸೈನ್ ಮಾಡುವಾಗ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ. Both counsels admit that while passing the order on 7/6/2024, delay was admitting the appeal, delay was also condoned. However, it appears the same is not found in the order. It appears that is an omission, accidental omission.
Is it serial number 9, Miller?
Serial number 7.
7/7.
Taking into consideration the order dated 7/6 for the 2024 and the reasons assigned, delay of 1149 days in filing the appeal is condoned. In the interest of justice, I 1/2020 is disposed of accordingly. ಮಾಡಿರ್ತೀವಿ ನಾವು ಮಾಡಿದ್ದು ತಾನೆ, ಮತ್ತೆ ಟೈಪ್ ಮಾಡ್ಕೊಂಡು ಬರುವಾಗ ಮಾಡಿಲ್ಲ. ಯಾರು BSR ಅಂದ್ರೆ ಯಾರು? ನೀವೇನ? ಅದನ್ನ ನಾವು ಹಾಗೆ ಮಾಡೋದಿಲ್ಲ ಜನರಲಿ. ನೋಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿ. Both counsels submit that the parties are trying for a settlement.
Settlement ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Counter party is informed that there is.
ಒಂದಿಲ್ಲ 3 ಲೈನ್ ಬರ್ದಿದ್ದಾರೆ ಜಜ್ಮೆಂಟ್.
ಅವ್ರಿಗೊಂದು ಡಿಸ್ಪೋಸಲ್ ಒಟ್ಟು
ರಿಸಾಲ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ 3 ಲೈನ್.
Ex parte
Even if it is ex parte, they have to give the reason.
ಹೌದು.
ಇದು more particularly in this kind ಏನು ಕಮರ್ಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಲ್ಲ ಏನಲ್ಲ. ವೆಡ್ಡಿಂಗ್ ಕಾರ್ಡ್ ಲೀಗಲ್ ನೋಟಿಸ್ ಬಿಟ್ರೆ ಏನಿಲ್ಲ
ಅಷ್ಟೇ ಎಕ್ಸಿಬಿಟ್ಸ್ ಆಗಿರೋದು ಅಷ್ಟೇ.
ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದೆ, ಅವರು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಡಿಕ್ರಿ ಮಾಡ್ಬಿಟ್ಟು.
ಏನದು ಅಲಿಗೇಷನ್ಸ್ ಆಫ್ ಕ್ರುಯಲ್ಟಿ ಏನು? ಕ್ರುಯಲ್ಟಿ ಅಲಿಜ್
ಕ್ರೂಯಲ್ಟಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಮತ್ತೆ ಇವನ್ ಮೈ ಲಾರ್ಡ್ ನೋಟಿಸ್ ವಾಸ್ ಸೆಂಟ್ ಟು ದಿ ಪೇರೆಂಟ್ಸ್ ಆಫ್ ವೈಫ್ಸ್ ಅಡ್ರೆಸ್ ಮೈ ಲಾರ್ಡ್. ಶಿ ವಾಸ್ ನಾಟ್ ಸರ್ವ್ಡ್.
ಮತ್ತೆ ಅವ್ರು
ಪಂಚಾಯತ್ ವಾಸ್ ಆಲ್ಸೋ ಕನ್ವೀನ್ಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಪಂಚಾಯತ್ ಕನ್ವೀನ್ ಮಾಡಿಲ್ಲ. ಇಟ್ ಇಸ್ ನಾಟ್. She tried to hang herself and put kerosene and ablaze herself. She has determined to give up
ಒಂದೇ ಪ್ಯಾರ ರೀಸನ್
physical relationship. ಇರ್ಲಿ ಇಬ್ಬರನ್ನ ಪ್ರೆಸೆಂಟ್ ಇಡಿ ಕೋರ್ಟ್ ಮುಂದೆ. ಯಾಕಂದ್ರೆ
ಪ್ಲೀಸ್
both counsels submit that
next week.
settle the matter.
next Tuesday.
Party shall be kept present before
Next
court on
Tuesday. Next week.
9/7 list on 9/7. ಅಲ್ಲ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಆದ್ರೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಇದ್ರೆ ಹಾಗೆ ಅದನ್ನ ಟ್ರೈ ಟು pull on the matter.
Still number 8, B.S. Umesh, Gauslism.
API for the appellant.
Respondent, sir, while Wakalat.
If Manad remembers, this is a case
I
where
have not received any delay application.
She was served, no?
now he
I
is
have summons received by WhatsApp, son.
WhatsApp ಅಲ್ಲಿ.
Yes, sir. And last 28/6 ಅಲ್ಲಿ
Manad the ordered it through Manad the magistrate.
Criminal miscellaneous 216 before a Metropolitan Magistrate Court.
Yes, ma'am.
It is issue notice to respond to ಇಲ್ಲ ಮೆಟ್ರೋಪಾಲಿಟನ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಥ್ರೂ ಸರ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದೀನಿ.
ಹೌದು
ಇಲ್ಲಿ
madam.
ನೋ ಸಚ್ ಅಡ್ರೆಸ್ ನಾಟ್ ನೋ ಸಚ್ ಪರ್ಸನ್ ಇನ್ ಅಡ್ರೆಸ್ ಅಂತ ಬರುತ್ತೆ.
Yes.
ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅನ್ನ
Yes, ಹೌದು.
ಕೆಲಸ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಸ್ ದೇರ್ ಯುವರ್ ಪಾರ್ಟೀಸ್?
Yes, ಸ್ವಾಮಿ. ಇವತ್ತು ಸೇಮ್ ಡೇನೆ ಅಲ್ಲಿದೆ ಸ್ವಾಮಿ, ರಿಕವರಿ ಆಫ್ ಮೇಂಟೆನೆನ್ಸ್ ಅಮೌಂಟ್ ಇದೆ.
ಕರೆಕ್ಟ್, ದೇ ಆರ್ ನಾಟ್ ಇನ್ ದಟ್ ಅಡ್ರೆಸ್ ಅಂತ ಬರುತ್ತಲ್ಲ.
ಓಕೆ ಸ್ವಾಮಿ.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಮೆಲಾಡ್ ತಮ್ಗೆ ಗೊತ್ತು, ನಾನು ಸರ್ವ್ ಆಗಿದೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಇಂದ ಕಾಪಿ ಕೊಟ್ಟು ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ, ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟು ಎಲ್ಲ
ಅದು ಇನ್ನೂ
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಬಂದಿಲ್ಲ. ಅದು
ಸ್ವಾಮಿ, ಇವತ್ತೇ ಇದೆ ಆ ಕೇಸ್.
ಇನ್ನೊಮ್ಮೆ ಕೊಡ್ತೀನಿ, ನೋ ಪ್ರಾಬ್ಲಮ್.
ರಿಟರ್ನ್ ಟು ಅಸ್.
ಮೆಲಾಡ್ ಐ ಹ್ಯಾವ್ ನೋ ಹೆಸಿಟೇಷನ್, ಐ ಸರ್ವ್ ಕಾಪಿ,
ಅಲ್ಲ
ನೋ ಪ್ರಾಬ್ಲಮ್.
ಇದ್ರಲ್ಲಿ ಕಾಪಿ ಆಯ್ತು. ನಾವು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ನಿಂದ ಕಳಿಸಿದ್ದು ಇನ್ನೂ ರಿಟರ್ನ್ ಬಂದಿಲ್ಲ ನಮ್ಗೆ.
ಸ್ವಾಮಿ, ಇವತ್ತೇ ಇದೆ ಸರ್ ಆ ಕೇಸ್, ಇವತ್ತೇ ಇದೆ ಸ್ವಾಮಿ MMTC 1 ಅಲ್ಲಿ. ಹೌದು ಸ್ವಾಮಿ, ನಾನು ಇಲ್ಲಿ ಬಂದಿದ್ದೀನಿ, ಅಲ್ಲಿ ಹೋಗಕ್ ಆಗಿಲ್ಲ.
ಮೆಟ್ರೋಪಾಲಿಟನ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಥ್ರೂ ಅಂತ ನಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ದು ಹೋಗೇ ಇಲ್ವಂತ.
ಇಲ್ಲ ಹೋಗಿದೆ ನಾನು ಐ ವೆರಿಫೈಡ್ ಇಟ್ ಹಸ್ ಬೀನ್
ರಿಟರ್ನ್. ಇಫ್ ಎಟ್ ಆಲ್ ಇಟ್ ಇಸ್ ಸೆಂಟ್
No
ಸರ್ಡ್ ಆರ್
problem.
ನಾಟ್ ಸರ್ಡ್ ಗೊತ್ತಾಗೋದಿಲ್ಲ.
ನೋ ಪ್ರಾಬ್ಲಮ್.
ಕಾಪಿ ಕೊಡಿ ಹೋಗ್ಲಿ.
ಕೊಡ್ತೀನಿ ಸರ್, ಕೊಡ್ತೀನಿ. ಇಫ್ ಯು ಸೀರಿಯಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಫಾರ್ ಡಿಲೇ ಐ ವಿಲ್
ಅಲ್ಲಿ
ಸರ್ವ್.
ಹೋಗಿದೆ, ನೀವು ರಿಸೀವ್ ಮಾಡಿರ್ತಾರೆ.
ಇವತ್ತೇ ಕೇಸ್ ಇದೆ, ರಿಕವರಿ ಪಿಟಿಷನ್ ಕೇಸ್ ಇವತ್ತೇ ಇದೆ ಸ್ವಾಮಿ MMTC ನಲ್ಲಿ. ಮುಗಿಸ್ಕೊಂಡು ನಾನು ಹೋಗೋಣ ಅನ್ಕೊಂಡೆ.
ಹೋಗೋದಾಯ್ತ್ರಿ. ಕಾಪಿ ಸಿ ನೋಟಿಸ್ ವಾಸ್ ಆರ್ಡರ್ ಥ್ರೂ ಫಾರ್ ಸರ್ವಿಸ್ ಥ್ರೂ ಮೆಟ್ರೋಪಾಲಿಟನ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್. ಹೌ ಡಿಡ್ ಯು ಕಮ್ ಟು ನೋ?
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ನಿಮಗೆ
ಹೋಗಿರುತ್ತೆ ಅವ್ರಿಗೆ.
ಯಾರು ಕಳ್ಸಿದಾರೆ ಹೇಳಿ ಸ್ವಾಮಿ, ಅವರು ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಯಾರಿಂದ ಬಂದಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
Respond submits that he has not received the copies. Appellant's counsel ಒಂದ್ಸರಿ ಒಂದ್ ಕಾಪಿ ಕೊಡಿ ಹೋಗ್ಲಿ.
ಆಗ್ಬೋದು.
Respondent response counsel. Okay. 32 days delay ಇದೆ, ಕಂಡೋನ್ ಮಾಡೋಣ. ಏನ್ ಹೇಳಿದ್ದಾರೆ ಡಿಲೇಗ್ ರೀಸನ್?
ಏನು ಹಾಕಿದ್ರೆ ನಾನು ನೋಡ್ತೀನಿ ಸರ್.
ಈಗ
ಲಾಸ್ಟ್ ಮೈ ಸೀನಿಯರ್
2021 ಪೆಂಡಿಂಗ್ ಇದೆ. ಲೆಟ್ ಅಸ್ ಸಿ ಏನು ವಾಟ್ ಇಸ್ ದ ಆರ್ಡರ್ ಫಾಸ್ಟ್. His petition is dismissed.
Yes sir.
For divorce, yes, my lord. Restoration of conjugal rights was
At
filed.
the most, you can file an application for interim element. I am in Ajmer. He is
Rajasthan.
working in a private school as teacher.
My lord, the papers were in Rajasthani, my lord, they were to be.
Utilizing the funds, etc. Financial difficulty ಅಂತ ಹೇಳಿದ್ದಾರೆ. Will come down the delay. Eight. See, heard. Considering the reasons assigned, delay of 32 days in filing the appeal is condoned in the interest of justice. I 1/2020 is disposed of accordingly. Admit call for TCRs. Records super left if you take list and date here. Next time.
Oblige.
24/7.
24.
Bill number 9. Pala Shetty Jagdish Sidramappa case.
For the appellant. There is a delay of 141 days in filing this appeal. I was not a party before both the matters.
Mahadevan.
Serial number 9. Yeah, 70. They're asking you, there is the respondent who are asking you address to us instead of him.
Apologies, Your Lordship. Proxy counsel for the OL, Your Lordship.
For delay, some instruction is there.
I was told that the OL is unwell, Your Lordship.
All right, but delay, he has said something. They are taking time, kindly see the order sheet.
ಏನೋ ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ರಿ.
Anytime this week will do, Your Lordship, will be able.
ನೀವು ಡಾಕ್ಟರ್ ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕೋ ಇಲ್ವೋ ಅವ್ರನ್ನ? Respondent has refused the notice, therefore service of respondent is held sufficient. That is about respondent number 2. 76 ಅಲ್ಲಿ next to be taken answered respondent for state 2. And now there is too much delay is also not there. How many days delay is there?
141 days.
31 days.
Yes. I was not a party before the company petition as well as the company application.
When
And-
Mr. Mahadevan is served in this. ಅವ್ರು ಯಾವಾಗ ಸರ್ವ್ ಆಗಿದೆ ಅವರಿಗೆ?
I served the copy when I filed the appeal in this matter. And since then he is taking time to file objections on the delay application.
I will condone the delay in 140. He was not a party there.
Right.
And considering the fact that the appellant was not a party to the proceedings in CP number 192 ಅಲ್ಲ ಅದು?
One. So,
2 ಆರ್ಡರ್ಗಳನ್ನು CP ನಂಬರ್ 192 ಕರೆಕ್ಟ್ ಅದರಲ್ಲಿ 136 ಅದರೊಳಗಿನ CA ನಂಬರ್
CA number 136 of 21 and also 192 of 2011.
the delay of ಎಷ್ಟು 141 days is condoned in the interest of justice. I do absolutely agree is disposed of accordingly as requested by response counsel list down ಅಲ್ಲ ಅವ್ರಿಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತಿದ್ರು 10 days ಬೇಕಾಗ್ತದೆ 16 sir.
Obliged, Your Lordship.
ನಾವು ಆಗೋದು ಬೇಡ ಆದ್ರೆ ಅವ್ರಿಗೆ ಕನ್ಸೂಮ್ ಮೇಲೆ ಕಲಿಸ್ತಾರೆ ಅಲ್ಲ ಅದೇನಾ ಅದು ಏನೋ ಅಡ್ವೊಕೇಟ್ ಸೈನ್ ಹಾಕ್ಬೇಕು ಅಂತ ಮಾಡಿದ್ರಲ್ಲ ಅದು ಯಾರಮ್ಮ ಬನ್ನಿ ಬೇಗ ಬೇಗ ಬನ್ನಿ ಮುಂದೆ ಯಾರು ಟೈಪ್ ಮಾಡಿದ್ದು ಇದನ್ನ ನೋಡಿ ಸೈನ್ ಹಾಕಿದ್ದಾರೆ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಅದ ಯಾರೋ ನೀವು ನೋಡಿರೋದಿಲ್ವಾ ಇದನ್ನ ನೀವು ಸೆಕ್ಷನ್ ಆಫೀಸರಾ ಸೀನಿಯರ್ ನೀವು ಇವ್ರು ಮಾಡೋದು ನೀವು ನೋಡೋದಿಲ್ವಾ ನೋಡಿಲ್ಲ ನೋಡಿ ಅಲ್ಲಿ ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಥರ್ಡ್ ಪಾರ್ಟೀಸ್ ಬರ್ದಂಗೆ ಜಸ್ಟಿಸ್ ಅಂತ ಬರೆಯೋದು ಬರಿಬೇಡ್ವಾ ಬರೀ ಎಲ್ಲದಕ್ಕೂ ತಪ್ಪಾಯ್ತಾ ಇನ್ನೊಂದು ಇದಕ್ಕೂ ಕರ್ಸಿ ಅದ್ ಯಾವ್ದಾದ್ರು MF ಅಡ್ವೊಕೇಟ್ ಬಂದು ಸೈನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು ಎಷ್ಟು ವರ್ಷದಿಂದ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಆಯ್ತು ಟೆನ್ಷನ್ ಮಾಡ್ಕೊಂಡು ಎಷ್ಟು ವರ್ಷದಿಂದ ಮಾಡ್ತಾ ಇದ್ದೀರಿ 7 years ಮತ್ತೆ ಟೋಟಲ್ ಒಂದು 7 years ಮಾಡಿದ್ಮೇಲೆ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು ಇದನ್ನ ಇವ್ರು ಬರ್ದಿದ್ದು ನೀವು ಯಾರು ಚೆಕ್ ಮಾಡೋದಿಲ್ವಾ ಮತ್ ನೀವೇ ಶೀ ಜೂನಿಯರ್ ನೀವು ಮಾಡಿರೋದಿಲ್ಲ ನೀವೆಷ್ಟು ವರ್ಷದಿಂದ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಸೀನಿಯರ್ ಅಸಿಸ್ಟೆಂಟ್ ಆಗಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿದ್ದೀರಿ 20 ವರ್ಷ ಮಾಡಿದ್ದೀರಿ ಎಷ್ಟು ಜನ ನೋಡಿರ್ತೀರಿ ನೀವು ಯಾವ್ದು ಗ್ರೂಪ್ ಡಿ ಇಂದ ಬಂದವರ ಹೇಗೆ ದ ಹೋಲ್ ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ದಿಸ್ ಒಂದು ಕ್ವಾಲಿಫೈಯಿಂಗ್ ಎಕ್ಸಾಮ್ ಇರೋದಿಲ್ಲ ಏನಿಲ್ಲ ಇವರಿಗೆ ಇದಕ್ಕಿಂತ ಅದು ಇನ್ನೊಂದು ಅಧ್ವಾನ ಇದೆ ಅವ್ರು ಗೊತ್ತಿಲ್ಲ ಚೇಂಜ್ ಆದ್ರೆ ಅವ್ರು ಸೈನ್ ಮಾಡಿ ಅದು ಯಾವ್ದೋ ತೆಗದಿದೆ ಅದನ್ನ ಕರ್ಸೋಣ
Cell number 10 adjourned for further hearing. Cell number 11, Rajeshwara PN, Sohani Holla, Sumita.
Kindly pass on. Kindly pass on. Now, election other court.
ನಿಮಗ್ ಪಾಸ್
ಬರ್ತಾರೆ ರಾಜೇಶ್ವರ.
ರಾಜೇಶ್ವರ್ PN ನೀವಲ್ವಾ
ನಾನ್ ನಾರಾಯಣ್.
ಇಷ್ಟು ದಿವಸ ನೀವೇ ರಾಜೇಶ್ವರ್ PN ಅನ್ಕೊಂಡ್ಬಿಟ್ಟಿದೀವಿ ಯು ಆರ್ಗ್ಯೂಡ್ ಆನ್ ದ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್
ಇಲ್ಲ ನಾರಾಯಣ್ ರಾವ್ ಅಂತ ರಾಜೇಶ್ವರ ಪಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಗ್ಯೂ
ಶಾರ್ಟ್ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ ಹಂಗಾರೆ ಇವ್ರು ಸ್ಟ್ಯಾಚ್ಯೂ ಸಿ ಹ್ಯಾಡ್ ಆರ್ಗ್ಯೂಡ್ ಯಾಗ ರೆಡಿ ಯಾರು ಪಾಸ್ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ
Pass.
ಪಾಸ್ ಇಟ್ ಓವರ್
ಫಾರ್ ಒಂದ್ ಮ್ಯಾಟರ್ ಆದ್ಮೇಲೆ ಬರ್ತಾರೆ.
Passed over. Cell number 12, KG Sadashivaya, Vijay Benjamin.
Let's say seek for a passover in this matter, my lords.
ಅರೆ ಎಲ್ಲ ಫೈನಲ್ ಇಯರಿಂಗ್ ಪಾರ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ಪಾಸ್ ಓವರ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ
Yes, passover, pass.
ರಿಪ್ಲೈ ಆಯ್ತು ಪಾಸ್ ಓವರ್
Cell number 13, AV
You are not filed
Kagadappa.
written submission. Last time we were asked to file written submission.
Don't I think so.
Huh?
I don't think any use. We have to argue different points.
Correct. We asked you to file the written submission.
No, I only told,
Huh?
I said I am sick. So this honorable court has to can file a written argument. This is given by this honorable court, not me. Then I said, yes, I will file.
We have
I will
seen,
file.
Last time only we had
But
seen.
suggestion was given by this honorable court.
He shall file his
Then
written
I am a
submission.
sick person. I want to know when he is coming. He has been proceeding since so many years,
The counsel-
2015.
Last time, response counsel.
He was,
said,
my arguments may be heard.
We have heard you. There was no clarity. You have some difficulty, no?
One submission. Madam.
You have some difficulties.
He has already argued.
Correct.
They are concluded. My arguments may be heard now.
We will hear you. Once again, listen to us. We'll hear you, but you have some speech problem. It's
No, I will speak double, second time.
Clarity ಇರೋದಿಲ್ಲ ಅದಕ್ಕೆ written
I will see that it clears.
So we had already directed you to file the written submission.
Not direct one submission. Madam.
He shall file his.
I said, I am not
See, the
well.
order sheet, last time order sheet we have.
Order sheet is there. I requested the court saying that I am not well. This honorable court said you can file written arguments. Then I said, I will file written arguments.
Correct.
Then I found there is no use in written arguments.
Correct. We say, see, we have passed an order directing you to file the written statement, written arguments. How can you say that there is no use in doing that?
That's my opinion. I am saying this.
You may.
I will not be helped because he has got the case recalled in my absence. I dismissed the case, dismissed after 8 years. In my absence, it is recalled. Or it may be transferred to some other court.
Why? Why it shall?
It was recalled in my absence. I have no knowledge of the case.
What was recalled?
My speech will be clear there in that court.
What was recalled?
It was dismissed.
When the,
He was sleeping for 7 years after filing.
correct, when was that
He
recalled?
filed and slept for 7 years. He got up and he was attending. It was dismissed.
No representation for the respondent. What?
It should be transferred. I think so. What I found.
See, your request, we cannot transfer like that. You. If you are
It's
not-
like that. I'm giving the reasons.
What is that reason?
It cannot be like that, like this.
No. See,
No, it's not like that. It's my case. I had to answer my client.
you, Mr. Counsel, what we said, you argue. Last time also said you argue.
Like that only, I said I am not well. This honorable court suggested me to give written arguments. I said I will file. Now the thing has come, order is passed, I directed you. It's coming in that way. Like I am committing contempt of court. It's coming in that manner.
Pardon? We didn't.
I only suggested I'll give in writing. Then this honorable court, okay, you can give in writing. I said, okay, I'll give. Now it has come in a one-sided. It is coming that this court has directed me to file written arguments. Why?
Right, we have said. We
That's it. But what is held is not held. That's why only case may can be transferred.
Why only on that ground? It becomes.
And so many points. I'll argue all the points. Why it should be transferred.
All right, you file an affidavit to that effect.
On submission, this case was dismissed on 10/3/23. Dismissed. Now it is dismissed on 10/3/23. It was recalled 10/3/23. Twenty-eight to 24. He recalled it 28. No, I have no knowledge of the case. I am thinking it is dismissed. Why I'll come? I was sick. I thought, oh, I'll take rest. Listed. No, my number was not registered. Yesterday I got registered. I did not get. But the lawyer calls me. How many misrepresentations? In every date of hearing, order sheet may can be seen. He says compromise. Compromise. Settlement is made.
May I
They're
make one
coming, he's
submission in
coming.
this regard, my lord?
Settlement. So many settlements. Learned counsel for the opponent. Somewhere is there, settlement talks are going on. Whose settlement? What settlement? Why settlement? Settlement is going on, he says. There is order sheet 10/4/24. No, why such a misrepresentation? And why the IA having 43 days delay in filing is allowed? I should be given notice. It's not given to me. And the matter comes, respondent is absent, no representation, and it is allowed. For submission, my lord, when the case is dismissed, my party should get notice. He did not get, and it is allowed.
If something was wrong, he could have filed application for.
Case was dismissed.
Correct. Dismiss.
Then he files IA, separate IAs. Those IA copies should be sent to my client. Then I'll come and argue. I have no knowledge. He has no knowledge.
Because how the court will come to know? It is listed, your name is shown in the cause list, and the application was allowed, it seems. If you have any grievance, you could have filed application to recall that order. Now at this length of time, we are saying so many things. Apart from that, what we are saying, if you have any grievance, you file in your affidavit. You file your affidavit, we'll consider to place the matter before the Chief Justice. You cannot make this kind of allegations just in the.
There are not allegations. But no, what I found, what is coming, I requested the court saying that I will file written arguments. Now it is coming that court has directed me. What is this? I have to see this thing in this age, being a senior advocate. And last time this honorable court called me layman. Directly this court said, you are speaking in layman's language. Last date of hearing. Oh, I'm speaking layman's language. It may be transferred. Otherwise, only layman's things will come. I want the case to be transferred. I'll file application. It may simply be adjourned. I'm filing the counter. It may be taken as I'm going to file an application. A week's time may be given. I'm sick. Such things should not come from the court. Now he comes and says, my senior is busy, then pass over.
My lord, my
Why
submission is
pass over?
not that, my lord.
Why pass over? I'm sick, I'm sitting since a long time here. He says, pass over. And it is passed over. And he concluded his argument. Why pass over? This pass over only made me to argue on this.
We record that you are making some remarks against the court.
No, nothing against the court. I never made it. I said, when he concluded the argument, Junior is sitting here, I should be heard.
We said we are going to hear.
No, I'll file an application maybe given for transfer. Next week. Date.
In the open court, we never hide anything.
That is the thing.
Want your time. You want next. Next.
Eleventh July. I'm not layman. I'm a senior counsel.
Cell number 13, A.V. Gangadrappa, Murugesh Vicharati.
For the respondent. They have filed application to club the matter along with MFA.
It's MFA 2801.
1220, sir.
No, sorry.
You have filed.
I filed the
Applicant, the appellant.
I filed the MFA 2801 of 2017 challenging the decree of divorce. Matter was heard for some time during the last week. And then when I made a submission regarding the pendency of this MFA 1220 of 2022, the observation of the court was to get that appeal also clubbed along with this appeal. Therefore, I filed the application. Decree of divorce, which has been challenged before this honorable court after hearing both sides. Other appeal is bigamy in the sense during the subsistence of the interim order of stay granted by this honorable court. After hearing both sides, interim order of stay was granted. During the subsistence of the marriage, these respondents claim that they have married and have produced the certificate, marriage certificate. I filed the suit before the family court for declaration that the marriage between defendants 1 and 2 is null and void, not binding on the plaintiff, etc., etc. The trial court has dismissed the suit.
May be allowed.
Pardon me?
If this decree is reversed, ಅದು automatic ಆಗಿ allow ಆಗ್ಬೇಕಾಗುತ್ತೆ ಅಂತ ಹೇಳಿ.
How?
This can be heard as well.
No, this, the 28101 of 2017 was heard. Then during the course of argument, I made the submission that during the subsistence of the marriage, the husband has taken a second wife, and that has been registered with the registrar. Declaration that this marriage, yes, that has now been dismissed by the trial court.
Now, this appeal is allowed that automatically goes. Why you wanted that?
Matter is now before the court, so that the parties are one and the same. The second defendant in this present appeal is also required to be heard. Therefore, I ತಮಗಿದೆ ತಾವು ಆದೇಶ ಮಾಡ್ಬೇಕಷ್ಟೇ.
It will come to the senior, by order of this Chief Justice 2019 order, it will go before the senior most.
Cell number 14,
ಏನಾಯ್ತು ಆರ್ಡರ್?
Please, please, my lord. 14.
Till number 14.
14, please, my lords.
Now, yes.
Yes, 14.
Sir,
14.
Number 14.
14, my lords. Kindly pardon me, yesterday I could
mic
not be
on
present, my lords, in the
ಮಾಡ್ಕೊಳ್ಳಿ.
afternoon.
You
Unmute ಮಾಡ್ಕೊಳ್ಳಿ. Mr. Hegde.
ಅಲ್ಲ, ನಮ್ದು ಅನ್ಮ್ಯೂಟ್ ಆಗಿದೆ, ಅನ್ಮ್ಯೂಟ್ ಇದೆ. Unmute ಇದೆ ಅಲ್ಲ? Unmute ಇದೆ. Am I audible? I will join at 2:30 if there is any inconvenience. I will join at 2:30, my lords, if that's the case. ನನ್ಗೆ ಸರಿಯಾಗಿ ಕೇಳ್ತಾ ಇದೆ. ನನ್ ಕೇಳ್ತಾ ಇದೆ.
What do you want?
No, my lords, if my lords are able to hear me, I will make my submission.
Right, we can also hear you.
Please, then my lords, my lord, in this case,
Yes, we are able to
grateful.
hear.
Your lordships had heard on the earlier occasion. First of all, my apologies. Yesterday afternoon, I could not be present, my lords. My lords, in fact, after hearing my lords, on the previous date, learned advocate for the divorced wife appeared. So that's why it was adjourned on the previous adjourned date. We thought they are going to make some submissions. I don't know whether they are present today. They sought time and they filed wakalat for the first time on the previous occasion.
No, there. Sanjeev Rao, if he doesn't turn up, we'll see. Nina Bandidra. We'll hear you and proceed to pass order.
Please, my lord, this is the case where, as the custody question is one of custody of the child, my lord, who is now almost 70, completed 17 years. Now, my lord, the child is now studying in expert college in Mangalore. And educational expenses, everything is borne by the father.
Network is not correct.
I will join at 2:30, my lords. I'm so sorry. I'll physically join late.
Break.
I will join
Able to
physically, my
hear
lords.
you.
I'm so sorry, the technical. Internet. Kindly permit me to appear at 2:30 physically, my lords. If the internet is not proper, kindly permit me to appear at 2:30. I don't know whether if I am not audible, I will appear physically at 2:30.
Yes, ಹೇಳಿ. ಆಯ್ತು ಹೇಳಿ. Yes.
Please, my lords. Now, my lord, as far as the divorce petition and the divorce orders are concerned, kindly see the exhibit P27.
Yes.
P27. That is,
Judgment in MC number 49 of 2014.
please. Adrolage, kindly see internal page number 10.
10, yes.
Last but 7th line. Joint petition filed by them for divorce and consent by the respondent was withdrawn. And thereafterwards, matter went on merits. And the petition was allowed in the next page, page number 12. And there is no order regarding visitation, anything in this order. And kindly see exhibit R6. Exhibit R6 is MC number 2 of R6. Howdu. This is joint petition. In this joint petition, second page, para 5.
R6 is the petition copy.
Howdu, adrolagene petition joint signed by both parties. Signed by both parties. Second petitioner in the middle portion.
Yes.
Para 5 middle portion. Second petitioner is intended to visit the child and wanted to make the temporary custody during the school holidays and vacation of the first petition is agreed to give the custody of the child to the second petitioner. Both parties agreed to claim the permanent custody of the child by approaching the court, etc. And so visitation during holidays, etc. was mentioned there. That's all. And now, by virtue of the impugned order, the learned trial judge in point number 3, that is internal page number 34 of the impugned order.
Point number?
I take my lord to para.
Number 3
para
in this
20.
case, sir.
Prior to that, may I take the honorable court directly to para 25. That's
Page number?
internal page 31. Internal page 31.
An internal page.
Of the judgment of the impugned judgment. That's ink page number 42.
Internal
Now,
page 30.
31, para 25. The evidence on record at the top. Evidence on record is sufficient to take note that the petitioner visits his child Rohan and the child Rohan is also will be in the company of his father during holidays. Present facts and circumstances do lead to establish the petitioner has love and affection towards the ward Rohan and also the ward is having love and affection towards the father. He likes to spend time in the company of the father. And the evidence is to the effect that the respondent permits the ward Rohan to be the company of his father and his grandparents and other family members of the petition in holidays. Respondent admits the petition is having love and affection towards the child and the circumstances taking note of the petition is having opportunity to meet the child and enjoy his visiting rights and is living and residing with his child during vacation and holidays and expressing his love and affection. Then it does not warrant to hand over the custody, so and so. And therefore, in the para 28, point number 3, court decides about the visitation and the custody. And then in the next page, at the last page, my lords, in the middle portion, already petition is enjoying and exercising his rights and meeting the child. Hence, there is no need to consider the visitation rights. Hence, it is dismissed. Now, my lord, the subsequent facts are this.
Right, you want specific.
Only that, my lords, I am informed. That's I was happy that the respondent wife also appeared so that she can also bring the true facts to the honorable court. The fact is that the father has taken care of the child, and the mother and the child both are residing together in a rented premises in Mangalore. Father is meeting the expenses of the child and also of that rented premises, and he is meeting the child whenever he wants on holidays. He goes. He is also a lecturer in Hasa. He goes and meets. Now, my lord, child is attaining 18 years in a year because date of birth, my lords, of the child. With kind permission, my lord. Check date of birth, my lord. The child is 7/5/2006 is the marriage, my lords.
Where are you referring?
Exact date of birth I'm trying to submit to the honorable court, my lords.
Yesterday, last time, 16.5 years on the.
Howದು.
He is born on.
7/5/2000, 7/5/2006, 7/5.
No, segment. He is 16.5.
Please, 16.5, 16.5.
He's about. ಅಲ್ಲ ಎಲ್ಲ ಒಂದ್ ಕಡೆ. Last time you said the date of birth, we counted based on that 16.5
Please,
years.
That's true, 16.5, 79. I'm trying to kindly pardon me, my lord. Locate the exact date of birth in the papers, my lords. Date of marriage is mentioned and date of birth.
For custody, wife also contest that. Other petition date of birth of the child ಹೇಳೋದಿಲ್ವಾ?
My lord, it's here 2/1/2008, my lords. 2/1/2008, my lords. It's in P17.
Somewhere we found it last.
P17 ಅಲ್ಲಿ ಇದೆ. P17, my lords. P17. ಹೌದು.
Statement of objection. Last time here. School certificate, P17.
ಹೌದು. Date of birth 2018. ಹೌದು.
P17 is
P17.
school record.
Admission. Rohan, yes. Date of birth.
P17 is application for admission.
ಹೌದು, ಅದರೊಳಗೆ ಕಾಲಮ್ ನಂಬರ್ 3 ಅಲ್ಲಿ.
ಅದೇ 2/1/2008 ಅಂತ ಹೇಳಿ. This basis
ಹೌದು.
only last time we counted he is almost 16.5 years ಅಂತ ಹೇಳಿ. But P17, there is no dispute about the date of birth of the child.
ಇಲ್ಲ. ಏನಿಲ್ಲ. So my lord, my only prayer is this, my lords. This visitation is going on even now, but is not specifically mentioned. During holidays, child is with the father, and other times he is also visiting the child. I only pray that let there be a positive order. Otherwise, there may be problem. Let there not be any problem.
So you confine that there should be a specific order for visitation.
That's all. As it is, actually, it is there, but it's there in the discussion. Let it be there in the operative
Any
portion.
trial court in its discussion, it has said anyhow they are visiting. And of course, he has the right of visitation.
That's all, my lord. With that, your lordship can be dispose of. I hope within when the child attains the majority, my lord. Now in this case, there is a in one or the other way, there is a amicable settlement among themselves. So this is not a matter which requires any.
Last time you only.
Please. I submit the same.
If we remember correctly, first time you said that child is about to attain the age of majority. It may not survive after some time. So
exactly. Even now the same prayer, but in the during I don't, because my lords, I will
what
not
you
be able
want is a specific order for
that's all affirming that right.
Exhibit. Was there any arrangement?
ಇಲ್ಲ. Arrangement among themselves in exhibit R6, it bears R6 shows that they themselves made some arrangement, and which is reiterated by the R6 joint petition. They said something in para 5.
ಅಲ್ಲ ಅದು exhibit R6 is
Joint petition for divorce, which is acted upon and which is signed by both parties, and it continued. And it is continuing even now as per the order of the learned trial judge.
ಯಾವ್ದು ಈಗ there was one divorce decree also, in that no visitation rights.
ಇಲ್ಲ ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇಲ್ಲ.
That is exhibit P27 ಅಲ್ಲ?
ಹೌದು, ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ.
MC 49 ಅಲ್ಲ ಅದು?
That's my lords, MC 49 of 2024.
49 of 2014.
2014.
In none of the proceedings, any interim arrangements were made for the visitation of the child?
ಇಲ್ಲ, ಎಲ್ಲೂ that nothing is made, my lord, except as reflected in the joint petition, which is a mutual arrangement between them. I am informed it's continuing even as on today. I hope it will continue for one more year, my lords, when child becomes a major.
Last time ಬಂದಿಲ್ಲ.
In fact, on the first occasion when I submitted, wife was ex parte, my lord, then wife entered appearance with the advocate. Therefore, my lords had accommodated for one adjournment.
But somebody has appeared for them, they are not appearing.
ಹೌದು, ಇಲ್ಲಿ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ. ಒಂದು ವಕಾಲತ್ ಹಾಕಿದೆ ಶಾರ್ಟ್ ಟೈಮ್ on one date, previous date, on that ground, and that was accommodated.
ಏನ್ ಮಾಡೋದು ನೋಡಿ, ಇಲ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ರು ಆಮೇಲೆ ಬಂದು ಅಲಿಗೇಷನ್ಸ್ ಬರ್ತಾರಲ್ಲ. ಅವ್ರು ಯಾರು ಇಲ್ಲಿ ಬರ್ತಿರ್ತಾರ ರೆಗ್ಯುಲರ್ಲಿ? ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ವಿಸಿಟೇಷನ್ ರೈಟ್ಸ್ ಬರ್ಕೊಂಡು ಚಾಲೆಂಜ್ ಮೆಮೋ ಅಂಡರ್ಟೇಕಿಂಗ್ ಹಾಕಿದಾರ. ವಕಾಲತ್ ಹಾಕಿಲ್ವಂತೆ, ಬರೀ ಮೆಮೋ
Sorry.
ಅಂಡರ್ಟೇಕಿಂಗ್ ಫಾರ್ ಅಪಿಯರೆನ್ಸ್ ಅಂತ.
Because my lords, on the previous occasion at 10:30 they requested, my lords, and my lords were pleased to adjourn the case on that ground.
Challenging dismissal of this petition for custody of petition under section 12 of the Guardians and Wards Act for custody of his son Rohan.
Nice.
The petitioner in C and Law 2015 on the file of Principal Judge Family Court Hassan has preferred this appeal. There is a lot of applications. The petition, I'm sorry. The appellant was the petitioner and the respondent was the respondent in C and W 2015. For the purpose of convenience and henceforth according to the ranks of the trial court. No, there are so many missing. The marriage of and governed by other law, personal law applicable to them. Their marriage was solemnized on 7/5/2006 at Dharmasthala. Out of the said wedlock, the couple begot a son. The couple are blessed with a son by name Rohan on 2/1/2008. There were some disturbances in the marriage. ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ತುಂಬಾ ಕೇಸಸ್ ಇದೆ.
ಇಲ್ಲಿ ಬರ್ತಿದ್ದಾರೆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಪೇಜ್ ನಂಬರ್
ಅದೆಲ್ಲ ಗ್ರೌಂಡ್ಸ್ ಮಾಡಿದಾರಲ್ಲ. ಪೇಜ್ 21 ಅಲ್ಲಿ ಇಂಟರ್ನಲ್ ಪೇಜ್
ಕೇಸ್ ನಂಬರ್ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ ಇದೆ 23
ಪೇಜ್ 20 ಇಂಟರ್ನಲ್ ಪೇಜ್ 21 ಅವ್ರು ಮೊದಲು ಟೀಚರ್ಸ್ ಇರೋದ್ರಿಂದ ಇದ್ರ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ
Next page 23 is in
Most
cases
ground
referred.
again.
Yes, there are cases.
49 of 2015 was for a mutual consent. There are two MC.
No, 49 is by contest, my lords.
49
Mutual
of
consent is 2 of 2015.
Withdrawn.
2 of 15.
Howd.
The
R6.
copy filed MC 2 of 2015 before
Before
ಯಾವ
the
ಕೊಟ್ಟದ?
senior civil judge Bantwal.
Senior civil judge Bantwal under section 13B of the Hindu Marriage Act, seeking dissolution of their marriage by
Mutual consent.
mutual consent. ಏನಾಯ್ತು ಅದರಲ್ಲಿ?
Adrolage, my lord, only one thing is para 5 says that mutual arrangement is being made. It was withdrawn. And then MC number 40,
ಡಿಸ್ಮಿಸ್ ಆಗಿಲ್ಲಲ್ಲ?
my lord, it's withdrawn, my lord. That
ಪಾರ್ಟೀಸ್
dismissed.
ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಆಗಿಲ್ಲ ತಾನೆ?
No, that's withdrawn, my lord. It's withdrawn or dismissed. Then because
ಆರ್ಡರ್ ಕಾಪಿ ಇದೆಯಾ?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಇದೆ ಸ್ವಾಮಿ. In the that discussion is found in the impugned order itself.
But however, that was because of the difference that was not taken to a logical conclusion.
It was withdrawn, my lord.
MC number 49 of 2015 against the petitioner seeking divorce on the ground of clarity. That was allowed on
Allowed on 1st June 2017. P27. 1st June 2017.
on hearing the part is that was allowed on 1/6/2017. You in that case MC consent date ಬರಲಿಲ್ಲ. That mutual
is withdrawn, my lord. 2 of 2015 is withdrawn.
Respondent had filed a petition under the DV Act in criminal miscellaneous number 1021 of 2014, and even that is allowed. Criminal miscellaneous 1021 of 2014.
ಹೌದು.
Exhibit test. Exhibit R2 ತೆಗಿರಿ and petition. Exhibit
R1.
R1. Main order ಹಾಕಿದೆ. Domestic Violence Act main order copy is also produced.
Order sheet.
R1, my lords. R1 is
Some of you have produced that. R1 ಬರೀ ಆರ್ಡರ್ ಶೀಟ್ ಕಾಪಿ ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಿ. ಇದು ಜಡ್ಜ್ಮೆಂಟ್ MC 199 of 2013 exhibit P10 ತೆಗಿರೋದು ನೋಡೋಣ. Petition, certificate copy of application, admission. ಅದು ಆರ್ಡರ್ ಕಾಪಿ ಹಾಕಿದಾರಲ್ಲ ಅದು 199.
P10, my lords.
That was allowed, that MC 199.
Please, my lords.
That was set aside by High Court.
That is, my lord, not about these parties, my lords. That is appears to be ಇವರೊಳಗೆಲ್ಲ my lord, that is the allegation is, my lord, that of course I will not repeat those allegations, that she had some relationship with Girish, marriage of Girish with Girish has been dissolved, etc. Allegation is she was having illicit relationship with Girish. For the purpose of marriage, Girish marriage is dissolved as per Exhibit R1. Not relevant.
In this case, law ground. The both the petitioner and respondent were working. The petitioner finds the end of the office in 15. Alleging that the respondent ಅಲೋ ಆಗಿದೆ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ ನೋಡಿ ಇನ್ನೊಂದು ಮಿಸ್ಲೆನ್ಸ್ 1020. He has made allegations that she has some relationship with another person.
Yes, please, ma'am. That is the allegation.
Yes.
I don't want to go with that, but the instruction is even now she is residing with so and so, but we will not now, my lords. Go on with that. I will not press any allegations now, but the contention instruction is even now she is residing with so and so. Anyhow, that's now marriage is now dissolved, my lords.
Like that. If further the respondent is working, ಇದೆ ಅಲ್ವಾ 40 kilometers ದೂರದಲ್ಲೆಲ್ಲ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹೌದು.
Working as a teacher, which is in a school which is 40 kilometers, yes, para 23, 40 kilometers away from her residence. In her absence, the child will be unmonitored. That may affect the interest of the child. He further claimed that he is residing with his parents and he is financially well off. The child's interest will be better, well protected if the child is in his custody. Therefore, he sought the custody of the child. The respondent contested the petition, denying the allegations made against her. She contended that the petitioner himself was an abuser, which forced her to stay separately, and initiate proceedings against him under the Domestic Violence Act and R1 to R8 were marked. The trial court, on hearing the parties were impugned judgment and order, dismissed the petition, holding that the allegations of respondent pleading the adulterous right were rejected. Were not proved. The trial court further held that both couple are financially able to financially independent on child's interaction and material on appreciation of evidence. It is found that child is spending its time with both the couples, though he stays with his mother. The trial court further held that the petitioner has migrated to Chennai for his PhD, for pursuing PhD, and therefore the child cannot be married. And his parents are aged 1 Therefore, child continuing in the custody of the mother is serves the welfare of the child. That right. Ultimately, the trial court dismissed the petition. Shri P.P. Hegde, learned senior counsel, appearing for Shri Yari, the advocate Venkatesh Reddy, learned counsel, fairly submits that the child is now 16 plus.
Oh,
16, aged 16 years.
studying in first year.
Should we record your concession or we should write it on merits?
Your lordship may write as my.
Should we
I'm
record your
kidding.
concession?
Please, your lordship may record mail because it's a factual situation between husband and wife, my lords. A factual situation. I'm sorry.
You want us to record your concession or?
Concession only, my lords.
Pardon?
My submissions as a
Concession record
pleading.
ಮಾಡನಾ?
Concede ಮಾಡಬಹುದು. ಮಾಡಬಹುದು.
ಕೇಳ್ತಾ ಇಲ್ಲ.
Concede. I am conceding to the position, my lords.
Concession record ಮಾಡಬಹುದಾ?
Yes, yes. Please record the concession.
Lord Hospital. The child is already 16.5 years old and now he is in a crucial, he is studying in PUC, na?
Oh,
PUC,
first.
which is a crucial time for the child. Okay. He further submits, ಇಲ್ಲ ಅದು ಅದರಲ್ಲಿ. ಅದ್ರ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇದಾರಲ್ಲ ಅದರಲ್ಲಿ.
ಹೌದಾ, he himself paying and entire
by way of maintenance.
ಅಲ್ಲಲ್ಲ, entire educational expense is himself meeting, not.
Petitioner/appellant is meeting the educational expense of the child.
And they admitted a child to expert college, Mangalore.
Considering
Agbo.
appellant is appellant petitioner is though the trial court observed in the body of the judgment that petitioner is enjoying the visitation rights. The same is not reflected in the final order. And the appellant is satisfied if visitation rights, specific order is passed for visitation rights. Right?
Yes.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ visitation rights and ಹೌದು.
Next one. Response counsel or memo of appearance ಹಾಕಿದಾರ?
Undertaking memo.
Undertaking. Respond, those served did not turn up. Shri Sanjeev Rao S, an advocate, undertook to appear on her behalf, but subsequently failed to appear. The records show that. Though the custody of the child was sought on the ground that mother is leading adulterous life. Therefore, it is injurious for the child to continue in her custody. The respondent filed MC number 49 of 2014 against the appellant petitioner for decree of divorce on the ground denying the said allegation and further claiming that such unfounded allegation against her amounts to cruelty. The exhibit R6 and R6 is 13B petition.
ಹೌದು, ಅದರೊಳಗೆ visitation arrangement is mentioned, that's all, para 5.
ನೋಡಿ ಕರೆಕ್ಟ್
ಹೌದು.
ಎರಡು ಒಂದೇ ಅಲ್ವಾ? R8 and P27. You only have produced that judgment.
ಹೌದು.
ಇದನ್ನೇನು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ because now my lords divorce everything has become
PS 27.
ಹೌದು ಇಲ್ಲ.
The certified copy of the judgment in MC number 49 of 2014 passed by the principal senior civil judge and JMFC Bantwal DK shows that the said court granted a decree of divorce in favor of the respondent herein, accepting her allegation that the petitioner making unfounded and uncharitable allegation of adultery subjected her to cruelty. Further, criminal miscellaneous ನಲ್ಲಿ award ಮಾಡಿದಾರಲ್ಲ, exhibit P 26, the certified copy of the order in criminal miscellaneous number 1000, certified copy of the order dated 8/5/2017 in criminal miscellaneous number 1021 of 2014 passed by the principal senior civil judge and JMFC Bantwal DK shows that the respondent herein filed the said case under section 12 of the Protection of Women from Domestic Violence Act against the present petitioner. Alleging that he has subjected her to domestic violence, suspecting her fidelity, and he failed and neglected to maintain her and her son, etc. The said petition domestic violence negative ಮಾಡಿದ್ದಾರೆ,
ಹೌದು.
ಮೇಂಟೆನೆನ್ಸ್ ಅಲೋ ಮಾಡಿದ್ದಾರೆ, partly
Maintenance only for the child, my lords.
that she is entitled to protection order, ಅದನ್ನು affirmative ಅಂತ ಮಾಡಿದ್ದಾರೆ. Gold ornaments negative. Compensation point number 5 was compensation, ಅದನ್ನು negative ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Maintenance to child at 4,000 per month.
In the said case, the said court ಅಲ್ಲ, he is restrained from committing violence ಅಂತಾನೆ ಇದೆ ಅಲ್ಲ.
Please.
Partly allowed the said court partly allowed the said petition, restraining the petitioner from subjecting her to domestic violence and awarding rupees 4,000 per month as maintenance to petitioner number 2. That is petitioner number 2 is son.
ಹೌದು, which is paying, my lords.
Number 2 the son.
ಹೌದು.
So, okay. Those orders have attained finality. Under such circumstances, the trial was justified in rejecting the petition for the further, the evidence on record shows that the petitioner, though the petitioner was in Hassan at the time of filing of the petition, subsequently he shifted to Chennai for his PhD studies. And his parents were in Hassan. The trial court took that aspect also in consideration in rejecting the petition.
Now he is in Hassan. Now presently he is a lecturer in Hassan.
ಅವಾಗ ಕೊಟ್ಟಾಗ
ಹೌದು, that's it.
ಆ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದಾಗಲೇ
ಹೌದು.
ಏಜ್ಡ್ ಇರ್ತಾರೆ. Petition was filed in the year 2015. Now 10 years have elapsed. And the parents of the petitioner, whether both of them are alive, no? Parents of the petitioner,
Sorry, I am able to.
no idea. By this time should have
ಬೇಡ, ಮತ್ತೆ ಎದ್ದಿದ್ಬಿಟ್ರೆ ಕಷ್ಟ.
further advanced in age, ಅಷ್ಟೇ ಹೇಳ್ತೀವಿ, further advanced in age.
ಅವ್ರು ಒಂದು ವೇಳೆ ಇದ್ರೆ
Taking into consideration all the above aspects. No, the trial court was justified in holding that the continuation of the custody of the child in with mother serves the welfare of the child. However, though the trial court itself observed that the child that the petitioner enjoying the visitation rights and child is happy in the company of both the parents.
And
did not
also,
pass any order, did not pass any order.
also, my lord, the child will be in the company of the father during holidays. Para 25.
Did not pass any order regarding visitation rights. Therefore, order requires to be modified only to that extent. Iga PUC na?
First PUC, my lord. Now, your lordship may say subject to the convenience and the child only, because now everything is going happily.
Subject to his academic.
Subject to his convenience. They will, that's all, my lords. Visitation plus company. Sometimes he comes and stays in Asan now. So subject to, we can cut.
Only to that extent, hence the following order. The appeal is partly allowed. The impugned judgment and order dated 7/11/2017 in C and W number 2 of 2015 passed by the Principal Judge Family Court Hasana.
Howd, Principal Judge Family.
So far it relates to the continuation of the custody of the child. So far it relates to rejection of the petition for permanent custody of the child is confirmed. It is further directed that the appellant petitioner is entitled to the visitation rights of the child.
And also company of the child during holidays, subject to the convenience.
ನಾವು ಒಂದು ಶೆಡ್ಯೂಲ್ ಹಾಕ್ಬಿಡೋಣ, ವೆಕೇಶನ್ ನಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅಂತ ಹೇಳಿ.
ಆಗ್ಬೋದು because ನಾವು
ಅದೊಂದು ಗ್ರೌಂಡ್ ನಾವು ಹೇಳಿಲ್ಲ ನಮ್ಮ ಬಾಡಿ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ನಾವು ಆಲ್ರೆಡಿ ಚೈಲ್ಡ್ is aged 16.5 years. After once the child attains the majority, he can stay with the parents of his choice.
Yes.
Either parents of his choice. Okay, ಅದೊಂದು ಇಲ್ಲದಿಲ್ಲ. ಈಗ ಬೆಳೆ as follows. The respondent the respondent shall hand over the custody of the child to the petitioner during 3 ವೆಕೇಶನ್ ಇರುತ್ತಲ್ವಾ, ಸಮ್ಮರ್ ವೆಕೇಶನ್, ವಿಂಟರ್ ವೆಕೇಶನ್, ದಸರಾ ವೆಕೇಶನ್.
ಹೌದು ಈಗ ಹೇಗೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ವೆಕೇಶನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿರ್ತಾ ಇದ್ದಾನೆ ಈಗ ಸದ್ಯಕ್ಕೆ. ಮೇ ಸಜೆಸ್ಟ್
ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ಬಿಡೋಣಲ್ಲ, ಸಬ್ಜೆಕ್ಟ್ ಟು ಅದರ್ ಕಂಡೀಷನ್ಸ್ ಅಂದ್ರೆ ಎಜುಕೇಶನ್, ಹೆಲ್ತ್ ಅದೆಲ್ಲ
ಆಗ್ಬೋದು.
ಡ್ಯೂರಿಂಗ್ ಅಲ್ಲಿಂದ ಅವ್ರು ಕೊಡೋದು ಬೇಡ, ಸುಮ್ನೆ ಅವ್ರಿಗೆಲ್ಲ ಇವರೇ ಕೊಡ್ಲಿ. ಆಫ್ಟರ್ ವೆಕೇಶನ್, sorry, when the vacation commence, generally parents will pick up the child, no? They can
ಹೌದು ಅವರೇ ಹೋಗಿ ಬರ್ತಾ ಇದ್ದಾರೆ, ಮಂಗಳೂರು ಹೋಗಿ ಕರ್ಕೊಂಡ್ ಬರ್ತಾ ಇದ್ದಾರೆ.
During the summer, winter and Dasara vacations, are the vacations as per the vacation pattern as per the school where he is studying, school/college where he is studying. Soon after the vacation is over, ಮತ್ತೆ ತಾಯಿಗೂ ಇದ್ದಾಗೆ ಆಗೋದಿಲ್ವಲ್ಲ, ಇರೋದೇ ಹಾಸ್ಟೆಲ್ ಅಲ್ಲಿ, ಪೂರ್ತಿ ವೆಕೇಶನ್ ಅವ್ರಿಗೆ ಕೊಟ್ರೆ ತಾಯಿ ಜೊತೆಗೆ ಇದ್ದಾಗುತ್ತೆ.
One aspect, since it's expert college at Mangalore, I know ಹಾಲಿಡೇನೆ ಕೊಡೋದಿಲ್ಲ ಅವ್ರೀಗ.
ಹೌದು, ಅದಕ್ಕೆ ಅಲ್ಲ, ಅದ್ರಲ್ಲೂ ಕೊಡೋದಿಲ್ಲ, ಎಂಟೈರ್ ವೆಕೇಶನ್ ಅವ್ರ ಜೊತೆಗೆ.
ಅದಕ್ಕೆ ಹಂಗ್ ಬೇಡ, ದಯವಿಟ್ಟು ಇಷ್ಟು ಸಾಕು. ಡ್ಯೂರಿಂಗ್ ವೆಕೇಶನ್ ಸಬ್ಜೆಕ್ಟ್ ದ ಕನ್ವೀನಿಯನ್ಸ್ ಚೆಕ್ ಸಾಕು.
ಡ್ಯೂರಿಂಗ್ ವೆಕೇಶನ್ ಅಂದ್ರೆ ಎಂಟೈರ್ ವೆಕೇಶನ್ ಅವ್ರ ಹತ್ರನೇ ಇರೋದು. ವಾಟ್ ಅಬೌಟ್ ಮದರ್?
ಈ ಅವನು PCMB, it's impossible for him to go out. They don't this college.
Without affecting his academic activities.
Correct.
So ಎಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ so that instead of all these full ಬಿಟ್ಬಿಡಿ, ನಮ್ಗೆ ಎಷ್ಟು ಬೇಕು
ಅದೇ ಇದು ಇದ್ರೆ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಆಮೇಲೆ ಎಲ್ಲಾದ್ರೂ ಸ್ವಲ್ಪ ಕರೆಕ್ಟ್ ಇಲ್ಲ, ಅದೊಂದು ಲೂಸ್ ಎಂಡ್ ಇದ್ರೆ ಅದಕ್ಕೂ ಹೊಡೆದಾಡಕ್ ಶುರು ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೆ half of vacation ಅವ್ರ ಜೊತೆಗೆ half of vacation ಇವ್ರ ಜೊತೆಗೆ
Now,
ಇರೋಂತ ಬಿಡೋಣ.
ಇದ್ರೊಳಗೆ I feel my lords, my respectful submission is, I had an occasion to speak to, he is also very responsible. ಅವನು ಹೇಳಿದ್ದು ಮಗು ಬಂದಾಗ ಬರ್ಲಿ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಬಟ್ ಒಂದು ಆರ್ಡರ್ ಇರ್ಲಿ ಅಂತ ಹೇಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಮತ್ತೆ ಅವಳು ಬಿಡ್ಲಿಲ್ಲ ಅಂತೆ. ಈಗ one aspect the honorable court may take judicial notice. ಅವರು this college, even if a close relative dies, they don't give leave. So, practically it's as if there is no leave for him for 2 years now. As I know.
ಕೊಡೋದಿಲ್ಲ ನಮಗೆ ಗೊತ್ತಿದೆ. That's why we are saying. That's why ಈಗ suppose if they give 1 week, entire 1 week ಇವ್ರ ಜೊತೆಗೆ ಇರ್ಬೇಕಂದ್ರೆ
Your
ಮಗು
lordship may
hostel ಅಲ್ಲೇ
correct
ಇರುತ್ತೆ.
this, subject to the convenience of the child. It's impossible to PCM ಬಿಡೋದಿಲ್ಲ, JE ಗೆ ಹಾಕ್ಬಿಟ್ಟವ್ರೆ, JE ಗೆ. He will not be getting the custody at all this year.
Expert ಆಯ್ತು, ಪೂರ್ತಿ ಅವ್ರ ಜೊತೆಗೆ ಇರ್ಲಂದ್ರೆ ಮುಂದೆ the child will not be with her. She has succeeded before the trial.
ಇಲ್ಲ child is with her
Child
only,
will
she
not
will
be
continue
with her
with her
when
only.
it stays in the hostel. Vacation ಅಲ್ಲಿ ಬಂದಾಗ ಪೂರ್ತಿ ಅವ್ರ ಜೊತೆಗೆ ಇರ್ಬೇಕು
I will
ಅಂತ.
not, I don't want any specific date. Your lordship may kindly say, has the right to stay and visit the child during whenever he goes to
That
Mangalore.
is enough for you.
And the second is, as far as stay during holidays is concerned, is subject to the convenience of the child. This decision, my lords.
ಬರೀ
He may
child
say, I don't want to come. Now, my lords, what I have seen is, these days 16 years child, they're so mature. They're so mature, they will themselves say, now ಓದ್ಲಿಕ್ಕಿದೆ, I will not come. Because I am told them.
ಅಲ್ಲ ಹೀಗೆ ಅಲ್ಲ ಹಾಗೆ ಬೇಡ. Respondent is petitioner is entitled to custody of the visitation right of the child during half of the vacations as per the schedules of the school or colleges where he is studying. The child shall
May I have one submission with kind permission, my lords? Am I afraid? Because some arrangement is peacefully going on. My only prayer is the arrangement present is going on, let them continue. They are now going on, my lords. Visitation and also.
ಅಂದ್ರೆ ಎಲ್ಲೂ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ವಿ. ಯಾವ್ದಾರ ಒಂದು ಕೋರ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದ್ರೆ we could have said that the same arrangement should continue.
Understand. I do understand. I only wish to guarantee the honorable court there will not be any dispute in this case, because I have seen him, I have spoken to him also along with the advocate, my lords. I feel there will not be any disturbance because only 1.5 years. Therefore, I don't want any stoppage of the visitation as it is going on now. That's the only.
As it is going on now ಅಂದ್ರೆ ಎಲ್ಲಿದೆ ಹೇಳಿ? ಇಲ್ಲ ಅಂದ್ರೆ ಇದ್ರಲ್ಲಿದೆ ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನಾರ ಒಪ್ಕೊಂಡಿದ್ದೆ ಅದ್ರ ಪ್ರಕಾರ ಅಂತ ಮಾಡೋಣ ಬೇಕಂತ.
Please.
R28 ಅಲ್ಲಿ ಎಲ್ಲೋ ಒಂದು ರಿಟರ್ನ್ ಇರಬೇಕಲ್ಲ.
ಹೌದು ಅದರಲ್ಲಿಗೆ R6 my lords.
ಒಂದು ತಿಂಗಳು 20 ದಿವಸ ನಾವು ಹತ್ರನೇ ಇರ್ಬೇಕಂದ್ರೆ ಮಗನ ಹತ್ರ ಇರಬೇಕಂತ
ಇಲ್ಲ ಅದು ಹಂಗೆ ಇದೆ. May I read that para 5 in R6.
R6
ಹೌದು R6.
ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತ ಅವ್ರಿಗೆ ಕೊಡೋದಂತ.
ಹೌದು R6 para 5 my lords. In the middle portion.
Second petitioner is intending to visit the child and wanted to take the temporary custody during school holidays and vacation. The first petitioner is agreed to give the custody of the child to the second petitioner.
That itself, that is actually continuing now. They are doing the same thing now. But of course, subject to the educational schedule of the child.
Temporary custody of the child during the school holidays.
Oh, that's going on, my lord. Same.
Petitioner appellant is entitled to temporary custody of the child Rohan during school holidays and vacation. During such time, the respondent shall hand over the custody of the child to the second petitioner. Second petitioner.
Appellant.
Petitioner appellant. ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಅದ್ರ ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂಡು ಪೂರ್ತಿ ಅವರೇ ಕೊಡೋ ಅಂತ ಹೇಳ್ಬಾರ್ದು. ಇಲ್ಲ ನೋಡಿ, ಡ್ಯೂರಿಂಗ್ ಟೆಂಪರರಿ ಕಸ್ಟಡಿ ಡ್ಯೂರಿಂಗ್ ಸ್ಕೂಲ್ ಹಾಲಿಡೇಸ್ ಅಂತಾನೂ ಇದೆ. ಇಲ್ಲ, ಸ್ಕೂಲ್ ಹಾಲಿಡೇಸ್ ಅವ್ರಿಗೆ ಇರೋದೇ ಇಲ್ಲ, ವೀಕೆಂಡ್ಗಳಂತೂ ಇರೋದಿಲ್ಲ ಅವ್ರಿಗೆ.
ಇದು ಅಷ್ಟೇ ಸ್ಕೂಲ್ ಹಾಲಿಡೇಸ್
ಅಲ್ಲ temporary custody during half of the
ಅಲ್ಲ ಅದು ದಯವಿಟ್ಟು ಬೇಡ, ಯಾಕಂತಂದ್ರೆ ಅಷ್ಟೇ ಸಾಕು. ಅವರು ಸಬ್ಜೆಕ್ಟ್ ಯುವರ್ ಲಾರ್ಡ್ಸ್ ಮೇಲೆ ಸಬ್ಜೆಕ್ಟ್ ದ ಕನ್ವೀನಿಯನ್ಸ್ ದ ಚೈಲ್ಡ್ ಆರ್ ದಿ
ಎಲ್ಲಿವರೆಗೂ
consent ಅಂತ
ಅವರಲ್ಲಿ
ಬರೀರಿ.
differences ಬರೋದಿಲ್ವೋ ಅಲ್ಲಿ
ಬೈ
ಚೆನ್ನಾಗೇ
ಕನ್ಸೆಂಟ್
ಇರುತ್ತೆ.
ಇದ್ರೊಳಗೆ ಬಂದಿಲ್ಲ. ಬೈ
Because he
ಕನ್ಸೆಂಟ್
is not there.
ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ kindly say by consent of both parties. By consent, this can be decided weekend and during holidays, so subject to the consent of both parties. Let it be consented. I do concede. I will concede. Let it be
ಅಲ್ಲ ಇದರಲ್ಲಿ
consented.
ಒಂದು ನೋಡಿ, you have suffered 2 orders. ಒಂದು you have subjected her to cruelty ಅಂತ
No, I'm
ಒಂದು
not on merits. I'm only saying, now my lords,
And
as a child is
secondly,
concerned,
you have
let there not
failed
be
and
any dispute.
neglected to maintain the child ಅಂತ 4,000 rupees maintenance award ಆಗಿದೆ. Why do you want any very unconditional order?
No, I don't want unconditional. If I am submitting that, let it be last para, my lords, subject to consent of both parties.
ಆಯ್ತು.
Then it ends.
ಹಂಗಂದ್ರೆ ಶಾಲ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಅಂತ ಬರೆಯಿರಿ. Petitioner is entitled to temporary custody of Ward Rohan during vacation, subject to consent of both the parties.
ಹೌದು, ಹಾಗೇನು ಸಮಸ್ಯೆನೇ ಆಗೋದಿಲ್ಲ. I concede to that extent.
No
Please.
orders to pass.
ಅಲ್ಲಿ ವೀಕೆಂಡ್ಸ್ ಅಂಡ್ ವೆಕೇಶನ್ ಅಂತ ಬಂತಲ್ಲ ಸ್ವಾಮಿ. ವೀಕೆಂಡ್ಸ್ ಅಂಡ್ ವೆಕೇಶನ್, ವೀಕೆಂಡ್ ಅಂಡ್ ವೆಕೇಶನ್.
ಅಲ್ಲಿ ವೆಕೇಶನ್ಸ್ ಅಂತ ಬಂತಲ್ಲ, ಅಂಡ್ ವೀಕೆಂಡ್ಸ್.
Please. Grateful.
ವೀಕ್ಲಿ ಹಾಲಿಡೇಸ್ ಅಂತ ಮಾಡ್ಕೊಂಡು.
Please.
Weekly holidays without disturbing his academic
ಹೌದು.
career. Academic
Please.
career.
That I personally guarantee, my lord, that will not
Yes,
happen
yes.
in
ಆಯ್ತು.
this case. Grateful.
ಹಾ. ಕರ್ಸಿ ರಾಜೇಶ್ವರ್ ಒಂದು ಫೋನ್ ಮಾಡಿ, ಬರ್ತಾರೆ. ಎಸ್ ಮಿಸ್ಟರ್ ರಾಜೇಶ್ವರ್, ಯು ಗಾಟ್ ಇಟ್.
Number 11.
ನಾನು ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡೆ ಅವಾಗ. ಕ್ಲಿಯರ್. Yes.
The matter where my lords have
Our-
appointed an amicus.
She had to argue, but she was waiting so far here. ನಿಮಗೆ ಅವ್ರ ಫೋನ್ ನಂಬರ್ ಕೇಳಿ ಎಲ್ಲಾರ ಇರ್ತಾರೇನೋ ಅಂತ. You had argued this.
I had argued the
She
matter.
had
My
to
lords
argue.
felt after going to the cross examination of the wife.
Correct. Feel here. ಮತ್ತೊಂದು ಯಾವ್ದು ಪಾಠ ಯಾವ್ದಿತ್ತು? ಎಲ್ಲ ಪಾಠ ಬೇರೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ? Cross examination in
Of the wife in the family court. I'm going through that, my lords felt that somebody is to be appointed as amicus to represent the side of the wife and she be heard in the matter. Yes, sir.
ಇದರಲ್ಲಿ what the trial court has said is one thing is that you have condoned the cruelty.
So let's
Second is that
point is, my lords, now reproachment is not possible. She is living in Chennai, I am living in Bangalore, and even after coming to know that I am a cancer patient, she says he's not eating properly, he has to take care of his health. So there's
now
no
he
love
is
left.
suffering from cancer.
Yes, my lords.
What kind of cancer?
Yes, I have produced it along with my petition before the Chennai High Court, my lord.
Chennai
Chennai Court, family,
ಇಲ್ಲಿ additional documents ಹಾಕಿ.
additional documents actually. That,
Section 9 petition.
Section 9 petition has been allowed. And my application to set aside was allowed, but became final because I did not pay the cost.
ಅದು ಬೇರೆ ಆಗಿದೆಯಾ?
One day delay.
For a day's delay.
ಅಲ್ಲ, ಮ್ಯಾರೇಜ್ ಇನ್ವಿಟೇಷನ್, ಫೋಟೋ ಕಾಪಿ, ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಎಕ್ಸೆಟ್ರಾ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಇಲ್ಲಿ ಏನು ಕಾಣ್ತಾ ಇಲ್ವಲ್ಲ? You say you have produced, ಇಲ್ಲಿ you have produced only that order. ಬಂದ್ಬಿಡಿ. Yes.
This is
ಇದು ಬೇರೆ. The other ground for rejection is that you had not pleaded this
Yes,
having
ma'am.
relationship with your niece.
Yes,
But
ma'am.
her pleading in the written statement cannot be taken into consideration to grant decree on that ground. That's what it is saying. But that allegation in the pleading, it carries more weight, Alva. She made allegations against him, saying that he has a relationship with his own niece.
No, she has not made an allegation as such. There is no allegation of incestuous relationship, your lordship. Her objection may kindly be seen.
But she suspects that, Alva. She suspects.
She just is stating about the behavior of the niece.
Paragraph, which paragraph is that? That is in para B and
Para B?
3B. 3B, no, however, after couple shifted to Bangalore, there was lot of change in behavior of the petitioner. At the instance of his sister's daughter, who is now age 24, and the couple and other family members, sister, purpose, we used to make her to sit on the lap, hours together, started to call his name.
However, after the couple shifted to Bangalore Jan 2008, there was a lot of change in the behavior of the petitioner. At the instance of his sister's daughter, who is now aged 24 years, when the couple and the other family members go out, the petitioner's sister purposely used to make that girl to sit on the petitioner's lap for hours together. That girl started to call the petitioner by his name, though he was her uncle, being elder to her. On one occasion, during one visit to the petitioner's sister's house, the said girl was hugging the petitioner in the bed in front of everyone in the hall, as she could not control herself, which was looking so odd that a family-oriented lady cannot tolerate it. The petitioner started avoiding the respondent while visiting his relatives as well as to visit his own sister. Even the petitioner's sister never restricted her daughter for reasons best known to her. The elder members of the family and the petitioner's sister just supported him because of monetary support, is what she states. And in her cross-examination at page 19 of her cross-examination.
But this allegation was not established.
It was not established.
What this also.
See,
She's
saying she's just speaking about the behavior of
a family member, close relative, his own sister's daughter.
No, in the
This
cross.
kind of allegation, what it implies, this allegation was made as if this is there was some, sexual, motive in that, as if this allegation is made. Even this is not proved.
In the cross-examination also, page 19 of her cross-examination,
PW1,
respondent.
The PW1 gave such suggestions were made in the cross-examination.
No, because that ground was never taken in his pleading as a ground for divorce.
No, not he is stating in the chief examination. In the cross-examination by way of suggestion, anything was
No.
suggested like that? There was some issue in Wokad hospital, etc.
In her cross-examination, a question was put to her.
Once, cross-examination, page number, go to
19.
just one. Page number 19.
19 of the cross-examination
Yes,
of the respondent.
you accused.
You have accused the petitioner in the year 2009, stating that he has made his niece to sit on his lap in an improper manner. I say that I cannot remember the year. I did not accuse the petitioner. I say that on that day, when we went to my sister-in-law's house, petitioner's niece sat on his lap in an improper manner. And hence I requested them not to behave in such a manner, since the said child was a grown-up girl. It is not correct to suggest that I have imagined that petitioner's niece sat on his lap in an improper manner. It is not correct to suggest that I accuse the petitioner's sister that she forced her daughter to sit on the lap of petitioner in such manner. I do not know whether my sister-in-law's daughter was aged 23 years in the year 2009. But I say that when I married the petitioner in the year 1993, sister's daughter was aged about 9 years. And she further says that it is true that there is age difference of 20 years.
So this was in the year 2014.
2014, when the girl was 23 years.
This
2009. The incident was in the year 2009. The girl was 23 years is what?
Correct.
Scum.
So at that subsequently consequences ಬಗ್ಗೆ ಹೇಳಿರ್ತಾರೆ ಏನಾಗುತ್ತೆ ಅಂತ. See. All.
Kindly see the
Girl was very
answer in page 20, my lords. Question and answer.
Oh, 20.
Your husband has always treated as sister's daughter as his daughter and not otherwise. Answer. I will answer this question in the argument. I have seen embarrassing situations.
In this case also, it appears in the cross examination, maintenance ಕೊಟ್ರೆ ನಾನು ಹೇಳ್ತೀನಿ ಅಂತ. Due to the court pressure, he is giving the amount. I am under stress since my husband is not coming to discussion. She refused to answer the questions also. ನೋಡಿ ಅದರಲ್ಲಿ, whether you are residing in Mumbai now, I cannot answer any question since I have got giddiness. Until salary certificate of my husband is produced, I cannot answer. ಇದು ಒಂಥರ arrogance court ಮುಂದೆನೆ. An email is shown to the witness, and when the advocate for petitioner asks the witness whether he has sent the said email, she answers that I do not want to discuss regarding the same, and immediately financial arrangements has to be made for the child, otherwise she will not discuss anything. She says she is not feeling well and hence she can't answer. It is not correct to say ದುಡ್ಡು ಕೊಟ್ರೆ I will become well ಅನ್ನೋ ತರ ಹೇಳ್ತಾರೆ.
Then kindly see the
It's not
last
correct to
question.
say that court has ordered for payment of 10,000 only. I say that court has ordered for payment of rent also along with the maintenance. The last one, whether you are aware that petitioner has lost 10 kg weight, it is not a valid question, and he has to eat and he has to take care of his health. I cannot eat. I am taking care of child and preparing food. I cannot answer any question since I have got giddiness. Until salary certificate is produced, I cannot answer. No, I cannot. It is not correct to suggest that petitioner has lost weight because of my harassment. What harassment? Be specific is the answer given by the respondent. ಅಲ್ಲಿ ಕೊನೆಗೆ observe ಮಾಡಿ continuously she gives answers in line about so many things, and she is not allowing the court to record the answers. Well, of course we have appointed.
She would have gone through a lot of stress, your lordship, and most of the commoners wouldn't be exposed to a court situation where they have to enter the witness box and face the cross examination.
What is that certificate of Dr. Sridhar? Sridhar is party.
Please.
I am not in a position. It is not correct to say that I am not in a position to understand the question and answer the question. No doctor has given me such opinion except Sridhar. Yes. And the page 15 observe witness continuously goes on speaking and not allowing the court to record the same, stating that she is under stress. See, the trial court has accepted all these things. It says that, of course, you can argue, we'll record your submission because she has not come despite service. Then again, that becomes the ground for the reversal or scheme. So we appointed. But though the trial court accepted that she is intemperate, etc., and this incident was cruelty, this incident making allegation, it says that he has condoned it subsequently living with her.
If para 30,
Subsequently living with, he lived with her after 2009.
para 33 of page 25 of the judgment,
Take one second. The chief examination evidence was laid twice on the concept.
It states as far as this allegations are concerned,
Yes, Tara?
the 33 LA, page 25.
Yes.
It cannot be said that the petitioner has not examined any other witness to corroborate his contention.
Para 20,
33 LA, page 25.
the petitioner has not
Examined any other witnesses to corroborate his contention only on the oral assertion of the petitioner. It cannot be said that the respondent had made an unseemly allegations against him, that he has a relationship with his niece.
but she
It
has
has
said
come
that-
to a finding that there is that she has not made any allegation of relationship as such. Only thing is, it is about the behavior of the niece.
the trial court. Yes.
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 The appellant has filed this petition under section 13(1) IA of Hindu Marriage Act, where he's made allegations of cruelty. And there are a few instances which he has listed out, saying that these all amount to cruelty. And it's my humble submission that none of the instances what has been alleged has been proved by the other side, by the petitioner. 1994, where his father was belittled and berated and offended by the respondent. And in his own cross-examination at page 13, he states that the respondent, that is the petitioner, has not ill-treated any of the members. And he admits that they have rarely visited them. Page 13 of the cross-examination, his cross-examination.
She has not ill-treated any member.
Ill.
It's page 30.
Page 13 of the cross-examination,
After marriage,
page 13.
it starts where? I mean,
Uh,
that statement particularly.
It's not correct to suggest that she ill-treated my family members.
It is not correct to suggest that.
In the middle it comes, till 35/2009, my parents were residing in Ranchi
Oh.
with some relatives. Not correct to suggest they were very rarely visited and there was no occasion for the respondent to ill-treat them. Volunteered that because of her behavior, they rarely visited. So he himself said that she has not ill-treated his family.
This compound question is asked. Is it compound question is not correct to suggest that they were rarely visited and there was no occasion for the respondent to ill-treat. That was a compound question. He says, he clarifies further. Her suggestion was that they were rarely visiting, therefore there was no occasion for them. He denies that.
He denies the ill-treatment also.
He
And
denies
even
rare
if it is, because rarely
Ah,
visited,
got that.
yes. And further, the second one is that she
That is
had,
not admission, that is denial.
and the incident also what he mentions is of the year 1994. After that also they have, it is admitted that they have lived together as a
Then
husband and
started living separately.
2009, he left,
2009.
he left the house. That is what they say. She says after 2 days of this said incident, he has left. They say the very next morning that he has left. 35/2009, there was an incident in the house where they had a quarrel. It is their case that they left the very next day. That is not been proved is what the family court has come to.
According to her admission, when he started to live separately.
After 2 days of 30/5/2009.
So that comes to 1/6 or 2/6. Within 2 days from 30th.
30th.
So this is this slapping incident was on 35 according.
35/2009.
Thereafter he has not lived together.
He has left the house after 2 days without informing her about his whereabouts,
This,
and she has approached the police after that.
The sisters, she seeing this niece and him in an obsessional manner. That was in.
Much earlier to that. She just, during the quarrel, she takes up this issue saying that since he was having a problem with the leg and he had gone for an X-ray to Wockard Hospital and he was returning, and it is through his sister that he has taken an appointment. So the issue of the earlier issue came up and they had a quarrel regarding that.
Yes.
The second instance is that she was blaming him for the misfortune of losing her child. So she had conceived in the year 1995, had a miscarriage, and again in 1997, she delivered a premature baby, and that passed away. So it's his case that she was blaming him and that she was being rude to him regarding that. And if your lordship sees, these are all incidents much prior to the said petition. The third incident is that she has not been in good terms with the mother-in-law. She's been rude to her. The mother-in-law had come down to have a surgery in Bombay. So during then that, because of her behavior, she had to leave early after undergoing the surgery. But if your lordship sees page 15, the cross-examination of the cross-examination of the petitioner, PW1.
What is said there?
In his first thing is in his evidence, he says that because of her, he got his mother and got her operated in Bombay. It was on her suggestion.
Yes.
Evidence is at page 4 of his examination in chief, para 8.
Yes.
Where he states, in 2007, I was transferred.
Yes.
Para 8
Yes, got it.
of chief examination. In 2007, I was transferred to Mumbai. During this time, my mother was lived in Ranchi, developed serious heart problems, and was diagnosed with major blockages in her arteries. While I was deciding whether to have her operated in Ranchi itself or in Pune, where my brother resided, the respondent requested me to have her treated in Mumbai. As a specialist heart hospital was located close to our residence. Accordingly, my mother was operated on in Mumbai and was moved in with us for post-operative rest. It's a chief examination. And further, it is her case that she has signed the surgery documents. She was with the mother-in-law. So that was asked in cross-examination, for which he answers at page 15.
Yes.
My mother stayed with me for a duration 3 to 4 days after surgery in our house. I don't know as to whether my wife signed several papers pertaining to surgery in the hospital, volunteered that only one document is signed by my wife when I had been to get medicine. Not correct to suggest that my wife also had gone to Ranchi along with my mother and stayed there for about 10 days. So his case of her being rude to the mother-in-law and not being there is not true, Your Lordship.
Yes, denied that. She went to
Yes.
Ranchi and Nagari.
And the fourth instance is that she was having this dominant and abusive behavior. And he has made allegations regarding her narcissistic tendencies, that she had a narcissistic compulsive disorder. So that whole paragraph itself was deleted. There is an amended petition. He has made the allegation and has deleted it.
Cleverly deleted ಅಂತ ಹೇಳಿದ್ದಾರೆ. Very good. Yes.
There are 2 documents which has been produced in support of that. 3 documents, exhibit P2, P3, the prescriptions, and P4 is the evaluation of the doctor. All of these have not.
These documents were admitted or
No, they were looked into. Only P5 and P6 were not looked into.
whether she had admitted?
No, she has not admitted at all. She has denied. Okay,
What is the use of that?
yes. And moreover,
Pleading a ಹೊರಟೋಗಿದ್ದಾನೆ. I'm just telling you. One is only prescription, P2. P3 is also prescription. P4 is during doctor's handwriting, it's very difficult to find. Style of functioning and hoping behavior during she is associated clinical symptoms manifested during stress. It is stress during stress.
after this, the child was taken in adoption. The dates may kindly be seen. And in the year
They were not able to manage themselves.
in
The adoption.
in 2008, she has executed a GPA in favor of her husband. And that has come in cross-examination.
2008.
8 ali.
By that time, petition was
14/1/2008 ali.
The petition was filed in which year? 2009.
2000.
2 months immediately after.
Oh.
July.
Page
Let us- Page
16,
of PW.
cross-examination, PW1 ಇದೆ.
Just. Yes.
Not correct to suggest that both of us stayed together for a duration of 2 years in Bangalore, volunteered that only 1.5 years. At the time of seeking adoption, I have not disclosed the disease of my wife to the institute from which the adoption was taken. True that Miss Rekha, younger sister of my wife, had given undertaking at the time of adoption in support of the adoption of being made. True that in the year 2008, dated 14/1/2008, volunteered that even my wife had also executed GPA in favor of me. It was agreed in the GPA that I had given power to my wife to manage the affair of the flat.
We are not.
No, just to say that her mental condition was fit and
Mental
fine.
health condition will not consider because even re-entry to his parents also, he has not examined anybody. He has not examined your sister or anybody.
Nobody.
And that slap.
Now, she had made certain allegations against him, saying that he was improperly, or himself and his niece were improperly.
Behavior was
behaving.
improper.
That is one thing. Secondly, he says that she was always abusive, intemperate, etc. That is found from the court records from cross-exam, the way she conducted in the cross-examination, her cross-examination. But
that-
that's not considering that mental health issue because trial court has said. Now the trial court says this was all condoned by subsequently living
No,
with her.
2007 in that they were together admittedly, they were,
2009, after 2009, they are not lived together.
yes.
2007, they were living together means it doesn't amount to condonation. There is an attempt of, patching up. Condonation, there should be unconditional, this thing. Anyway, even if we take it as condonation, but condonation, really because he was trying to adjust with her, with all such continuous.
These are natural wear and tear of the marriage is what my submission is, Your Lordship.
Too much possessiveness.
Yes, it happens in marriages like it is.
Yes.
There's no allegation for divorce as such.
ಅಭ್ಯರ್ಥ ಅಂತ ಹೇಳಿ ಜಜ್ಮೆಂಟ್.
ಹಾ?
ಅಭ್ಯರ್ಥ ಅಂತ ಹೇಳಿ ಒಂದು.
What is say for this judgment not applicable ಅಂತನ?
ಯಾವ್ದು?
ಅಲ್ಲ ಇದೆ miss. ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ. Yes. Any this only on the ground of divorce petition filed by the husband advocate on the ground of adultery. In the defense, averment made by the wife in the written statement alleging husband and his family members were lunatics are suffering from mental imbalance. ಅಲ್ಲಿ ಪಿಟಿಷನ್ ಅಮೆಂಡ್ ಮಾಡಿರ್ತಾರೆ ಅದನ್ನ ನೋಡು. In that petition, husband amending the petition seeking divorce on the ground of cruelty. That amounts to mental cruelty ಅಂತ ಬರುತ್ತೆ.
Here, my lords, in replication, I have said that this amounts to cruelty. Though I have not amended my petition, in the replication, I have made that statement.
That's all. Permission Anything else? Have you seen this judgment which he relied?
No, I just received it now.
ನಾವೇ ಹೇಳಿದ್ದು.
ಅದು not
In that
applicable.
case, the petition was amended. She had made allegations of lunacy, etc. against his family members. And he amended the petition to claim that such allegations amount to cruelty.
In this
Idರಲ್ಲಿ
case,
pleading
because I
ಇಲ್ಲ.
filed a rejoinder denying these allegations
filed a
and
rejoinder.
said this amounts to cruelty.
In the rejoinder has
In the rejoinder, I have said,
rejoinder have filed.
I have filed rejoinder.
Correct. In that, whether he said this amounts to cruelty?
There are two, my lords.
Additional objection ಅಂತ ಹಾಕಿದ್ರೆ.
No, my lords, it's a rejoinder filed in April 2010, my lords.
2010 or 17?
2010, my lords. April
Ah, yes,
2010.
yes. So there was another additional statement also. Para ಎಷ್ಟು?
There are two, my lords.
Para, yes. Allegations made in the objection. Please read which point you want to highlight.
My lords, the suggestion that the petitioner and his sister's family members support an imaginary relationship between the petitioner and his niece on account of monetary support that they derive from him is made in bad taste. This statement is made despite the respondent's personal knowledge of the monetary affluence of the petitioner's sister's family. It is respectfully submitted that the reckless and seemingly allegations made by the respondent is a facet of cruelty and that the petitioner has suffered at her hands throughout the marital relationship.
Made by the respondent is a facet of cruelty. Correct. But why the trial court did not notice this aspect of the notice? Because trial
There
court
is-
says that
Prayer is
There
not.
is no allegation as such, your lordship. She
This
just
is
says that
also
her
part-
behavior was improper. Nothing beyond that. She's not saying anything that her husband is having an affair with the niece, nothing of that sort, your
what
lordship.
is that indirectly it is said?
More than
What is that indirectly it is said? See, once it is said, it should be said.
objectionable manner.
If a suit for defamation is filed on this ground, whether it amounts to defamation or not.
The Honorable Trial Court in its judgment at page 11, my lords, para 13 refers to the rejoinder.
But.
But in the judgment, in the appreciation,
Says that you have not taken such contention
contention.
in the pleadings.
yes, ma'am.
But this rejoinder is also pleading.
Yes, ma'am.
Your rejoinder is as big as
Yes, ma'am.
more than your petition.
Yes.
1/3/2012. Devotion, sorry. You read rejoinder date ಎಷ್ಟು ಹೇಳಿದ್ರಲ್ಲ ನೀವು?
That's para 13, my lords. Page 11. But in para 39, the honorable trial court says, no,
So now you
no
say
grounds in the petition.
this judgment applies to you.
Please.
Para 4 of rejoinder, no?
Para 2 months.
April 2010.
Yes, ma'am.
You were referring to another deposition in DV Act case anta ಹೇಳಿದ್ರಲ್ಲ.
Yes.
This is the very deposition.
This case itself, no other case.
What do you say about this proof of this incident of she slapping him with
No, there's absolutely no evidence on that except for his pleading, your lordship.
she has denied that in the cross examination?
No question was put to her at all.
Then correct, that trial court says. Is that correct? Trial court says that you have not elicited in her cross examination. Correct, you are
Yes,
right.
how?
When you said, we remember that. Trial court says that this incident was not elicited in her cross examination. You went through the cross
And
examination.
not even in their evidence.
Their
Where
evidence.
is the evidence?
Evidence. Cross-examination, she was not counted with that.
In his chief examination has stated about this incident.
Yes, my lords, that's the basis of, my lords, kindly see.
PW1, because trial court, yes, trial court has said that this is not elicited in her cross examination.
Cross-examination.
It's para 11 of my chief examination.
No, this is countered by them,
She has denied it.
the cross examination.
In her objections.
Not objection, in the cross examination.
Cross-examination, she was not counted with the question.
Allah, in his cross examination, she has disputed this incident.
No, nothing about that as far as. There's no mention about that incident at all.
One nimsham, now, no, trial court says that this is not elicited in her cross examination.
Yes.
What about she cross examining him with reference to that? Now deposition, no. Parents are defense personnel, no?
Please,
Parents of both of them.
no.
Huh.
See, my father was working in a company in Ranchi. Mills.
Ranchi.
Yeah, her father was in defense.
Her father was in defense. ಅವ್ರು ನಿಮ್ಮ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಇದನ್ನ ಕೌಂಟರ್ ಮಾಡಿದಾರ ಅವರು?
Let's may come to page 16 of cross examination of PW1, my lords.
Page 16. Allegations made in para 10 of the cross examination, chief examination are false. Para 11 ಅಲ್ಲಿ ಇದೆ, ಇಲ್ಲಿದೆ. Not correct to suggest that the allegations made in para 11 of the chief examination affidavit are false.
And made by me to suit my case.
Had treatment in Mukad hospital. Prove that.
Will my wife advise me not to make the knees to sit on the legs?
Had
Not
taken
correct to
treatment
suggest
for
that the
hospital.
incident became a quarrel.
Not correct to say. Will my wife advised me not to make my niece to sit. Illi, oh, ನೀವೇ suggest ಮಾಡ್ತಾರೆ. She respond herself suggested.
Yes, ma'am.
She made this. 2 days later, no, not correct to suggest that
I left 2
this
days.
incident
Later.
became a quarrel, and 2 days later I left the house without information. So,
To resolve the cross examination of that incident. Para 11, suggestion given, such a thing did not happen. And I had no occasion to cross examine because she was not ready to answer the questions.
her chief examination,
Para 17,
is 17.
para 17.
Contents of paragraph 10 of the petition are totally false. 10 alla, 11 alla.
Then that is paragraph 10 of the petition.
Correct. 10 of the petition is not about this incident. 11 is about she assaulting you with this petitioner with footwear. Para 11 ಅಲ್ಲಿ ಬಂದಿದೆ ಅಲ್ವಾ ಅದು? Petition para 11.
Affidavit para 11, my lords. Para 10 is the, para 9 in the petition, amended petition.
9. 9 is about para 9. Okay. 10 is para 10 of the petition ಅಲ್ಲಿ ಹೇಳಿದೆ.
Yes,
So this is denial.
yes.
Cross examination ಅಲ್ಲಿ ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಕ್ಲೋಸ್ ದ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬಿಕಾಸ್ ನಾಟ್ ಪಾಸಿಬಲ್ ಟು ಫರ್ದರ್ ಕಂಟಿನ್ಯೂ ಅಂತ ಮಾಡಿದಾರ.
ಏನಿಲ್ಲ, it had gone for
ಫರ್ದರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಸ್ ಡೆಫರ್ಡ್ ಅಂತ. ಫರ್ದರ್ ಈಸ್
Their examination is
went-
deferred. So ಆಮೇಲೆ
talking about in the affidavit, I say that my daughter with me is not correct.
6/1/2015 is the last cross examination.
She has gone on saying that she's not ready to discuss, she's not ready to say. ಆದ್ರೆ ನೀವು ಅದನ್ನ ಸಜೆಷನ್ ಮಾಡ್ಬೇಕಿತ್ತು, ಮಾಡಿಲ್ಲ ನೀವು. ಇಲ್ಲಿದೆ, your husband has always treated as sister's daughter as his daughter
Yes.
and not otherwise. I'll answer to this question in the argument. I have seen, he has put that question. ಕೇಳಿದ್ದಾರೆ ಅವ್ರು, ಕೇಳಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರು. ಅಲ್ಲ ಅದಲ್ಲ, this incident of she's
Incident of
35, 2000 not
May. ಅದಕ್ಕೆ ಹೋಗಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ ನಮ್ಗೆ ಬಿಕಾಸ್ ಇಮೇಲ್ ತೋರಿಸಿದ್ವಿ. ಇಮೇಲ್ ತೋರಿಸಿದಾಗ she started saying I am not,
that email? Email ಅದು ಇದನ್ನ ಮಾಡ್ತಾರೆ. That is not proved as per.
that is 65B is not there, therefore it's not taken into consideration.
ಈಗ ಇನ್ನೊಂದ್ಸರಿ ಚಾನ್ಸ್ ಕೊಡೋದಕ್ಕೆ ಅಂತ ಕಳ್ಸೋದ ತಿರುಗಿ?
Lords, my submission, my lords, to is that, my lords, she has obtained a decree for restitution of conjugal rights. 2 years have also passed. There's no reconciliation. Even if my lord sends it back, my lords, nothing fruitful will happen, my lords.
You did not correct. ಅದೊಂದು, that is one more problem. She has secured that decree when that restitution.
2022, my lords, April, 9th April 2022. 12th April 2022.
4/2022.
Yes, my lords.
ಅಂದ್ರೆ ಈಗ 2 ವರ್ಷ.
2 ವರ್ಷ
1 ವರ್ಷ ಅಲ್ವಾ ಜುಡಿಷಿಯಲ್
ಒಂದು ವರ್ಷ.
ಸೆಪರೇಷನ್ ಗೆ?
ಅಷ್ಟೇ. If my lords considers my application for restoration of that petition, my lords, and the order made, that's also over, my lords.
When you filed the application and when order was passed?
That was again 12th April 2023.
12
April 2023.
2023.
Yes, my lords. And I had to make the payment
That
order before
restoration order is passed.
restoration order.
Ex parte decree set aside.
Yes, ma'am.
You were given 1 day time, huh?
No, I was given time, but I made the payment 1 day later.
You made the payment one day late. You
1,000
paid the
rupees.
amount.
I paid the amount, 1,000 rupees was the cost imposed. Instead of paying it on 27th April, I paid it on 28th May, 28th April. And the order was, if the payment is not made on 27/4, it will get dismissed automatically.
This petition for recalling gets
recalling.
dismissed. What this petitioner is doing?
She is now a chief executive officer in a NGO.
Petitioner, husband.
Husband is a NGO, in an NGO is the chief executive officer.
What she is doing?
I have said that she is doing real estate business, and my property which is there in Mumbai, she is collecting the rent.
She has stated in a statement that it has been equally shared by both. And right now she is residing in that house is what from the evidence we can make out.
So that means
She's
not
residing.
sharing the rent.
She's residing.
enjoying
Earlier
the
till 2000,
entire property.
2010 or 11, she was sharing the rent is what she has stated. Later on, she moved in with her daughter and she's residing there in that apartment.
So after this, she has also not moved any petition for this
I am not.
restitution of conjugal rights. It seems. Are you aware whether she has filed any
No
execution
execution
case?
petition notice is received by me. I have not received any execution petition notice.
Hmm. And see here, she is not appear in despite.
My lords may request the amicus, because the email IDs are there. She could establish communication and find out what is her stand as of today.
Probably, ಅವ್ರಿಗೆ ತೊಂದ್ರೆ we appointed in another case an amicus curiae. She sought her relief. ಅವರು ಹೇಗಿರ್ತಾರೆ? What is it? What brother is suggesting is that since you have failed to appear before the court has appointed me as amicus curiae. If you want to give any instructions,
And I can,
You can share your
That
number
email.
and then.
yes,
you
Do you
call
make
me
an
over the
effort?
phone, that's, I can effectively argue the case in person.
let's see.
What she does, we'll see.
In case if she replies well and good, if there is email ID, I can just.
ಇಲ್ಲಿ ಅಂದ್ರೆ that was not held.
If there
that
is
was
no-
held not proved because
Mail ID was
the mail ID ಅದ್ರಲ್ಲಿ ಇದೆ. Can make an effort, you can make it. Otherwise, we can proceed to
Yes,
pass
yes.
judgment.
Yes, your lordship.
Mr. Rajeshwari, we can
Please,
proceed. Because.
She may not respond.
Hmm?
She may not respond because court notice ಗೆ respond ಮಾಡಿದ್ರು.
Before the court only, she was not
Yes,
faithful.
exactly.
We do not know because in another case, we appointed that amicus curiae sought her relief.
Not
Discharge.
answer ಕಳಿಸಿದ್ರೆ
Oh.
I'll not answer and ನಿಮ್ಗೆ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ?
ಅದೇ.
Heard for that, reserved.
great.
And heard for the, heard Shri so and so and Srimati so and so amicus curiae for that judgment reserved. ಹಾಗಾದ್ರೆ we'll list it on some other day and dictate in the open court.
Please,
only.
yes, please.
Because now after hearing her again, we have to.
Yes,
I mean,
I understand.
structure our this thing. Monday ನಾವು ಇದ್ರ ದಿವಸ ಬೆಳಗಾವ್ ಹೋಗೋದು ಆಯ್ತು ಮಂಡೇನೆ ಹಾಕಿ ನೋಡ ಫಾರ್ ಫರ್ದರ್ ಅವತ್ತು ಬೆಟರ್ ಟು ಹ್ಯಾವ್ ಅಂದ್ರೆ ಇಲ್ಲಾಂದ್ರೆ ಸಂಡೇನೆ ಕೊಟ್ಟಿರ್ಬೇಕು ಫೈಲ್ ನಮ್ಗೆ ಅಷ್ಟೇ ಇವನ್ ಇಫ್ ಇಟ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಹೌ ಟು ಗಿವ್ ಇಟ್ ಟು ಮೀ ಮಂಡೇ ಇಲ್ಲಾಂದ್ರೆ ಡೇಟ್ ನೋಡ್ಕೊಂಡು ಕೊಡೋಣ ಯಾಕಂದ್ರೆ ನಮ್ದು ಯಾವ್ದು
Please.
ಪ್ರೋಗ್ರಾಮ್ ಇದೆ
Understand,
ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಮಧ್ಯಾಹ್ನ ಅಲ್ಲಿ ಡೇಟ್ ಮೆನ್ಷನ್ ಮಾಡೋಣ
please.
ಲೈಟ್ ಎಷ್ಟೊತ್ತಿಗಿದಾವೆ ನೋಡ್ಕೊಂಡು ಮಾಡೋಣ ಟ್ಯೂಸ್ಡೇ
Great.
ಇದನ್ನ ಒಂದು ಕೆಲಸ ಮಾಡಿ ರಿಸರ್ವ್ ಬೇಡ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್
For final.
We'll, no, no, we'll record our appreciation during the course of the day. She does all the time.
Yes.
For final hearing, seal number 15 adjourned, seal number 16. Rajeshwari M. Venkatesh R. Bhagat. Rajeshwari M. Venkatesh R. Bhagat.
Yes.
Yes, ma'am, yes. For the appellant, please.
60. Still serial number?
16.
16.
15, 15
15.
adjourned. 16.
This is of naming only the permanent alimony, madam, please.
Yes.
Please. The petitioner has filed a petition challenging the order passed by the family court madam, upon the miscellaneous petition. She has filed 25 application under HM Act, please, claiming 50 lakhs as a permanent alimony. 50 lakhs. The marriage of the parties took place in the year 1995. The date of marriage is 11/6/1995. And meantime, the respondent filed a petition for divorce. Of course, that is of just a brief facts of the background, madam, please.
Yes.
So MC 334.
Marriage was on which date?
11/6/1995,
11/6/1995 is the marriage.
date of marriage.
Hmm.
And the respondent husband files a petition for divorce in MC 334/1998.
See 334 of 1998.
98. And the said petition was allowed. That is a divorce.
What
petition.
ground?
On the ground of reality, madam, please.
Under section 13(1),
1A, please.
1A.
1A.
That was allowed on
That was allowed on 16.
which came to be decreed dissolving the marriage and the hereditary. All right. Against that, MFA was filed.
As against the MF, that was allowed on 8th August 2001, please.
8/10/2001.
8/10/2001.
8/8/2001. 8/8/2001.
As against which the wife, that is a petitioner, filed a MFA in 4565 of 2001.
MFA 45. 4565 of 2001.
Wherein during the
2001, what is that allowed?
ಅಲ್ಲ petition divorce
Okay.
decree was granted. ಅದನ್ನ ಅದೇ ವರ್ಷ ಚಾಲೆಂಜ್ 2000.
It is a decree.
8/8/2001 MC number 334 of 98 was allowed.
Allowed, please.
Okay.
MFA 4565 of 2001.
Was filed by the petitioner wife.
And it was settled by joint memo, no?
It was settled by joint memo
Live together.
for living together on 1/7/2006.
So 1/7/2006.
And meantime,
For reunion.
please, madam.
For reunion.
For reunion. MFA came to be allowed on 33/2012.
33.
2012.
MFA revived.
Revived. And the divorce petition was upheld.
As granted.
Divorce was granted, please.
8.
30/3/2012.
Divorce was granted ಅಂದ್ರೆ ನಿಮ್ಮ MFA dismiss ಆಯ್ತಾ?
ಹೌದು, order. In view of the joint memo, the MFA was dismissed by granting, upholding the divorce petition, please.
30th
30/3/2012.
Yes. Divorce decree confirmed.
Yes.
Yes.
And there were too many petitions from maintenance, my lord, which was not, because of the rejoining and again for the separation, it was not maintainable. Wherein the petitioner filed a miscellaneous petition in the year 2015, please.
There are no children out of the marriage?
There was a child which was born, girl child which was born on 5/3/1996.
5/3/1996.
5/3/1996. Who is now aged about 28 years.
She is with
She is with the mother, that is a petitioner hearing, please.
Yes.
And in view of the divorce granted by this court, the petitioner has approached the family court for seeking the permanent confirm the order of the trial court, please.
Now the trial court.
Trial court has granted only the ink page, may not please.
Petition respondent is directed to pay lump sum of 6,50,000 to the petitioner and daughter, permanent alimony.
So 3 lakhs to the daughter and 3 lakhs to the wife. 3 lakhs to the wife and 3,50,000 to the daughter.
You are only quantum here.
Only with respect to the quantum.
What is the observation regarding the quantum? Para
Quantum-
28 onwards.
This one?
Para 28 onwards.
Yes.
Reasoning regarding quantum.
Yes, only regarding the
Read
quantum.
Yes, please read that. Sometime.
And with respect to the
The claim of
qualification-
petitioner for lump sum permanent alimony of 50 lakhs is not only exorbitant but also baseless. And beyond the reach of the respondent, who is earning only a sum of rupees 46,025 per month by working as a teacher in the high school.
Thus, the claim of the petitioner for grant of permanent alimony rupees 50 lakhs relying on the decision of apex court in the case of Ushri versus Srinivas is not only unreasonable, but it also shows the greed of the petitioner. Admittedly, the petitioner has done TCH after PUC, and the husband of the petitioner is only a high school teacher and getting salary of rupees 46,000 per month. Being wife of the high school teacher, the petitioner cannot expect permanent alimony of 50 lakhs as awarded by the apex court in the case of Ushri versus Srinivas, wherein the party in this said case claimed to have earned name and fame in the world of music and has been performing concert in various parts of India and abroad. Thus, taking into consideration the necessity of leading a decent life and also keeping in mind the status and social strata of family of the petitioner and the respondent and also need of the education expenses, the marriage expenses of the daughter Nischala, I held is just and proper to award a sum of rupees 1 lakh towards education expenses, rupees 1,50,000 towards marriage expenses of the daughter, and rupees 1 lakh towards maintenance of daughter till she gets married or gets employment. After education and reduced maintenance to the petitioner on account of her conduct at the sum of rupees 3 lakhs. Thus, it is held that the petitioner is in all entitled for rupees 6,50,000 towards permanent alimony.
What is that conduct it is observed?
No, because since she has filed a complaint as against the respondent and the family members for dowry harassment when she has rejoined the husband, that was the only conduct, nothing else. And in page number 12, para 20 of the impugned order, please.
Already granted daughter, already in criminal miscellaneous, this maintenance was awarded.
Only for 3,000 rupees until she attained majority.
Para 20.
Para 20. In this connection, I would like to appreciate the cross-examination of PW1, wherein she has admitted that her education qualification is SSLC and TCH. And even prior to her marriage, she completed a TCH and worked as a teacher for 3 to 4 years. After divorce, she worked as a teacher for a month in a school situated at Jalali. Further stated that as the said school is far from the place of residence, therefore she did not continue to work in the said school. Further stated that she did not apply in any school for the post of teacher. She further admits that she is 46 years old, though she denied that she has got a good health and further stated that she is having a wheezing problem and she cannot work. Further admitted she has not produced any medical certificate to show that she is suffering from ill health and she cannot do any job, and she further deposed in her cross-examination that she has no intention to do any job and she has no experience to do job. It is suggested in her cross-examination that though she has got education qualification and also good health, why she is not working, doing any job. PW1 took time to think and stated that she has filed this petition to make a way for her livelihood. It's not the admission of PW1. So it is, she has deposed before the court that she is not working, Milord, please.
Exhibit P3 and P7, what is this? Exhibit P4. P4 is certified copy.
P3, the order of the MFA.
P4.
P4 is also a order of in the
It's
MFA.
after this order of this court. MFA.
That they filed joint memo for rejoining, Milord.
Left side upper the participating. No, it is not on joint memo, it is heard both sides on the whether finding of the court will have to be reversed. Page 9. Between the matter between the parties and respondent was willing to take the appellant. Matter regarding the appellant permitted to go and stay. But to the extent of lodging the complaint before the Vasanagiri police. But without doing that. Respondent entered into a compromise petition instead of saving the family, she has harassed the resident. No, it was allowed on merits, sorry, dismissed on merits.
Yes,
The judgment copy is here. After suffering a finding that you have subjected your spouse to cruelty, whether you are entitled to that much of this thing.
She has also attempted for rejoining, Milord, sincerely, because she is
No,
also
the
not.
court has observed, if there was any non-cooperation on his part, you could have come before the court. Harassment of the observer. You have not challenged that. 2006 joint memo, both parties have arrived at a conclusion to end the dispute and live together and to take back appellant today itself and live together. Appellant has agreed to live. So appeal is disposed of accordingly. 2016 this order was passed in 2011. This exhibit P6.
P6
was
is-
in 2012. P6.
P6,
miscellaneous.
wherein the court has ordered maintenance only 3,000 for the daughter, Milord, not for the wife. That is the reason she has filed RPFC before this. honorable court.
Partition suit.
Partition suit is pending, Milord.
Out of 1/3, 160 is granted.
Yes,
You are
Milord,
not-
that is under
Second
pending for consideration, please, in RFA. RFA is pending.
Salary ಕೊಡ್ತಿಲ್ಲ, salary 90,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ salary.
Please, Milord.
There also you filed RPFC and you failed them.
No, I had filed CME 67, wherein the court granted
No,
only
against that order you filed RPFC.
RPFC. Wherein in the present RPFC, liberty was given to me to file a necessary petition, Milord. That is the reason I have filed the
ಅಲ್ಲ, you
present.
only filed exhibit P7, you filed.
Yes, I had filed.
ಅದ್ರಲ್ಲಿ ಏನಾಯ್ತು?
Adnali, they gave liberty because meantime that day, since since the divorce was granted, I had taken permission to file permanent alimony, separate application.
Within a period of 3 months. Oh, because of this liberty you filed this.
Yes, yes, please.
So only this litigation is generated because of this
Liberty given by
judgment
this,
in
please.
RPFC number 43 of 2011.
Yes, Milord, please.
ಆಗಿದೆ, we have not seen, we'll continue in the afternoon.
Please, please.
ಅಲ್ಲ ಈಗ, ನಾನು ಈಗ ಇಲ್ಲಿ ಹಾಕಿದ್ರಲ್ವಾ ಇಲ್ಲಿ.
Assessment liabilities have been filed by both the parties.
Salary slip.
Please.
ಹಾಕಿದ್ದಾರೆ, ಸ್ಯಾಲರಿ ಸ್ಲಿಪ್ ಇಲ್ಲ,
Salary slip ಕೊಟ್ಟಿದ್ದೀರಾ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
Trial court ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ, ಇಲ್ಲಿ ಹಾಕಿ.
ಹಾಕಿದ್ರಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ಎಕ್ಸಿಬಿಟ್ ಸ್ಯಾಲರಿ ಸ್ಲಿಪ್ ಅಂತ ನೋಡಿದ್ವಿ ನಾವು P series ಅಲ್ಲೇ.
ಎಲ್ಲ ಅವಾಗ 46
He's already
ಕೊಟ್ಟಿದ್ದೀರಾ? 90
retired now.
ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಅವ್ರು ರಿಟೈರ್ಡ್ ಆಗಿದ್ದಾರೆ.
ಇದ್ದಾರೆ.
ಮತ್ತೆ benefits ಎಲ್ಲ retired benefits ಎಲ್ಲ
In the afternoon, we'll continue in the
salary 90,000.
ಇಲ್ಲ.
ಯಾವ್ದೋ ಒಂದು ಕೇಸ್ ಯಾವತ್ತು ಹಾಕೊಂಡ ಟ್ಯೂಸ್ಡೇ ಅಂತ ರಾಜೇಶ್ವರಿ and ಇನ್ನೊಬ್ರದಲ್ಲ. Yes.
Serial number 51.
Yes, 51.
23rd, please.
Pardon?
23rd.
23rd. You are for respondent.
I am for respondent. I am for respondent.
As requested. List on 20.
23rd.
23/7.
Yeah.
23rd July.
Pastor matters. Till number 1, Sangamesh Patil. Prashant Riya.
Copies are served.
Copy-
For
copy,
petitioner,
sir.
copy served.
Served, my lord. He has informed me.
The DI
Prashant,
There is a
There is
Prashant.
an acknowledgement, you have to produce it. ಬೆಳಿಗ್ಗೆನೇ ಇರ್ಲಿಲ್ಲ.
Sir ಮಾಡಿ.
Like, you should produce the acknowledgement, otherwise there is a preemptive order.
Within 5 days. 26.
ಅವ್ರೇ ಇಲ್ಲ, ಏನಾರ.
he has informed me, my lord.
He has
Yes,
informed.
yes, my lord.
Then all
Copies, my lord. Pray for time for objections, my lord.
ಹೇಳಕ್ಕ. All right.
We want to file objections.
ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅವ್ರದೇ ಸಬ್ಮಿಷನ್ ಅಂತ ತಗೊಳ್ತೀವಿ ಅಷ್ಟೇ. As informed.
You can produce that acknowledgement, no?
Submits that copies are served on him. Office subsection should comply. ಈಗ ಏನಾಗ್ಬೇಕಿದ್ರಲ್ಲಿ ಡಿಲೇ 1291.
Objections is. We will file the
Yes, sir.
objections. 10 days time.
2 weeks.
File
As
objections.
requested to file counter to IA 1 of, 2 weeks time, there's
Yes.
10 days time is granted to file counter to IA 1 of 16. This from
16/7. Till number 2, KP Bhuvan, KV Sadashivaya.
It was passed over. Oh, password ಕೇಳಿದ್ರು. Non filing of memo for having served the copy and the appellant. Copy serve ಮಾಡಿದಾರ ನಿಮ್ಮ ಮೇಲೆ?
No, my lord, regarding the regarding
Of calculation copy. Copy of memo of calculation is not served on them.
No, my lords, we are not, even my lords, my learned friend should only assist me, my lords, with regard to the maintenance amount, if any arrears are there.
ಇನ್ನೂ ಒಂದು ಹಾಕಿದಾರಲ್ಲ memo of calculation. Copy of what? ಅದನ್ನು ಬರೆಯೋದಿಲ್ಲ ಅವರು.
copy of memo of calculation.
That is second one.
Yes, you represent
The
respondent.
respondent, my lords.
You should serve the copy and them, no?
I'll take instructions to that.
2018 matter. ಇಲ್ಲಿ ನಿಮ್ಮ ಹತ್ರ you have filed a memo of calculation.
ಎಲ್ಲ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ, ಹಂಗಾಗಿ my lords,
ಇಲ್ಲ, ನಿಮ್ಮ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ಲ.
please.
ಹಾಗಾದ್ರೆ ನಾವು ಅದನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡಲ್ವಾ?
With regard to arrears of maintenance, if any, my lord, if they,
What is that memo of calculation arrears for you?
12/6.
See, 1/6. Both persons looked at one another. Parties are trying for settlement. Oh, ಇದು ಅದಲ್ಲ.
ಇದು
Party shall appear ಅಂತ ಮಾಡಿದ್ವಿ ಆ ಕೇಸ್ ಇದು.
ಹೌದು. ಇದರಲ್ಲಿ ಪಾರ್ಟಿ ನಮ್ಮ ಪಾರ್ಟಿ ಐ ಆಮ್ ನಾಟ್ ಟ್ರೇಸಿಂಗ್ ಹರ್ ಮೈ ಲಾರ್ಡ್ where she has.
Then how did you submit that the parties are trying for settlement?
No, according.
Find out the genuineness of that, we directed the parties to be present.
In CM is awarded 5,000, my lord. As on today, they are,
That your party is also not turning up.
no, their party is coming.
The parties have not turned up. Thus it is clear that the settlement of proposed, sorry, the submission that the parties are trying for settlement. Has no basis. Please for this matter is cleared.
Very clear.
I'll say finally.
Final disposal.
Time is granted to comply the office objection. Failing which the memo of calculation shall stand dismissed. Okay. This is the final hearing ಬರ್ಬೇಕು.
ಹೌದು sir, final hearing is.
This for final hearing on. So 10 days. 10 days.
10/3.
ಅದು ಯಾವತ್ತು ರೀಚ್
10/7.
ಆಗಿರುತ್ತೆ, ಯಾವತ್ತು ಮಾಡಿರೋದಿಲ್ಲ.
10-7.
Please, take.
10-7.
Yes.
For final hearing, Bill number 16.
What is presence for bail? ಅಲ್ಲ, ಇನ್ನೊಂದು ಯಾವ್ದೋ ಇದೇನಾ? Assets and liability statement second set file ಮಾಡಿಲ್ಲ.
ಇಲ್ಲಿದೆ ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡ್ತೇನೆ ಪ್ಲೀಸ್ ವಿತ್
Same copy, no?
ಸೇಮ್ ಕಾಪಿ ಸೇಮ್ ಕಾಪಿ.
Then I consider that next submit, sir. The- Second set of statement of assets and liabilities, which is submitted on
4/2/2020.
14/2/2023. And what is the age of the child now?
She is now 28 years.
21. What she is doing?
She's engineer.
She has completed her education.
Yes, she has
Software
completed.
engineer,
She's working.
having job also. We're staying with mother,
But not yet married.
not at.
She is not married.
Correct. But he has remarried?
No.
He has not married. But at least daughter's marriage expense are not 6 lakhs rupees.
Allah, he ruined his life. Marriage is of the year 1995.
Your marriage ಬಿಟ್ಬಿಡಿ now.
Allah, 96 ನಲ್ಲಿ all the courts in 11 courts it was held. His life as well. Father died because of the complaint lodged.
You are not concerned about her maintenance.
Yes.
What about?
Daughter is earning more than 4 times than me. 1 lakh, she is earning very well. Took his side.
Yes, obligation ಏನು?
ಅದು ತನ್ನ ಗಿಫ್ಟ್ ಕೊಡೋದು ಬೇರೆ. ನಾ ಮೇಂಟೆನೆನ್ಸ್ ಫುಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ. 3,000 rupees per month ಥ್ರೋಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ 2007ರಿಂದ. Till she attained the age of majority.
ರಿಟೈರ್ಡ್ ಬೆನಿಫಿಟ್ಸ್ ಎಷ್ಟು ಬಂತು?
30 ರಿಟೈರ್ ಬೆನಿಫಿಟ್ 11 ಲಕ್ಷ ರೂಪಾಯಿ ಗ್ರಾಚ್ಯುಟಿ. ಅದ್ರ ತಂದಿಲ್ಲ. ಇದು 11 ಲಕ್ಷ ಗ್ರಾಚ್ಯುಟಿ, 9,000 ಕಮ್ಯುಟೇಷನ್ ಪೆನ್ಷನ್, ಒಟ್ಟು 20 ಲಕ್ಷ ಚಿಲ್ಲರೆ ಸಿಕ್ತು.
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿದ್ರು?
ಅಷ್ಟೇ ಟೀಚರ್. ಮತ್ತೆ ಈಗ ಪೆನ್ಷನ್ ಸಿಗ್ತಾ ಇರೋದು 21,914.
Have you submitted the records?
Not
Have you submitted this, a pension settlement?
ಪೆನ್ಷನ್ ಇದೆ ಪೆನ್ಷನ್.
No, they will give a document, pension settlement ಅಂತ ಹೇಳಿ.
ಅದೇ ಇಲ್ಲಿ ಪೆನ್ಷನ್
PF and etc. whatever they have received back ಅದೆಲ್ಲ ಬರುತ್ತಲ್ಲ.
ಓಕೆ. ಇದು ಏನಾಯ್ತಂದ್ರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅವ್ರ ಸರ್ವಿಸ್ ನಲ್ಲಿ ಇದ್ರು ಅಸೆಟ್ಸ್ ಅಂಡ್ ಲಯಬಿಲಿಟೀಸ್ ಹಾಕ್ಬೇಕಾದ್ರೆ. ಆಫ್ಟರ್ ದಟ್ ಆಫ್ಟರ್ 20 days.
Correct. Now when this judgment was passed, he was still in service or this is in 2015?
ಹೌದು, ಈ ಮೊನ್ನೆ ರಿಟೈರ್ ಆದ್ರು.
Retire
2022.
2020.
22. Yes, madam. Date of appointment 70, retirement 31/8/2022.
31/8.
2022.
How long he had served? What was his?
He was 28 years, 24 months. I am just pass on the.
28 years, 4 months.
And his now pension is total pension is 32,870.
That is monthly pension.
Yes, ma'am. Monthly. Yes, madam. Yes.
They get some terminal benefits.
That's 21 lakhs he got.
21.
21 lakhs totally. ಇಲ್ಲಿ ಈಗ ಫೋನ್ ನಲ್ಲಿ ಟೆಲಿಫೋನಿಕಲಿ ಕೇಳಿದೆ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. He has to produce. He cannot hide it. Yes.
But whether he was interacting with the daughter at any time earlier?
ಕೊಡ್ತಾ ಇಲ್ಲ.
ಹೋಗ್ತಾ ಇಲ್ಲ ಅಥವಾ you?
I will tell you, my lord, in 2001, I saw a letter of her. She was small at that time. Wrote to the father. Beautiful handwriting. It was a senior office case. Then I took the matter. I saw that handwriting. Divorce was granted. She filed a MFA before this honorable court. By seeing that handwriting, Justice Dattu was holding the bench. Then I told my client, go try for another reunion. Reunion was tried. Immediately after, within 6 months, lodged a complaint against all. All were arrested. Father died. And based on that, on the decree was, MFA was dismissed, decree was granted. This on record, I produced all those things. This is the thing. Then that criminal proceedings were quashed. 11 cases have been filed throughout. Everywhere, the conduct of the
Correct,
wife has
that,
been.
that is the conduct of the mother. We are asking, what about the daughter?
I paid till she attained the age of majority, I paid.
You have paid only maintenance.
Yes.
Education expenses ಏನಾದ್ರು
Yeah,
ಕೊಟ್ಟಿದ್ದೀರಾ?
including that, it is covered here and also 3,000 per month I used to pay.
3,000, have you paid any amount?
Yes, madam, under this order it is paid. Yes, madam.
Where did she study engineering?
No, I am not having.
ಮತ್ತೆ ಅವ್ರ ತಂದೆಯಾಗ ಅಷ್ಟು ಗೊತ್ತಿಲ್ಲ ಎಲ್ಲಿ
Have you
ನೋಡಿದ್ವಿ
filed
What about-
application for custody of the child?
During,
No, madam.
right, dispute maybe between husband and wife,
Yes, madam.
but there should be some finer emotions or
Yes,
something towards daughter that is not done so far. At least to redeem that or he, I mean,
ಮದುವೆಗೆ
this
ಒಂದಿಷ್ಟು ಕೊಡ್ತೀನಿ,
it
voluntary
prima
ಆಗಿ.
facie it shows that it's 6 lakhs. He
Madam,
seems to
6
be-
lakhs paid in when, my lords? That day it's value, if it's doubled now, that's value. And
Sorry.
she is having site, everything she purchased from it and telling my daughter is given, 2 sites she is having. Petitioner is having 2 sites, appellant is having 2 sites.
No, this is given not only for her. The judgment says that it is granted for marriage expenses.
Yes, madam.
I know, just and proper to award page number 19 of the
Yes, yes,
judgment.
madam. I saw that.
Rupees 1 lakh towards the educational
Yes,
expenses.
madam.
1,50,000 towards the marriage expenses.
Yes, madam.
Of the daughter. And 1 lakh towards the maintenance of the daughter till
Yes.
she gets married or gets employment.
Yes, madam.
Now, when the daughter was employed,
Maybe 5 years.
ನಿಮಗೆ ಏನು ಗೊತ್ತೇ ಇರೋದಿಲ್ಲ.
ನನ್ಗೆ ಏನು
because they are
ಕೊಟ್ಟೇ ಇಲ್ಲ ಅಲ್ಲ, ನನ್ಗೆ ಏನು ಕೊಟ್ಟೆ ವಿಸಿಟೇಷನ್ ರೈಟ್ ಇಲ್ಲ.
That said, you didn't seek visitation rights. You didn't seek the custody of the
ಅಲ್ಲ,
daughter.
ಹೋದಾಗ ಎಲ್ಲ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ, ಏನ್ ಮಾಡ್ತಾರೆ ವಿಸಿಟೇಷನ್?
ಕೇಳ್ಬೇಕು ಅಲ್ಲಲ್ಲ, ಅವ್ರ ಹತ್ರ ಹೋಗೋದಲ್ಲ. Right. Now, when she got employment,
I think 3 years back.
It has been suppressed in her affidavit. She should have been told she is with me, her salary is this much because she is the dependent. Nothing has been told.
defendant, ಇಲ್ಲ.
Yeah. With mother,
He
she is
is-
there.
She was, ಯಾವಾಗ just to arrive at just,
She started joining ಯಾವಾಗ?
ಅವ್ರು ಯಾವಾಗ employment ಗೆ ಸೇರಿದ್ರು ಅಂತ ಅಷ್ಟೇ ಹೇಳಂತ ಹೇಳ್ರಿ.
4 years back and 4 years.
ಅಂದ್ರೆ this 4 years back ಅಂದ್ರೆ 2000,
2020.
2020.
19 ಇಲ್ಲ 20.
What is the age of the daughter now?
Now she is
21 years ಅಂತ ಹೇಳಿ.
28 years.
28 years.
She was born in 1996.
ಮದುವೆ ಆಗಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಮದ್ವೆ ಆಗಿಲ್ಲ.
Something for that.
28 ವರ್ಷ ಆದ್ರೂ ನಿಮ್ ಮಗಳಿಗೆ ಮದುವೆ ಆಗಕ್ಕೆ ಆಗೋದಿಲ್ಲ.
ನಮ್ ಜೊತೆ ಇದ್ರೆ ನಾನ್ ಹಾಕಿ ಸ್ಕೂಲಿಂದ ತಕೊಂಡೋಗಿ ಬೇರೆ ಸ್ಕೂಲ್ ಹಾಕಿದ್ರು. ಐ ಎಮ್ ಎ ಟೀಚರ್, ಐ ನೋ ವೆರಿ ವೆಲ್ ದ ವೆಲ್ಫೇರ್ ಆಫ್ ದ ಚೈಲ್ಡ್. ಬೇಡ ಅಂತ ಹೇಳಿ ಎತ್ಕೊಂಡು ಹೋದ್ರು ಬೇರೆ ಕಡೆಗೆ.
ಅಲ್ಲ ಈಗ ನೀವು the wife's
ಅಲ್ಲ, ಬಿಕಾಸ್ ಆಫ್ ವೈಫ್ ಡಾಟರ್ ಸಫರ್ಡ್. ವಾಟ್ ಐ ಆಮ್ ಟೆಲಿಂಗ್, ಬಿಕಾಸ್ ಆಫ್ ವೈಫ್
ಕರೆಕ್ಟ್,
ಡಾಟರ್
ಅದಕ್ಕೆ
ಸಫರ್ಡ್.
ನೀವಾದ್ರೂ ಈಗ ಡಾಟರ್ಸ್ ಯು ಪಾಸ್ ಇಟ್, ನೌ ಶಿ ಇಸ್ ಮೇಜರ್, ಪಾಸ್ ಇಟ್ ಟು ಹರ್ ಅಕೌಂಟ್, ಡೋಂಟ್ ಗಿವ್ ಇಟ್ ಟು ದ ಮದರ್.
You make a condition that it should be used for her marriage.
I will leave it to your lordship.
Fix ಮಾಡಿ.
ಅಲ್ಲ, ನಂಗೆ ಮತ್ತೆ ಬೇರೆ ಏನು ಇನ್ಕಮ್ ಇಲ್ಲ. 30-20 ಕಮ್ಯುಟೇಷನ್
Retired benefit.
ಆ?
Retired
21 ಲಕ್ಷ ರೂಪಾಯಿ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಡಾಕ್ಯುಮೆಂಟ್.
ಈಗ ಡಾಟರ್ಗೆ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಪ್ರೈವೇಟ್ ಸ್ಕೂಲ್ ನಲ್ಲಿ ಇದ್ರು, ಗುಜರಾತಿ ಸ್ಕೂಲ್ ಏನೋ.
ಅಲ್ಲ, all right, we understand, at this age she may be having medical expenses, etc. We understand that. But 2.5 lakhs for marriage and education, that seems to be very.
ಆಗಲ್ಲ, ಈಗಿನ ಆರ್ಡರ್ ಅಲ್ಲ.
ಯಾವಾಗ
ಆರ್ಡರ್ ಅಲ್ಲ.
see 2016 ನಲ್ಲೇನೆ ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜ್ ಫೀಸ್ ಎಷ್ಟೊಂದಿತ್ತು, ನಾಟ್ ಅವಾಗಿನ ರೇಟು ಇವಾಗಿನ ರೇಟು ಅಂತಂದ್ರೆ ಈಗ ನಾವು ವಿ ಡು ನಾಟ್ ನೋ ನೌ ವಾಟ್ ಇಸ್ 5 years 4 years ಕೋರ್ಸ್ ಕಡಿಮೆ ಆಗುತ್ತಲ್ವಾ ಅದು?
ನಾನು ಮತ್ತೆ ನಂತರ ಏನ್ ಬೇರೆ ಸೋರ್ಸ್ ಆಫ್ ಇನ್ಕಮ್ ಇಲ್ಲ ನನ್ನ ಹತ್ರ. ಐ ರಿಟೈರ್ಡ್ ಪರ್ಸನ್.
Assistant liabilities, he is having 9 lakhs in his account, bank account. As on the last date of page number 218 ಅಲ್ಲಿ 31/7/22 ನಲ್ಲಿ he was holding page number 280. 280.
You have filed that he has.
ಹೌದು.
I have filed. I have filed all. I not missed
Correct.
anything. All the accounts have been produced, man.
So he was having cash in hand of 8,96,109.
Page number
280. 280.
Last page, madam, of my compilation, last page,
Is his age now?
62, madam. Retired 62, yes, madam.
Salary account.
Salary.
Salary.
ಇಲ್ಲಿ update date ಇಲ್ಲಲ್ಲ ಇದು.
ಅದ್-
Retired ಕೊಡಿ.
ಅದರ ನಂತರ ಆ ದಿವಸ ತನಕ ಹಾಕಿದ್ದೇನೆ, ಇದು ಹಾಕುದು
ಆಮೇಲೆ ತಗೊಂಡ್ಬಂದ್ರೆ
ಕೊಡ್ತೀನಿ, ಏನು ತೊಂದರೆ ಇಲ್ಲ, ಎಲ್ಲ ಕೊಡ್ತೀನಿ, ಏನು ತೊಂದರೆ ಇಲ್ಲ.
ನೀವು ವಾಲಂಟ್ರಿ ಹೇಳಿ ಇಷ್ಟು ಕೊಡ್ತೀವಿ ಅಂತ.
280?
We'll record that and close.
Your lordship, if lordship suggest me, I'll just ask within 2 minutes and I will let you know.
2022 ನಲ್ಲಿ ಕೊಟ್ಟಿರೋದು, ಅದಕ್ಕೆ ಅದು ಅಲ್ಲಿವರೆಗೂ ಅಷ್ಟೇ ಇದೆ. ಅಪ್ಡೇಟ್ ಅಂದ್ರೆ ಈಗ. He's fair. We have to see both sides. He is also now at this age here. He will be having medical expenses. ಏನದೆಲ್ಲ ಬೇಡ ಪೇರೆಂಟ್ಸ್ ಅಂತಿದ್ದಲ್ಲ ಒಂದಿಗೆ ವರ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. ಒಂದು 5 ಲಕ್ಷ ಮದುವೆಗೆ ಇದ್ರ ಜೊತೆಗೆ ಎಲ್ಲ ಸಿಗ್ತದೆ. ಇರೋದು ಈಗ ಅಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ 5 ಲಕ್ಷ. 60 ಲಕ್ಷದಲ್ಲಿ ತಾಯಿ ಕೊಡೋದು ಬಿಟ್ಟಿರಲ್ಲ, ತಾಯಿ ಕೊಡೋದು ಕೊಡ್ಬೇಕು. ಈಕಿಗೆ 2.5 lakhs. Out of 2.5 lakhs, how much is given for her marriage? Education 1 ಲಕ್ಷ ಅಂತ ಕಾಣಿಸುತ್ತೆ.
Marriage expenses 1 lakh.
Towards the education is 1 ಲಕ್ಷ, 1.5 ಲಕ್ಷ marriage and 1 ವರ್ಷ maintenance. ಒಟ್ಟು 3.5 ಲಕ್ಷ, 3 ಲಕ್ಷ petitionary.
Ask your client to pay another 5 lakhs rupees.
ತಾವು ಹೇಳಿದ್ರೆ ನಾನು ಈಗಲೇ ಫೋನ್ ಮಾಡಿ 2 ನಿಮಿಷದಲ್ಲಿ ಹೇಳ್ತೀನಿ. ಅಂದ್ರೆ ಯಾಕಂದ್ರೆ ಅವ್ರ ಹತ್ರ ಅವ್ರದ್ದೇ ಹೇಳಿದ್ರೆ ನಾನು ಸರ್ ಅದ್ರಲ್ಲಿ 3 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಿ 17 ಲಕ್ಷ ಇದೆ ಅಕೌಂಟಿಗೆ ಇದೆ, ಹೋಲ್ ಲೈಫ್ ನಲ್ಲಿ ಕಮ್ಯೂಟೇಷನ್ ಮಾಡಿ 9 ಲಕ್ಷ ತಗೊಂಡಿದ್ದಾರೆ. ಇದು 30 ಲಕ್ಷ 32,870 ರೂಪಾಯಿ ಬರ್ತಿತ್ತು, ಕಮ್ಯೂಟೇಷನ್ ಮಾಡಿ 9 ಲಕ್ಷ ತಗೊಂಡ್ರು. ಈಗ 21,914 ಪೆನ್ಷನ್ ಬರ್ತದೆ.
ಲಕ್ಷ ಬಂದಿದೆ.
ಹಾ
10 ಲಕ್ಷ ಬಂದಿದೆ.
ಅವ್ರಿಗೆ ನಾವು
ಅದ್ರಲ್ಲಿ ನೋಡಿ ನಾವು ವಿಷಯ ಮಾಡಿ.
What are his other assets?
ಏನ್
ನಿಮ್ ಪ್ರಕಾರ ಏನಿದೆ ಅವ್ರ assets?
He has a house where there is a bill and that is pending for consideration before the estate.
ಅಪ್ಪನ ಪ್ರಾಪರ್ಟಿ, ನನ್ನ ಅಪ್ಪನ
Sister
ಪ್ರಾಪರ್ಟಿ
in Gamali.
ನನ್ನ ಹಿರೇ ಅಣ್ಣನ ಮಗಳಿಗೆ ವಿಲ್ ಮಾಡಿದ್ದಾರೆ, ಇವ್ರು ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಆಗ್ತಾರೆ. ಆ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ನನ್ಗೆ ಹಕ್ಕು ಉಂಟ. ದಟ್ ವಾಸ್ ಡಿಕ್ರಿ, ದಟ್ ವಾಸ್ ಚಾಲೆಂಜ್ ಹಿಯರ್, ಸ್ಟೇ ವಾಸ್ ಗ್ರಾಂಟೆಡ್. ಅಪ್ಪನ್ ಸೆಲ್ಫ್ ಅಕೌಂಟ್ ಪ್ರಾಪರ್ಟಿ ಮೊಮ್ಮಕ್ಕಳಿಂದ
Suit is also decreed. Now ನೀವು ಕೂಡ reasonable ಆಗಿರ್ಬೇಕಂತ. ಯಾಕಂದ್ರೆ now all right, he has also not taken care of her for all these years. But whatever it may be, now he is also in his evenings. ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಇರುತ್ತಾ 62 yearsಗೆ. According to you, what is his in total worth assets? Now partition suit is decreed, that will be in all probabilities ಅದು ಹೋಗುತ್ತೆ. So you cannot count that income. House property income ಇದ್ರಲ್ಲಿ ಕೌಂಟ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. What is his pensionary and other income?
That I have no idea, my lord, regarding.
What is the source of his other sources of income?
ಏನ್
ಸಂಬಳ 1 ಲಕ್ಷ ಬರ್ತದೆ, ಪ್ರಾಪರ್ಟಿ access ಬೇಕಾಗ್ತದೆ.
ಅಲ್ಲಿ wife ಹೇಳಿದ್ರು. ಅದೇ ಈಗ ಎಜುಕೇಶನಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ 1.5 ಲಕ್ಷ, ಅದು ಕಡಿಮೆ ಮಾಡೋದು ಬೇಡ. ಮದುವೆಗೆ ಅಂತ 1 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ರ? ಕೇಳಿ, ನೀವು ಆಸ್ಕ್ ಯುವರ್ ಕ್ಲೈಂಟ್.
Just check the weekend.
Yes.
The password.
Yes.
If this amount they have already paid 6.5.
paid before this honorable court received without demur.
ಈಗ ಕೇಳಿ, ಅದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ
ಕೇಳಿ.
and you also, because
Please, Sonia.
now
Another one, sir.
she has suffered decree on the ground that she has subjected to him to cruelty. For that kind of cruelty, we cannot again give any bonus for that. Now we are concerned only about daughter, because he has some pious obligation. Same way, is it your case that he has remarried?
No.
ಮತ್ತೆ ಅದಕ್ಕೆ
ಇಲ್ಲ.
ಇನ್ನೂ ಈಗ ನೋಡಿದ್ರೆ ವಿದಿನ್ ಡ್ರಾಪ್ ಆಫ್ ಎ ಹ್ಯಾಟ್ ಮತ್ತೆ ಇನ್ನೊಂದು ಮದುವೆ ಮಾಡ್ಕೊತಾರೆ, ಅಂತದ್ದೇನು ಇಲ್ಲ.
Lordship suggest on figure, I will just remind and I will within
ಮಾಡಿದ್ರೆ by consent ನಾವು
file.
ಲಕ್ಷ ಅಂತ ಹೇಳಿದೀವಿ.
ಈಗ whatever is
ಕೇಳಿ, ಈಗಲೇ ಕೇಳ್ಕೊ. Yes.
ಕೇಳಿ. ಅವ್ರು ಕೇಳಿದ್ರೆ ಅವ್ರು ಆಗೋದೇ ಇಲ್ಲ ಅಂತಾರೆ. ಬಿಟ್ಟು
ಇಲ್ಲ, ನಾ ಹೇಳಿದೆ ನಮ್ಮ ಸೀನಿಯರ್ ಕ್ಲೈಂಟ್ ಇವರು, ಸರ್ ನೀವ್ ಏನ್ ಹೇಳ್ತೀರಿ ಮಾಡಿ, ನಾನು ಆ ಮದ್ವೆ ಇವ್ರಿಗೆ ಕಳ್ಸ್ಕೊಟ್ಟಿದ್, ನಾನು ರಿಪೆಂಟಿಂಗ್ ಥ್ರೂ ಔಟ್ ಇಲ್ಲ.
ಆಮೇಲೆ ಮದ್ವೆ ಖರ್ಚು
Really?
ಕೊಡ್ಸಿದ್ರೆ ತಂದೆನ್ ಕರಿಬೇಕು ಮದ್ವೆಗೆ.
ಹೇಳಿ.
Still I am repeating that act of sending back and sending all to jail. I am telling, I am the culprit, sending all the family members to jail.
We understand that.
Yes.
Password.
Cell number 17, S.V. Prakash, B. Sudhakar for R1 and R2.
Yes.
ಬೆನಿಫಿಷಿಯರಿ ಇಲ್ಲ.
Beneficiary. ಪ್ರಕಾಶ್ ಅವ್ರು ಬೆಳಿಗ್ಗೆ ಇನ್ನೊಂದ್ ಯಾವ್ದೋ ಕೇಸ್ ಇರ್ಲಿಲ್ಲಲ್ಲ ಈ ಕಡೆಯಿಂದ
4ನೇ ಮ್ಯಾಟ್ರಿಕ್.
ಯಾವ್ದೋ ಒಂದು ಎಸ್ ವಿ ಪ್ರಕಾಶ್ ನಿನ್ನೆನ ಇವತ್ತ ನಿನ್ನೆ ಬಂದಿತ್ತ ನಿನ್ನೆ ಯಾವ್ದೋ ಒಂದು ಕೇಸ್ ಎಸ್ ವಿ ಪ್ರಕಾಶ್ ಅಂತ ಹೆಸರಲ್ಲಿ ಬಂದಿತ್ತು ನಿನ್ನೆ ಯಾವ್ದೋ ಒಂದು ಕೇಸ್ ನಾವ್ ಹೇಳಿದ್ವಿ ಅವ್ರು ಬರ್ತಿರ್ತಾರಲ್ಲ ಅಂತ ಹೇಳಿ ನನ್ ಕೇಸ್
ರೀಚ್ ಆಗಿಲ್ಲ ಅವ್ನು.
ಮೆಟ್ರಿಮೋನಿಯಲ್ ಕೇಸ್
ಹೌದು ಹೌದು.
ಯಾವ್ದೋ ಒಂದು ಕೇಸ್ ಇದೆ ನೋಡಿ ನಿಮ್ಮ ಏನಾದ್ರು ಮಾಡಿದ್ವಾ ಮತ್ತೆ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ವಾ ಏನು
ಅಲ್ಲ ಇದು ಸೀಲ್ ನಂಬರ್ 4 ಇವತ್ತಿನೊಳಗೆ ಮೇಡಮ್.
ಇವತ್ತಿನೊಳಗೆ
ಎಸ್ ವಿ ಪ್ರಕಾಶ್ ಅವ್ರಿಗೆ
ಕರೆಕ್ಟ್ ಅವ್ರ ಕೊಲಿಗ್ ಬಂದಿದ್ರಲ್ಲ ಕರೆಕ್ಟ್ ಇಲ್ಲ ಮೊದಲ ಅವ್ರು ಕಂಡಿರ್ಲಿಲ್ಲ. ಒಂದು 2 ಮ್ಯಾಟ್ರಸ್ ಇದೆ, ಒಂದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಬೆನಿಫಿಷಿಯರಿ ಬಂದಿರೋ
This has been decided by the Supreme Court, my lord. This is they follow ಮಾಡಿದ್ರೆ because we have not filed our appeal, so I don't have any say.
Where is that Supreme Court judgment?
105.
105 became 150, enhanced to 150 by this honorable court.
First case.
And both have gone there. The landowners as well as the beneficiary filed SLP before honorable Supreme Court. ಎರಡು ಒಂದು ಇದೆ 111 same village, Sominಕೊಪ್ಪ.
With regard to 105, I don't have any dispute, my lord. Regard to 105, I don't have any dispute. 150,
ಕೊಟ್ಟಿರೋದೇ 105.
because we
Then
have not
Supreme
challenged.
Court has passed the judgment. Where is that?
Well, I have produced all the
Email.
judgments with
Oh,
a
connect.
memo,
Civil
with a
appeal.
memo.
Oh, there are
with a
batch of
memo.
matters.
Before that, your lordship kindly
The dated-
take
ಇಲ್ಲಿ ಕೊನೆಗಿದೆ. ಇಲ್ಲ. ನಮ್ಮ ರೆಕಾರ್ಡ್
page 28, page 28.
ಅಲ್ಲ that's it. 25/4/2024 judgment.
ಇಲ್ಲ ಅದೇ.
ಹೌದು 25/4/2024.
ಅದ್ರಲ್ಲಿ internal patient.
ಅಲ್ಲ
You are referring to Supreme Court judgment?
ಅದು ಫಸ್ಟ್ ಅಲ್ಲೇ ಇದೆಯಲ್ಲ, ಫಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸಿವಿಲ್ ಅಪೀಲ್.
ಅದ್ರಲ್ಲಿ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ನೀವೇನೋ ತೋರ್ಸಕ್ ಹೇಳ್ತೀನಿ. 3036 hectares ಅಲ್ಲೇನು ಯಾವ್ದೋ ಸರ್ವೆ ಅದೇನು ಬರೋದಿಲ್ಲ. ಕೋಲಾ
Last document. The main judgment is available in the last order. ಕೊಟ್ಟಿದ್ದೀರಿ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಿ.
ಇಲ್ಲ ಹೇಗ್ ಗೊತ್ತಾಗುತ್ತೆ?
ಅಲ್ಲ last in the last document.
ಯಾವ ಲಿಸ್ಟ್ ಯಾವ ಡೇಟ್ ಇಂದು?
Memo 18/6/24.
18/6 ಅದರಲ್ಲಿ ಇರೋದು 13 January 2020. This court's judgment?
No, not Supreme Court. This
Supreme
court
Court
judgment is page 28. In the cognate matters, this
yes.
honorable court was pleased to enhance the compensation from rupees 105 to 150. The reason is this: the entire land is utilized for the formation of Upper Tunga project. Therefore, there is no question of deduction. The reference court, though fixed 150, deducted and granted 105. So therefore, this court 15%, and this court took a view that when entire land is used by the acquiring authority, there is no question of deduction. Therefore, 105 became 150. Para 6, page 28,
Para 6 we are saying.
para 6.
32.
32 ದಲ್ಲಿ. It is pertinent to note that the lands have been acquired under the same notification and for same purpose for Upper Tunga project. It is also pertinent to mention here that the land of the appellant is situated in the same village and has potentiality for non-agricultural use. Therefore, we find that lands of the appellant are similarly situated in that of the land involved in MFA so and so. In the aforesaid judgment, in respect of the lands covered under the same notification and for the same purpose and has potentiality for urban use. In the aforesaid judgment, you have already determined the market value of the land at rupees 150 per square feet. Therefore, in order to maintain the parity, the market value of the land in question is assessed at the rate of 150 per square feet. Yeah, SLP dismissed. In other matters, my lord, SLP is referred against the MFA 3364 of 2012 and connected matters. Two judgments I have produced. Main judgment is the last document in the bunch of papers.
ನೀವು ನಮಗೆ ಕೊಟ್ಟಿರೋದು ಮೂರಿದೆ. ಹಾ, ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಜಜ್ಮೆಂಟ್ ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇದೆ. ಯಾವ್ದು ತೋರಿಸ್ತಾ ಇದ್ರೆ ಅದು ಫಸ್ಟ್ ಜಜ್ಮೆಂಟ್.
ಹಾಕಿದೆ ಸೀಲ್ ಇದೆ, ಅದೇನು ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಅದು ಇಟ್ ವಾಸ್ ಫೈಲ್ಡ್ ಇನ್ ದ
ರಿಟರ್ನ್ ಕೊಡ್ತಿದ್ದೀವಿ.
ಅಷ್ಟಿಲ್ಲ ಆ ಡಿವಿಷನ್ ಬೆಂಚ್
sorry, it is.
First you have submitted Supreme Court judgment.
Yes, yes.
Serial number 1.
No, I understand. It is missing. It is not in this. It is in.
7587 of 2021.
Yes.
Civil appeal number.
Ma'am,
My lord,
may
Lordship have it tomorrow, my lord.
ma'am, one submission. ma'am.
ಈ ಜಜ್ಮೆಂಟ್ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ? This 25th April 2024, because he is conceding.
That, my lord,
this,
with
my
regard to 105, I will concede
this,
because I have not challenged.
150.
My lord, those memos only they have not given to me. Only I know about that judgment which the Supreme Court has held. The remaining, my lord, I have to verify, my lord.
Supreme Court.
My lord.
Mira,
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅದು. ಮೆಮೊ ಕೊಡ್ಲಿಲ್ಲ ಅವರು. ಮೆಮೊ ಕೊಟ್ಟಿಲ್ಲ.
So Supreme Court has.
Supreme Court I know, my lord. Supreme Court I know.
Supreme Court ಅಲ್ಲಿ ನಾವು ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ಹಾಕಿದ್ವಿ.
50 ಕೊಟ್ಟಿರೋದನ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. That's it.
Let me see same village ಏನು ಅಂತ ನಮ್ಗೆ ಐಡಿಯಾ ಇಲ್ಲ.
ಅಕೋಲಾ ವಿಲೇಜ್ ಅಂತ ಇದೆ ಅದ್ರ.
ಇಲ್ಲ, ಇಲ್ಲಿ ಸೋಮನಕೊಪ್ಪೆ ಇದೆ.
ಸೋಮನಕೊಪ್ಪ. My lord, 3 villages, they are part of Shivamoga city now. Sominakoppa, Gadikoppa, Alkola. In respect of these 3 villages, but compensation is now fixed at rupees 150 per square feet on the ground that these lands.
I will go through, my lord.
ಅಕೋಲಾ ವಿಲೇಜ್ ಅಂತ ಇದೆ. ಅದು ಮತ್ತೆ ಮಲ್ಟಿಪಲ್.
Alkola, Gadikoppa, Sominakoppa.
I will go through those judgments, my lord.
ಹಾ, ಅಲ್ಕೋಲಾ ವಿಲೇಜ್.
Let them give the memo copy.
ಕೊಡ್ತೀನಿ. I will furnish you.
ಇಲ್ಲಿ ಯಾರೋ ರಿಸೀವ್ಡ್ ಕಾಪಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ನೀವು ಅಂದ್ರೆ ಮೊದಲು ನೀವು ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ವಾ? ಮತ್ತೆ ನಮ್ಮ ಆಫೀಸರ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್
ಕೊಡ್ತೀನಿ, ಇನ್ನೊಂದ್ಸರಿ ಕೊಡ್ತೀನಿ, ಬೇಕಾದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡ್ತೀನಿ.
ಇಲ್ಲೇ ಕುತ್ಕೊಂಡು ನೋಡ್ಕೊಳ್ಳಿ.
Kindly have it next week, ma'am.
ಈಗ ಅರ್ಧ ಹಿಯರ್ ಮಾಡೋದು ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾಕೆ? ನಾಳೆ ಮಿಸ್ ಮಾಡ್ತೀವಿ ನೋಡಿ.
Kindly have next week.
You go through the rest of. ಆಯ್ತು, ಈಗ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ ನೋಡಿ. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
ಇದೆ ಮತ್ತೆ ಸೆಪರೇಟ್ ಅವ್ರಿಗೆ ಹೇಳ್ಕೊಟ್ಬಿಡಿ. ಅದಿದೆ, ದಿಸ್ ಇಸ್ ದೇರ್ ಆನ್.
ದಯವಿಟ್ಟು ಒಂದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಅದ್ರ ಮೇಲೆ ಇರುವಂತ SLP ಎರಡೇ ಕಾಪಿ ತೋರಿಸಿ. ಸೇಮ್ ವಿಲೇಜ್ ಬೇರೆ ಎಲ್ಲ ತೋರಿಸ್ಕೋಬೇಕು.
ಅಲ್ಲ, ಈಗ ಮಲ್ಟಿಪಲ್ ಸಿವಿಲ್ ಅಪೀಲ್ಸ್ ವೇರ್ ದೇರ್. ವೆದರ್ ಇನ್ ದಟ್ ಕೇಸ್ ಈ ವಿಲೇಜ್ ಇಂದ
ಇದಕ್ಕೆ ಯಾವುದು ಅಂತ
ಈ ವಿಲೇಜ್ ಕವರ್ ಆಗಿತ್ತಾ ಅಂತ ನೋಡಿ.
ಅದೇ ಕೋರಿಲೇಟ್ ಮಾಡೋದು ಮಾಡ್ಕೊ.
Past one. Seal number 18.
The applicant.
It is Surana.
Yes.
What happened was, an extent of 17 guntas of land was earlier acquired by for the railways. And that was included in the notification, and the award is made for that 17 guntas also. Now the notification is confined minus 17 guntas. For that, a writ petition was filed to quash the notification to that extent. I have produced the certified copy of the order made by this honorable court in WP 13,697.
Correct. First tell us what is your case?
Yes. Out of the acquired land is a 3.
Your petition was under section 18.
18. I am the beneficiary of the,
Correct.
the award is made.
Claim petition. Beneficiary. Managing Director, BMDC.
Yes.
Pre-notification ಯಾವಾಗ sir? Pre-notification.
Notification is on 3/1/2007.
ಎರಡು ಹಾಕಿದಾರಾ?
Synopsis.
ಹಾಕಿಲ್ಲ.
ಎರಡು ಡೇಟ್ ಇದಾವೆ.
3/1 and 4/6/2007.
ಎಲ್ಲ 3/1, 3/1/2007.
Why two? Twice they were issued. How they were issued? Twice. ಇಲ್ಲಿ ಎರಡಿದೆ. ಎರಡು ನೋಡಿ. 3/1.
ಪ್ಯಾರಾ 4 ಹೇಳಿದ್ದಾರೆ. ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ
How much extent was acquired?
3 acres.
37 guntas.
3 acres.
That 27 guntas.
ಹೇಳಿರೋ notification ಬೇರೆ ಬರಲಿಲ್ಲ. Date of notice, notification 3/1. So we are concerned with 3/1/2007 notification. Award ಅಲ್ಲಿ 3/1/2007 notification ಇದೆ. ನಿಮ್ಮ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ you refer to 3/1/2007 notification and 4/6/2007 notification. But award refers to 3/1/2007 notification.
See, it's correct, but the total extent of land notified was 3 acres 36 guntas.
Both in
That
both
is
the
good.
notification put together.
Put together, total land acquired. But actually, out of that land, 17 guntas was earlier acquired for the railways. 3 acres 33 guntas of land only.
Total 3 acres 33 minus 17.
333.
Minus 17 guntas, huh?
So award is made for 3 acres 33 guntas of land.
3 acre.
3 acres 33 guntas, 33 guntas land award ಆಗಿದೆ. But actually, out of this 3 acres 33 guntas, 17 guntas of land was earlier acquired for the railways.
Whether that was denotified for the purpose of this.
No, it is acquired for railways, compensation is received. Therefore, a writ petition was filed to confine the acquisition only to the extent of 3 acres and 16 guntas. I have filed the certificate copy of the order. Kindly take IA number 1 of 22.
This was in 2021.
I produced the certificate copy of the order at 30. Take the.
Yes, got it.
Yes. So the notification was to the extent was quashed and it was confined to only 3 acres 17 guntas.
Same parties are.
Same parties.
Sujabai, Ashwini, Mokshika. Okay. Vittala.
My lord will get the operative portion at page 10 of the requisition order. So the acquisition has to be confined only to 3 acres 17 guntas.
Page number?
Page number 10.
Notification dated 3747 are hereby set aside and quashed so far as the extent of 17 guntas.
Of land in survey number 18.
18. Now, this.
So the compensation has to be reduced.
This 18 guntas was.
17 guntas.
17 guntas was in the land of these claimants only.
Yes, same survey number. The double notification ಆಗಿದೆ.
Survey number ಎಷ್ಟು?
Survey number 18.
18.
Same parties.
Claim petition, ಇದ್ರಲ್ಲಿ ಎಲ್ಲಿ award ಅಲ್ಲಿ where do we find that survey number? Because that 3 acres.
Page 50.
Page 50.
Page 50 of the
Award ಅಲ್ಲಿ.
award page.
The decree ಅಲ್ಲಿ award.
Decree last page ಅಲ್ಲಿ.
50. Survey number 18, 3 acres, 33 guntas. Yes,
Yes.
you are right.
So 17 guntas reduce ಆಗುತ್ತೆ.
What is for entire extent?
Entire extent.
So this was a subsequent event, this quashing,
Subsequent ಅಲ್ಲ,
quashing of the notification.
when they
This
went for,
reduction.
when they went for taking the possession of property, measure the property, they found that the survey 17 guntas of land was acquired earlier by the railways.
But this, when this award was
Ah,
passed.
yes, yes, that is, writ petition was filed.
Why you took up the contention, there was no quashing. So now that has culminated into an order,
Order.
your contention.
Now therefore, the award has to be redone, number one.
Point, that is the only point.
That is another point is,
One
the reference courts has awarded at the rate of rupees 400 square feet for 1 acre of the industrially converted land.
Who represented?
For the 2 to 3, 2 to 5.
So you were also parties to this.
Writ petition.
They were parties in that writ petition,
Writ petition was filed subsequently.
right? But there is an order now, whether it has attained
But
finally.
17 guntas, yes.
So
we have not challenged
on
the
this
writ
point, you are not in this.
No, we are not.
This next point is,
Next point is for 1 acre of land that is said to be industrially converted. The market value is calculated at the rate of rupees 400 rupees per square feet.
1 acre, ಎಷ್ಟು?
1 acre of land out of 3 acres, 17 guntas, what remains now?
Yes.
1 acre ge, the reference court has awarded compensation at the rate of rupees 400 rupees per square feet.
One acre is acquired by KID.
Pardon?
Out of 1 acre out of
1 acre ge 400 rupees grant ಮಾಡಿದ್ದಾರೆ.
ಬೇರೆ ಬೇರೆ ಸ್ಟ್ರಿಪ್ ಬೇರೆ ಬೇರೆ ಆಗಿದೆ.
ಬೇರೆ ಬೇರೆ ಬೆಲ್ಟಿಂಗ್ ಸಿಸ್ಟಮ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. Number one. So, see, they depend, the reference code depends upon exhibit P9. Exhibit P9. Exhibit P9 ಅಲ್ಲಿ, if the land is converted for industrial purpose, then the value applicable for the agricultural land plus 25% has to be added. See, for one purpose, they can't say that we will depend upon exhibit P9, the guidance value, and for that, guidance value notification, SR value.
There, what was the land
1 acre for converted for industrial purpose,
converted? That
for
was-
industrial purpose,
That was converted, there is no dispute.
converted for industrial purpose. That is the finding recorded.
Correct, ಅದ್ರ ಬಗ್ಗೆ dispute ಏನು ಇಲ್ವಲ್ಲ ಇದು.
ಇವ್ರು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ ಈ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಕ್ಕೆ,
Evidence ಮಾಡಿಲ್ವಾ ನೀವು?
ಮಾಡಿಲ್ಲ ನಮ್ಮವರು.
So you have to accept it.
I'm not, say, I cannot raise the contentions
Right.
unwarranted.
Now it is your
So
point.
therefore, see, according to the notification, the land is located by the side of the railway station, railway track. So railway track notification prakara, only 200 rupees is the value as per the guidance value.
200.
200. 400 is fixed for the commercial sites, not for industrial sites.
Yes. By the side of railway track, huh?
Railway track. The decided, and there is also a nala passing by there.
In that document, it is like that.
Railway track ಇದೆ.
ಅಲ್ಲ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಗಿದೆಯಾ ರೈಲ್ವೆ ಟ್ರ್ಯಾಕ್ ಪಕ್ಕದಲ್ಲಿ ಇರೋದಕ್ಕೆ
ಹೌದೌದು ರೈಲ್ವೆ ಟ್ರ್ಯಾಕ್.
ವೇರ್ ಡು ವಿ ಫೈಂಡ್ ದಟ್ ಎಕ್ಸಿಬಿಟ್ P9
P9 ಅಲ್ಲಿ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ರೋಡ್ ಅಂತಿದೆ. ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ರೋಡ್ ಅಲ್ಲಿ 200 rupees per square feet ಕೊಡ್ತಾರೆ.
ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಹೇಳಿ ಅದ್ರಲ್ಲಿ? ಎರಡಿದೆ P9 ಅಲ್ಲಿ ಇದೆಷ್ಟು P10 P9 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಬರುತ್ತೆ ಹೇಳಿ?
P9 ಅಲ್ಲಿ 32 ಇದು ಬಿಡದಿ ಗ್ರಾಮ.
ಇದ್ರಲ್ಲಿ ಅದಿಲ್ವಲ್ಲ ಇದು P9 ಇಷ್ಟೇ ಇರೋದು ಯಾವ ಗ್ರಾಮ ಅಂತ ಇದೆ? P9 ನಲ್ಲಿ ಸೂಚನೆಗಳು
P9 ಅಲ್ಲಿ see, that is the gazette notification of the year 2006.
ದೊಡ್ಡಬಳ್ಳಾಪುರ ಇದು which is this village? So
ನನ್ನಲ್ಲಿ ಕಾಪಿ ಇಲ್ಲ. I have got another notification.
village of the
I have got another notification. I will pass on. ಬೇರೆ ಕೇಸಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನು.
ward ಅಲ್ಲಿ ಬಂದಿರ್ಬೇಕು.
ಬಂದೆ.
ಇವರೇ ಹೇಳಿದ್ರಲ್ಲ
ಒಂದು ನಿಮಿಷ.
ಇದು ಬಿಡದಿ ವಿಲೇಜ್ ರಾಮನಗರ ತಾಲೂಕ್
ಬಿಡದಿ ಅದೇ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ ನನ್ನ ಹತ್ರ ಇದೆ ಕೊಡ್ತೀನಿ.
ಇದರಲ್ಲಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಯಾವ್ದಿದೆ ಅಂದ್ರೆ P9 ನಲ್ಲಿ ದೊಡ್ಡಬಳ್ಳಾಪುರ, ದೇವನಹಳ್ಳಿ, ನೆಲಮಂಗಲ, ರಾಮನಗರ, ಹೊಸಕೋಟೆ, ಕನಕಪುರ ತಾಲೂಕುಗಳಿಗೆ
ಅಲ್ಲ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಕೇಸಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ಮಾರ್ಕ್ ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್ ಮಾರ್ಕ್
P9 ಅಲ್ಲಿ
P9 ಅಲ್ಲಿ ಎರಡೇ ಶೀಟ್ ಇರೋದು ಅದರಲ್ಲಿ.
ಎರಡು ಶೀಟ್ ಅಲ್ಲಿ ಯಾವ ವಿಲೇಜ್ ಸಂಬಂಧಪಟ್ಟಿದೆ ಅಂದ್ರೆ ಅದು ದೊಡ್ಡಬಳ್ಳಾಪುರ, ದೇವನಹಳ್ಳಿ, ನೆಲಮಂಗಲ, ರಾಮನಗರ, ಹೊಸಕೋಟೆ ಮತ್ತು ಕನಕಪುರ ತಾಲೂಕುಗಳಿಗೆ ಮಾತ್ರ ಅನ್ವಯವಾಗುತ್ತದೆ ಅಂತ ಇದೆ.
ನಿಮಿಷ ಮೇ ಪಾಸ್ ಆನ್ ದಿ ಅನದರ್ ಕಾಪಿ ಆಫ್ ನೋಟಿಫಿಕೇಶನ್.
ಕರೆಕ್ಟ್ ಇದು ರೆಕಾರ್ಡ್ ಮೇಲೆ ಈಗ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿರಿ ಇದು ಸಂಬಂಧನೇ ಇಲ್ಲ ಅಂತ ದಿಸ್ ಅಡಿಷನಲ್
ದಟ್ ಈಸ್ ವಾಟ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹಸ್ ರೆಲ್ಡ್ ಅಪಾನ್.
ರೆಕಾರ್ಡ್ಸ್ ಅದೇ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಏನೋ ಕೊಟ್ರಲ್ಲ ಇವರು ಅದು ಇದು ದಟ್ ಇಸ್ ಕ್ವಾಶಿಂಗ್. P10 ಅಲ್ಲಿ ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ. P10 ಅಲ್ಲಿ ಯು ಸೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಲೈಡ್ ಆನ್ P9. P10 ರಾಜ್ಯಾದ್ಯಂತ ಅಂತ ಹೇಳಿ ಅನುಸರಿಸಬೇಕಾದ ಪ್ರಸ್ತಾವಿತ ಕಟ್ಟಡಗಳ ದರಗಳು ಅಂಡ್ ದಿಸ್ ರೆಫರ್ಸ್ ಟು ದ ಬಿಲ್ಡಿಂಗ್ ವ್ಯಾಲ್ಯೂ. ಕಟ್ಟಡ ಅಂದಾಜು ನಿರ್ಮಾಣ ವೆಚ್ಚ
400 rupees ಅಲಾಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಐ ಡೋಂಟ್ ನೋ.
ಇದು ತೋರಿಸಿ ಅವರು P9 and P10 ಏನಿದೆ ಅಂತ ನಿಮ್ಗೆ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಏನ್ P9 10 ಅಂತ ಕೊಟ್ಟಿರೋದಿಲ್ವಾ ಕಾಪಿ?
ನನ್ನ ಹತ್ರ ಎರಡು ಶೀಟ್ ಇದೆ ಅಷ್ಟೇ. therefore
P9 ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ತಗೊಂಡ್ರೆ P9 ಅಂತ ಇರುತ್ತೆ.
ಎರಡೇ ಶೀಟ್ ಕೊಟ್ಟಿರೋದು ನಾನು. ಸೇಮ್ is given to me.
ಅದು ಬಟ್ ಸಿ ದಟ್ ಇಟ್ ರಿಲೇಟ್ಸ್ ಟು ಸಮ್ ಅದರ್ ತಾಲೂಕ್ಸ್.
ಬಂದೆ
ಅಲ್ಲಿ ಟಾಪ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ. P9 ಅಲ್ಲಿ ಇದು ಸೈಟ್ ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ. ಅದ ನಾವು ಒಂದ್ ನಿಮಿಷ
ರೆಫರ್ ಮಾಡ್ತೀರಿ P9 ಇಸ್ ನಾಟ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇದೆ ರೆಫರ್ ಟು ದಟ್. ನನಗೆ ಕೊಟ್ಟಿರೋದು ಎರಡು ಶೀಟ್ ಕಾಪಿನೇ. ಅದ್ರದ್ದು ಕಾಣ್ತಾ ಇಲ್ಲ, ಇದ್ರದ್ದು ಕಾಣ್ತಾ ಇಲ್ಲ. ಬಟ್ ಇದರಲ್ಲಿ ಒನ್ ಥಿಂಗ್ ಇಸ್ ಅಪಿಯರಿಂಗ್.
ರೆಫರ್ಸ್ ಯು ಸೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಫರ್ಸ್ ಟು ದಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಫರ್ಸ್ ಟು ಎಕ್ಸಿಬಿಟ್ P9 ಅಂದ್ರೆ ಇದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ತಿಳ್ಕೊಬೇಕು ನಾವು.
ಇದೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಬಂದಿರೋದು.
Correct. P9 is not the document which are speaking of.
That is true. P9 ಅಲ್ಲೂ ಇಲ್ಲ, P10 ಅಲ್ಲೂ ಇಲ್ಲ. But if there is a industrial converted land,
They are prepared for some other case it seems ನೋಡಿ. ಈ ಕೇಸೇನಾ ಇದು ನಿಮ್ಮ ಬ್ಯಾಚ್ ಬತ್ ಯಾವ್ದಾರ ಇದಾವ?
ಅಲ್ಲ ಇನ್ನೊಂದು ಪಕ್ಕದ ಕೇಸ್ ಇತ್ತು, ಅದು ರಿಮೈಂಡ್ ಆಗಿದೆ.
ಅಲ್ಲಿ ಈ ಕೇಸಿನ ರೆಕಾರ್ಡ್ ನೋಡ್ಕೊಂಡೆ.
ಈ ಕೇಸಲ್ಲಿ ಅದು ಕಾಣ್ತಾ ಇಲ್ಲ, P9 ಅಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ.
ಸೊ ಈಗೇನ್ ಮಾಡ್ತೀರಿ? ಇನ್ನೊಂದ್ಸರಿ ಇದು ರೆಕಾರ್ಡ್ ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀರಾ?
ಅಲ್ಲಲ್ಲ, this is the trial court record which has come to the court. ನಮ್ಗೆ ಕೊಟ್ಟಿರೋ ಕಾಪಿನ ಅದರಲ್ಲಿ 400 rupees ಹೆಂಗ್ where the learned judge looks into, we don't know.
Cost in SLAO as per exhibit P5 ಅಂತ ಹೇಳ್ತಾರೆ. 400 per square feet. Exhibit P4 ಗೆ ರೆಫರ್ ಮಾಡ್ತಾರೆ. para 21. As per the order passed in SLAO.
That award is not approved by the government.
Documents.
54 lakh.
See, that award was not approved by the government, and therefore the
Sales statistics.
54 lakh ಮಾಡಿದ್ದಾರೆ. Para 22 ದಲ್ಲಿ ಇದೆ ನೋಡಿ ಆರ್ಡರ್.
So
Para
if
22
one
order.
quota is sold for 1,35,000,
now what happened was
be 54 lakhs.
the land acquisition officer made one award
ಅದನ್ನು ಅವ್ರು exhibit P5
that was sent for approval.
As per
Approval was
exhibit
not
P5.
granted. Therefore, that award cannot be looked into.
Correct, where is the evidence for that? It was sent to approval and it was not approved by the government. You said you have not laid evidence. Whether any suggestion was made to the claimants?
No, no, that is an admitted factor. The first award,
ತೋರಿಸ್ಬೇಕಲ್ಲ ಎಲ್ಲಿ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
there are two awards. One is not approved, other is approved.
Where have you made a suggestion to the witness that this exhibit P5 was sent for approval and it was not approved ಅಂತ?
Yes, I'll come to that.
ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲಿದ ನೋಡ್ಕೊಂಡು ಪೂರ್ತಿ ರೆಡಿಯಾಗಿ ಹೇಳಿದ್ರು. ಅಲ್ಲ, they refer to exhibit P5. Now he is saying that exhibit P5 was sent for approval and that was not approved.
That was not approved.
Where is the, in the statement of the deposition of the witness, have you stated, suggested?
I'll come to that.
ನಿಮ್ಮ ಹತ್ರ ಡಿಪೋಷನ್ ಕಾಪಿ ಇದೆಯಾ? Cross examination is just one paragraph. ವಿಷಯಕ್ಕೆ ಮುಂದೆ ಕಂಡು ಬರುವ ಕಾರ್ಖಾನೆಗೆ ನಾವು ಬಿಡದಿ ಲೈಸೆನ್ಸ್ ಅಪ್ರೂವಲ್ ಪ್ಲಾನ್ ಕಟ್ಟಡವನ್ನು ಅಕ್ರಮಪಡಿಸಿದ್ರೆ ಸರಿಯಲ್ಲ.
The second award is there.
ಕರೆಕ್ಟ್ ರೀ, ನೀವು ಈಗ ಕ್ರಾಸ್
ಬಂದೆ.
ಎಕ್ಸಾಮಿನೇಷನ್ P1 ಹೋದ್ರಿ, P5 ಬಗ್ಗೆ ಅಲ್ಲಿ ಏನು ರೆಫರೆನ್ಸೇ ಇಲ್ಲ. Whom do you represent? ನೀವ್ ಯಾರನ್ನ represent ಮಾಡೋದು? You are
The beneficiary,
beneficial claimants.
claimants,
There is no cross examination with reference to exhibit P5.
nothing, man.
Then how can you say that?
Kindly say paragraph 14.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಇವ್ರು ಹೇಳೋದು ಈ ಲ್ಯಾಂಡ್ ಒಂದು ಇರುತ್ತೆ. ಇನ್ನೊಂದು ಹೇಳ್ತಾರೆ P5, the trial court has relied on exhibit P5, but P5 was sent for approval and that is not approved.
Approved.
But they have not laid any evidence. In the cross examination.
Therefore, second award is passed. Exhibit P6.
ಅದಕ್ಕೆ ಏನಾದ್ರೂ ಮೆಟೀರಿಯಲ್ ಬೇಕಲ್ಲ ಇವರೇ. Therefore second award was passed ಅಂದ್ರೆ how can, it's very difficult for us to follow your arguments.
ನಿಮಿಷ. ಅದರಲ್ಲೇ ಇದೆ.
P5 ಮೇಲೆ
Exhibit P6 ನೋಡು.
First now he said P5 was sent for approval, it was not approved. Still the trial court relies on that ಅಂತ ಹೇಳ್ತಾರೆ. There is no such suggestion to witness. ಅವ್ರು ಯಾವ್ದೋ ಬೇರೆ ರೆಕಾರ್ಡ್ ತಗೊಂಡು ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದಾರೆ ಅನ್ಸುತ್ತೆ. ಸುರಾನ್ ಅವ್ರೆ, ಇದೇ ರೆಕಾರ್ಡ್ ತಗೊಳ್ಳಿ, ಈ ಫೈಲ್ ತಗೊಂಡು ಓದಿ, ನಿಮ್ಮ ಅವ್ರು ಕೊಡೋ ಫೈಲ್ ಬಿಟ್ಬಿಡಿ, ಈ ರೆಕಾರ್ಡ್ಸ್ ತಗೊಂಡು ಓದ್ಕೊಂಡು ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಆಯ್ತು. Kindly pass out to notebook.
ಪೇಪರ್
ರೆಡಿ.
ಪೇಪರ್ ಬುಕ್ಸ್ ಆಲ್ಸೋ ರೆಡಿ.
ಪೇಪರ್ ಬುಕ್ ಯಾಕೆ ಬೇಕಂತ
ಇಬ್ರು ನೋಡ್ಕೋಬೇಕಂತ ಕೊಡ್ತಿದ್ರೆ
ಕೊಡಿ.
it will be helpful for us.
ನಮಗೊಂದು ಕಾಪಿ ಕೊಡಿ.
ಏನೇನಿದೆ ಅದರಲ್ಲಿ? what this paper book contains?
Lord, please notice, my lord.
ಅಲ್ಲಲ್ಲ, go through it. ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ. ಅಲ್ಲ, go through the court records and make a sentence.
ಒಂದ್ ನಿಮಿಷ. ಅಲ್ಲ, ಇವ್ರು ಏನಾರು ಹೊಸದು ಕೊಡ್ತಿದ್ರೆ we don't take it like this. Trial court record ಅನ್ನೇ ಕಾಪಿ ಮಾಡ್ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ, if at all you want to produce any other record, you have to file application.
No, my lord, we are not
That is-
noticing.
ನೋಡಿ ಇವ್ರೆ.
No new records.
But
Please
what are-
notice, I am just submitting what has happened earlier, that's all, my lord. Because it's an old case, please notice the reframed synopsis.
There, see, in the award, there is reference to only.
Just go through them and make a submission.
You cannot file something which is not there in our records.
ಬಂದೆ.
If you say it is a paper book, exhibit P1 to P11 ಅಂತ ಇದೆ. Whether this, second award, third award, translated copy of the second award ಎಲ್ಲ ಬರ್ದಿದ್ದೀರಲ್ಲ. What are
Those second award, my lord, they are relying on it, which is not marked. I just wanted to point out to your lordship, my lord, nothing else. They cannot rely on it. These judgments which I am producing there, only shows that it is, they become honest. Once the first award is passed,
So whatever they are doing, it adds to that. Now we have to decide whatever material was.
Yes,
placed.
and the, I will show you. I will
Except-
show how the second award is made.
Except that this writ petition order, it was not there. Now it is being produced by way of additional evidence that we can accept because it is between the parties. That bitter we have to rely on the documents. which
only
are-
that, my lord.
ಇಲ್ಲ, ನಿಮ್ಗೆ ಏನು
Rest
ಗೊತ್ತಾ?
is
Just
only
perpetuate.
judgments. Rest is only judgments, nothing else.
Judgments.
There is one more judgment.
Serial number 12 ನಿಂದ ಇರೋದೆಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್. ಅದು ಬಿಟ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 6 is a judgment. ಉಳಿದದ್ದೆಲ್ಲ ಏನೋ ಬೇರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
Only award, second award is there, ಅದು ನೋಡ್ಬೇಡಿ. ಅದು
One ನಿಮಿಷ
ಬಿಟ್ಬಿಡೋಣ.
ಬರ್ತೀನಿ, I'll come to that.
I will leave that.
Say,
Rest of it is judgment.
go
That's it.
kindly pass over the records and go through and make a submission.
Rest is judgment.
Let go through it. ಅದರಲ್ಲೇ ಇದೆ. ಆ ಟ್ರಯಲ್ ಕೊಟ್ಟ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ನೋಡ್ಬೇಕು.
All that. ಅದು ತಗೊಳ್ಳಿ, ಅದೊಂದು ಸೆಟ್ಲ್ಮೆಂಟ್.
Past over matter, seal number 16, Rajeshwari M, Venkatesh R Bhagat.
ಏನಾಯ್ತು?
ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರೆ ಕೊಡ್ತೀನಿ ಹೇಳಿ.
ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರೆ ಕೊಡ್ತೀನಿ ಅಂತ.
ಸಾಹೇಬ್ ಹೇಳಿದ್ರೆ ಕೊಡ್ತೀನಿ.
ಮತ್ತೆ ಸಾಹೇಬ್ರೆ ಹೇಳಿದ್ದು.
ಅದನ್ನೇ ಕೊಡ್ತೀನಿ ಅಂತ.
ಅಲ್ಲ, ಅವ್ರು ಸಾಹೇಬ್ರೆ ಹೇಳಿದ್ರೆ ಕೊಡ್ತೀನಿ ಅಂತ.
ಅಲ್ಲ,
ನೀವ್ ಹೇಳಿದ್ರೆ ಕೊಡ್ತೀನಿ.
ನಾನು ಹೇಳಿದ ಹೀಗೆ ಹೇಳಿದ್ದಾರೆ ಸಜೆಸ್ಟ್ ಮಾಡಿ, ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರೆ ಕೊಡ್ತೀನಿ ಇಷ್ಟೇ.
So now.
ಶುಕ್ರವಾರ ಇದೆ.
Agreeable for that.
I have informed her. She said, oh.
ಅವ್ರು ಎಗ್ರಿ ಆಗೋದಕ್ಕೆ ಕಷ್ಟ ಇವ್ರಿಗೆ. ಇವ್ರು ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರೆ ಅವ್ರು ಕೇಳೋದಿಲ್ಲ. ಏನ್ ಹೇಳ್ತಾರೆ?
ಅವರು 10 lakhs ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
See, now he is also, he will be having medical needs also. Now daughter is, now she is employed, independent. But it is his pious obligation to perform her marriage, to give something for that. ಅದಕ್ಕೆ ಕೊಟ್ಟಿರೋದಕ್ಕೆ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಸೇರಿಸ್ಕೊಡ್ತಾ ಇದೀವಿ. 6 + 5, 11.5 lakhs ಆಯ್ತು.
I shall leave it to the court.
Allegation after going.
ಇವಾಗ ಕೇಳಿ ಒಪ್ಕೊಳ್ತಾರೋ ಇಲ್ವಾ ಅಂತ. ಇಲ್ಲಾಂದ್ರೆ ನಾವು
merits ಮೇಲೆ
ಇಲ್ಲಾಂದ್ರೆ ಒಪ್ಕೊಳ್ದೇ ಇದ್ರೆ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದ ಮ್ಯಾಟರ್. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡ್ತೀವಿ.
ಕಡಿಮೆ ಆದ್ರೆ ಅವಾಗ ಬ್ಲೇಮ್ ಮಾಡಬಾರ್ದು. Based on papers you have to show it. ಕಡಿಮೆ ಆದ್ರೆ ಮತ್ತೆ ಅಷ್ಟು ಕುಡಿ.
ಇಲ್ಲ ಆಯ್ತು. We cannot force you. If she wants you to argue the matter, you argue the matter.
I rest my case. ನಂದೇನಿಲ್ಲ. I have no other submissions.
No other.
She says 7 lakhs ಅಂತಾರೆ ಅಷ್ಟೇ.
ಅದೇನೆಲ್ಲ ಇಲ್ಲ.
ಇದು ಒಂಥರ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತಂದ್ರೆ ಸ್ಕಿನ್ ಡಿಸೀಸ್ ಇದ್ದಂಗೆ, ಕೆದರಿದ್ರೆ ಇನ್ನಷ್ಟು ಸಂತೋಷ ಆಗುತ್ತೆ ಅಂತ ಕೆದರ್ತಾನೆ ಇರೋದಂತ ಹಾಗೆ ಹೇಳ್ತಾರೆ. ಯಾರೋ ಸಮ್ ಸೀನಿಯರ್ಸ್ ಹೇಳಿದ್ದನ್ನ ಕೇಳಿದ್ವಿ ನಾವು. ಹಾರ್ಡ್ ರಿಸರ್ವ್ಡ್ ಅಂತ ಮಾಡ್ಬೇಕಾ ಅಷ್ಟೇ.
Since we accept the offer, please. We accept the offer.
ಒಂದು ಅಲ್ಲ ಇಲ್ಲೇ ರೆಕಾರ್ಡ್
ಟಿಡಿನೇ ತಗೊಂಡು ಬಂದ್ಬಿಡ್ತೀನಿ, ಚೆಕ್ ತಗೊಂಡು ಬಂದ್ಬಿಡ್ತೀನಿ. ಶುಕ್ರವಾರ ಇಟ್ಬಿಡಿ. ಅವ್ರಿಗೆ ಆರ್ಥರೈಟಿಸ್ ಅಂತೆ, ನಾಡ್ದು ಬಂದು ಚೆಕ್ ಕೊಡ್ತೀನಿ, ಆಫೀಸಿಗೆ ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಚೆಕ್ಕಿಂತ ಡಿಡಿ
ಡಿಡಿನೇ ತರಿಸ್ಬಿಡ್ತೀನಿ. ಅಲ್ಲ ಅಕೌಂಟ್ ಹೇಳಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಸ್ಬಿಡ್ತೀನಿ.
whatever is submitted will record it now.
Yes,
5 lakhs in addition to what is the awarded.
5 lakh rupees I will pay, madam. Yes.
After. Drawn on the account of a daughter.
Yes.
ಮಗಳಿಗೆ ಕೊಡಿಸ್ತೀವಿ ಇವ್ರಿಗೆಲ್ಲ. ಅಮ್ಮ ಅದು ಕಷ್ಟ ಆಗುತ್ತೆ ಮುಂದೆ, ಯಾಕಂದ್ರೆ ಮಕ್ಕಳೆಲ್ಲ ನಮ್ಮ ಮತ್ತೆ
ಮದುವೆ ಮಾಡ್ಕೊಟ್ಟು ನನ್ ಜೀವನ ಏನು ನನ್ ಜೀವನ ಏನು.
ಈಗ ಅವ್ರದ್ದು ಜೀವನ ನಿಮಗ್ ಕೊಟ್ಟಿದಾರಲ್ಲ 3000, ಈಗ ಬದಲ್ ಕೊಟ್ಟಿದಾರಲ್ಲ 6.5 ಲಕ್ಷ ಕೊಟ್ಟಿದಾರಲ್ಲ.
ಇಲ್ಲ 3 ಲಕ್ಷ ಮೇಡಮ್. 3 ಲಕ್ಷ ಕೊಟ್ಟು ಮಗಳು 3 ಲಕ್ಷ ಕೊಟ್ಟು.
ಮಗಳ್ 3 ಲಕ್ಷ. ಈಗ ಮಗಳಿಗೆ ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೂ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅವರು. And what about him? And you have implicated him and all his family in the criminal cases. ಅದಕ್ಕೆಲ್ಲ ಖರ್ಚು ಕೊಡೋದಕ್ಕೆ ಸಾಲ ಮಾಡಿರ್ತಾರಲ್ಲ ಅವರು, ಅದ್ ತೀರಿಸ್ಬೇಕು ಅಲ್ಲ. ಅವ್ರು ಅಗ್ರಿಯಬಲ್ ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಡಿಸೈಡ್ ಆನ್ ಮೆರಿಟ್ಸ್. ಆಸ್ಕ್ ಹರ್ ಬಿಕಾಸ್ ಇಟ್ಸ್ ನೋ ಫೋರ್ಸ್. ಸುಮ್ಮನೆ
ಕಡಿಮೆ ರೆಕಾರ್ಡ್ಸ್ ಬೇಸ್ ಮಾಡದೆ ಏನು. She may not get, we may dismiss also.
we do not know, we can't say like
I'll just say maybe disposed of with the amount, whatever the amount.
Not have a when feeling that we pressurize.
No, I had made her understand, please. ನಾನು ಹೇಳಿದ್ದೀನಿ ಅವ್ರಿಗೆ.
When the matter was, and during the course of hearing, the court found an element of settlement. Therefore, ಯಾರು respondent ಅಲ್ಲ, she is appellant.
Yes,
Appellant
she is the
is
appellant.
also present before the court. On discussion, the parties agreed that respondent shall pay a sum of rupees
5 lakhs towards the full and final settlement of the all claims.
over and above,
over and
it has been awarded by the impugned judgment. Shri what is his name? Venkatesh Bhagat Learned Council, Venkatesh Learned Council submits that on next hearing date, the respondent tenders
DD ಅಂತ.
to ಬೇಕಾದ್ರೆ ಬರ್ಕೊಂಡು ಇಲ್ಲಿ 5 lakhs ಅದ for the towards the marriage expenses of the daughter ಅಂತ ಮಾಡ್ಬಿಡೋಣ. Shri Venkatesh Bhagat Learned Council submits that on next hearing date, the respondent pays the DD drawn in the name of
Daughter.
in the name of the daughter list on
Friday.
Friday.
ಹಾ.
ಬೆಳಿಗ್ಗೆನೆ ಮಾಡ್ಬಿಡಿ, ಆಫ್ಟರ್ನೂನ್
ಬೆಳಗ್ಗೆ ತಂದ್ಬಿಡ್ತೀನಿ. 2 ದಿವಸದಲ್ಲಿ ಬರ್ತಾರಂತೆ. ಅರ್ಥರೈಟಿಸ್ ಆಗಿ ಕೂತಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
ಅವ್ರ ಒಪ್ಪಿಗೆ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋಡಿ ಪಾಪ ನೀವು ಸುಮ್ನೆ ನಿಮ್ದಿದ ಅನ್ಕೊಳ್ಳೋದು.
5-7.
ಅದು ಟು ರಿಪೋರ್ಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹಾಕಿ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಅವಾಗ ಬೇಗ ಬರುತ್ತೆ.
ಮಾಡಿ.
Both of them are teachers.
Seal number 17, Mr. Prakash, V. Sudhakar. ಇದು ಪಾಸ್ವರ್ಡ್.
ಅಲ್ಲ ಓರ್ಲೇಟ್ ಮಾಡೋದು ಕಷ್ಟ ಆಗ್ತಾ ಇದೆ. ಅದು ಈ MF ಇಲ್ಲಿ MFಗೂ ಅಲ್ಲಿಗೆ ಸಿವಿಲ್ ಅಪೀಲ್ಗೂ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು. ನಾನು ಐ ಟಾಕ್ ಟು ಮೈ ಕೌಂಟರ್ ಪಾರ್ಟ್, ಅವ್ರು ಲಿಸ್ಟ್ ಮಾಡಿ ಕಳಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಇಲ್ಲಿ ನನ್ನ ಹತ್ರ ಏನು ಕಾಪಿ ಬಿಟ್ರೆ, ಆರ್ಡರ್ ಕಾಪಿ ಬಿಟ್ರೆ ಮಿಕ್ಕಿದ ಪೇಪರ್ಸ್ ಇಲ್ಲ. ಐ ಟಾಕ್ ಟು ಮೈ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಅಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಾನು ರೆಡಿ ಮಾಡ್ಕೊಂಡು ಬರ್ತೀನಿ. ಯಾವ್ದು ವಿಲೇಜ್ಗೆ ಯಾವ್ದು ಇದೆ
This 9-7.
ಪ್ಲೀಸ್. I'm sorry, my lord. In the first case, I could not appear for the reason that I was held up.
All right, we have recorded your submission. ಯಾರೋ ನಿಮ್ ಕೊಲ್ಲಿಗೆ
Please.
ಅಲ್ಲ ಅವ್ರೇನೋ ನೋಡಿ ಹೇಳ್ತಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಅವ್ರ ರೆಡಿ ಆಗಿರೋದಿಲ್ಲ ಅಷ್ಟು ಬೇಗ ನೆಕ್ಸ್ಟ್ ಕರ್ಸಿ.
Seal number 19, Money and KBS, Bipin Hegde Fararvan.
Yes, sir. Yes, sir. Yes, sir.
My lord, we appear for the appellant. It arises out of a judgment passed in a proceeding initiated by the first respondent State Finance Corporation under section 31(1) AA of the State Financial Corporation Act. My lord, the suit came to be decreed, and we are challenging that judgment before this bench. Now, the brief facts are the two facilities were obtained by the petitioner corporation, the appellant corporation, for a sum of rupees 24 lakhs and another facility for 5,70,000.
Yes.
24 lakhs, one
5
facility,
lakhs
and 5,70,000 on various terms. I think one was on a lesser interest, whatever.
Yes.
These facilities were obtained on 20th May 1977. The appellant corporation, the appellant company, my lord, appears to have defaulted in the payment and servicing of the loans. A demand notice was issued by the First Respondent Corporation on 15th of April, 1981. And then thereafter, my lord, since the amounts were not paid, the assets of the appellant company were sold on 15th November, 1984.
Not appellant company. That is respondent number 2, it seems.
Yeah, sorry, the respondent number 2, of which the appellant is one of the guarantors. I'm
You
sorry.
are only a
A
guarantee.
guarantor, yes. So we are sailing together, my lord. The appellant and respondents 2 and 3 are sailing together. The second appellant is the defaulter company. The appellant and the third respondent are directors of the company.
Hmm.
I'm sorry, I was wrong in.
Not even issued reply notice. You are not even issued.
We had, I will point it out.
No, you know, synopsis, you said only respondent number 2 had issued the reply. You two had issued the reply.
Yes, respondent number 2 had issued because the demand notice, my lord will see, the first notice of 19, kindly see item 6 of the list of dates. The first notice was on all 3, the defaulter company and the guarantors. And then they sell the assets on 15th November 1984. Realize the dues. In fact, they sell, they sell for more than what is due to us. My lord, see. According to them, what was due was to the tune of about 65 lakhs. They sold it for 81 lakhs on 15th November 1984.
44 lakhs as on 15/4/1981.
Yes, and they sell it for 81 lakhs. 84, they sell it for 81 lakhs.
Correct. Allavaga, or the interest 44 lakhs 20 is double, it has become double.
No, 81 lakhs was what was fetched in the auction. The claim amount was 44 lakhs.
44 lakhs.
44 lakhs.
And their claim was 44.
Yes. In fact, there is no dispute, my lord, that they sold in excess.
All.
There is no dispute. I'll come to that, my lord. There is no dispute regarding the excess realization. After, and a very peculiar procedure was followed. They themselves bought the plant and machinery and the land. And there is no evidence, I'm not on that. I just want to point it out to the honorable court. There was no notification, publicity, or anything of that nature. They bought it themselves. And then, yes, the corporation bought it. And then they sell it to another private entity for 105 lakhs within months. But at the end of the day, they made well with the assets. There is no communication to the defaulter company or its guarantor directors about the outcome of the auction. No communication whatsoever. And my lord, then it goes into a quietus from 1984. Nothing at all is heard. And in 1993, kindly note, these dates are very relevant. On 29th June 1993, a notice is issued to the guarantors, the appellant and the third respondent, that there are still dues payable by the defaulter company. And since the guarantee deed is a continuing guarantee, they demand a certain amount of money from us. It is replied on 10th August 93.
Both of you replied? One.
Yes, both of us replied.
But in your synopsis, you have said only respondent number 3 replied. Serial number 9.
Yes, my lord. I will point out the exhibit. Father and son. Father and son are directors. Pramod Mehra and father is, yes. Yeah, father and son. They responded denying the liability. In fact, saying that it was sold in excess and no details were furnished by the corporation as far back as 1984. A contention was also taken that having sold the assets in 1984, a notice in 1993 was time barred. And thereafter, on 5th November 1994, this proceeding is instituted for recovery of the balance. And
but your reply notice was not marked.
it is marked.
No, legal notice exhibit P3, legal notice dated 22/9/1992 anta heltare. There is no reference to 1993 notice. Right?
Yes.
Mhm.
Exhibit P. Exhibit P3.
P3 is the notice anta, that's how it is marked. P3 is the notice dated 22/9/1992.
Yeah, P5 is the reply.
P5 is the letter dated 10/8.
Yeah, it's a reply. It's a reply.
92 ಕ್ಕೆ 90.
My lord has exhibit P5.
Yes.
And that the page 31 of that compilation, my lord.
Yes, and given a compilation.
I mean, yes. You have this
Exhibit
set of
P5.
compilation?
for
P5.
From Nandakishore.
Yes,
Mehta.
yes, that's the third respondent.
You said both of them have issued a reply, but it.
I'm sorry, yeah, I stand corrected.
Mehra.
But my lord, he represents both father and son. And he says that in the body of the letter, he says both Nandakishore and Pramod Mehra. Para 1,
Reply to your aforesaid notice, we state that.
either by the company or it's by its directors, Nandakishore Mehra and Pramod Mehra.
Either by company or. Anyway, if it is time.
Yes.
Against one, it will be time barred against other. also.
Absolutely, my lord. I'm only on that. Yes,
The order does not state that it is being issued.
yes, yes, yes. So my lord will see at paragraph 9 of that reply notice, they refer to the demand notice of 15th April 1981.
KSFC refused to agree. It starts para 9 starts like this.
Yeah, the KSFC refused to agree to any of our aforesaid proposals, as the KSFC's intention was not to help our unit, but to grab our unit. Therefore, by their notice dated 15th April 1981, the KSFC recalled the loan given to us and called upon us to repay rupees 44,20,675 with interest thereon, but from 4th April 1981, within 7 days. Yeah, kindly come to para 11, my lord. These dates are relevant on the argument of limitation, which my lord will kindly consider. Para 11, under instructions from the managing director KSFC, the special tehsildar wrongfully attached our aforesaid properties and conducted a mock auction on 15th November 1984. Since the auction was not properly publicized, there were no genuine bidders. The KSFC collected KHDS and KSIC, who were not at all interested in the bid. Reference before my lord puts on the file. Kindly come to paragraph that exhibit P3, para 5, the demand notice on the guarantors. I'll just put my submission on law, my lord, for the consideration of the court. Kindly see paragraph 5. And before that, para 4, 404. My lord has that?
Yes.
The company is also liable to pay certain amounts to KIADB and KSSIDC, KEB, etc. I mean, it can't be as vague as that. And kindly see the next paragraph. My client, taking into account pari passu arrangement with KSIIDC and payment to KIADB and KEB, has worked out appropriation of the sale proceeds. And after such working out, a sum of rupees 24.69 lakhs has been taken for appropriation to the dues of use of the company to the corporation. After adjusting the amount, kindly mark these very important words, on a tentative basis. I'll explain the meaning of the word tentative. The company is still liable to pay a sum of rupees 148 lakhs as on 28th June 92, and this amount may also be enhanced in case the corporation is liable to pay the amounts to the accounts of the company to various other agencies as stated supra. As on 20th June 92, the company is liable to pay a sum of rupees 148.60 lakhs. And then in para 6, they invoke the continuing guarantee. The continuing guarantee deed executed by 1 and 2 have undertaken to pay the amounts as and when the corporation has demanded the amount from the guarantors if company has failed to pay the amount. The company is liable to pay a sum of rupees 148.60 lakhs on 20th June 92 as stated supra and has failed to pay the amount. The entire assets of the company has been sold, and after adjusting the sale proceeds as stated supra, the company is still liable to pay a sum of rupees 148.60 lakhs. On this amount, the company is also liable to pay an interest at the rate of 16.5% from 20th June 92 till the amount is realized. Well, the only point for the consideration of the court is, if an auction had happened in 1984 and they had distributed these proceeds amongst the other agencies which they claim, and of those details which are not forthcoming in the notice, why would they wait till 1993 to issue a notice to the guarantors? Now, I will explain why that happened also, my lord. And before I do that, on the point of limitation, my lord I must be aware of Deepak Bhandari's case, my lord, where the Supreme Court on the point of limitation has stated, I will refer to the relevant paragraphs. This is
Is there in your compilation?
we have provided a list of authorities, my lord, and it is numbered, manuscripted. Page 67 is Deepak Bhandari versus Himachal Pradesh State Industrial Development Corporation Limited.
Yes.
I don't know whether my lord has it.
Yes.
Yes. Now, kindly come to paragraph 28 and 29. The last two paragraphs at page 78.
Page 70.
70, manuscript 78. Para 28. It is thus clear. Well, this is in the context of an auction sale in that case. It is thus clear that merely because the corporation acted under section 29 of the State Financial Corporation Act did not mean that the contract of indemnity came to an end. My lord, we are referring to the guarantee cum indemnity. Section 29 merely enabled the corporation to take possession and sell the assets for recovery of the dues under the main contract. It may be that on the corporation taking action under section 29 and on their taking possession, they became deemed owners. The mortgage may have come to an end, but the contract of indemnity, which was an independent contract, did not. The right to claim for the balance arose under the contract of indemnity only when the sale proceeds were found to be insufficient. The right to sue on the contract of indemnity arose after the assets were sold. The present case would fall under Article 55 of the Limitation Act of 1963, which corresponds to 115 and 116 of the old Limitation Act. The right to sue on a contract of indemnity or guarantee would arise when the contract is broken. Okay, 29. Therefore, the period of limitation is to be counted from the date when the assets of the company were sold and not when the recall notice was given. So therefore, my lord, in this case, the guarantors there, after the sale and it was found to be insufficient, when they approached the guarantors, they took the contention that the limitation applies from the date of the notice issued to the principal debtor. The Supreme Court said in a contract of guarantee stroke indemnity, so far as the guarantors are concerned, my lord, the cause of action of or the limitation doesn't begin when the 1981 notice was issued, but when the sale is effected and then there is a shortfall, then the 3-year period limitation starts. And therefore, my lord, the reason why a notice, was issued in 93, what is, my lord, that, with due respect, my lord, why 93 and why not before? Just to highlight to the court what really happened. My lord, after the auction in 1984, the Finance Corporation appropriated the entire sale proceeds of the auction, and then they sold it to a private entity and took 105 lakhs. They claim it rested there. There was no further communication with the defaulting company or the guarantors from 1984 onwards. We were never told about what was the settlement with the other agencies. And even, my lord, in these proceedings, even in the notice which I pointed out at Exhibit P3, they don't set out the amounts which were paid to the other agencies, whether they claim a pari passu agreement. My lord, no pari passu agreement was marked in these proceedings by the petitioner, by the state corporation. And my lord, no details are forthcoming as to what was paid to the other agencies. I'm not on that. I'm just wanting to bring that to the notice of the court. The reason why they woke up in 93 was this. After the sale, my lord, in 1984, and having appropriated all the sale proceeds, the unit was closed. The workers filed a petition in the labor court claiming closure compensation and back wages for having wages not paid. In those proceedings, which were instituted in 1984 after the sale of the unit, in 86, they make the State Finance Corporation a party, the workers. They say their contention before the labor court was that we have a prior right over those monies, and therefore the State Finance Corporation could not have appropriated the entire proceeds and settled in a manner without notice to the workers. Now, my lord, what the labor court does is it passes an award dismissing the labor's contention against the State Finance Corporation. That award comes somewhere in 94. Anticipating that there might be an adverse award against them, they institute this notice and proceeding in 94. But they won the case after this proceeding was instituted in 94. I'm just highlighting to the court why it came in 93, 94. If there was no labor case, we would not have had a petition in 94. And they filed it before the award, anticipating that the labor court might pass an award against them after they were made a party in those labor court proceedings in 86. Now, the workers thereafter take coercive proceedings against the directors under the labor laws for not having paid their wages. And the guarantors file a writ petition challenging the labor award so far as it makes them liable criminally for violation of certain provisions of labor law. And in that, my lord, in that proceeding, quite strangely, in a writ petition before this honorable court, before a learned single judge of this court, my lord, the guarantors, the appellant before my lord, make the State Finance Corporation a party alleging that the dues were wrongly appropriated. If we are liable to the workers, it's the State Finance Corporation which has to bear the workers' liability. And in those proceedings, my lord, the learned single judge comes very heavily on the State Finance Corporation for not being transparent on the manner in which the auction was held, for not being transparent on the manner in which the proceeds were distributed, and finds that no concrete evidence was forthcoming in those writ proceedings. My lord, though it was targeted against a labor proceeding which was coercive.
That was in which year?
That was in 94.
94. Before
Yeah.
filing this petition or after filing this petition?
After filing this, the institution was in 94, but then during the proceeding was instituted before the award.
Petition order was passed in which year?
I'll show you the date of award.
Exhibit P6.
P6.
Writ petition was filed in 98.
P6, certified copy of the order.
Yes.
Dated date is not mentioned.
I'll mention the date.
August 99, the writ petition was disposed of.
That's right. And my lord, in that judgment of the learned single judge, my friend is very right in that date, my lord. You said exhibit P6, isn't it? P6. Yes. It's dated, my lord, the order is dated August, 20th August 99. And the corporation, my lord, the State Finance Corporation was made liable, and my lord, the learned, I mean, the honorable judge became later on as honorable justice of the honorable Supreme Court. He realized, kindly see the operative part of the order. Kindly come to page 11, I mean, the print page 11 or manuscript page 45. The corporation did not state what was the amount due to the KSIIDC.
Which internal page?
Internal page 11 of that judgment, my lord.
Internal page 11, para?
I'm reading para 7, my lord.
Yes.
It is further stated that as on 1st of January 1984, the company was liable to pay to the corporation rupees 65 lakhs 11,724, which amount was mentioned in the recovery certificate. Now, let me pause here for a moment, my lord. There is no doubt that 81 lakhs or 105 lakhs were far exceeding this amount, admittedly. So there's no dispute regarding it being in excess. The corporation did not state what was the amount due to the KSIIDC, which had also advanced the loan along with the corporation on a pari passu basis. It is further stated that no sale proceeds were remained over with KSFC. On the other hand, it is stated that an amount of rupees 32 lakhs is due from the company to the corporation. It is stated that steps are taken to file the miscellaneous application under section 31(1) of the State Financial Corporation Act. Now, this was the stand of the State Finance Corporation. They were still contemplating, my lord, at that point. It's an 88th petition about taking, by which time the labor court award came and then this proceeding was initiated. And my lord will see the operative part. In those proceedings where I do not know whether the State Finance Corporation was a necessary party, the attempt of the appellant was trying to rope in, though the challenge was to a labor court order initiating coercive measures, they dragged in the State Financial Corporation. And my lord will see the operative portion of the order, what the learned single judge. I mean, this is only, I mean, this was set aside by a division bench, and just as a matter of what transpires. Para 20, internal page 32, para 29. And before that, the learned single judge refers to Lord Denning's judgment reported in the SEC.
Right now, that judgment was set aside according to.
That's set aside, and therefore the State Finance Corporation was held not to be liable. They said that the workman's liability is no priority.
Yes.
The KSFC has to pay a matter.
I just brought the notice of the Honorable Court to these proceedings, my lord, just to highlight under what circumstances the 93 notice was initiated.
Not intended to recognize or accept any claim of workman. He therefore allow this appeal, the order dated so and so is set aside. Consequently, petition is dismissed. So now whatever is observations are, but that.
They won at every level.
No. Why are you reading so in detail?
Not required, my lord, not required. All I wanted to point out was the circumstances under which a sale was effected in 1984. They claim that they settled the pari passu charge holders as well. And they rested their claim against us over there. In 93, a notice was issued to us and a proceeding was initiated in 94 in the backdrop of the claim by the workers and an anticipation, my lord, of some liability on the State Finance Corporation, which for their benefit eventually resulted in no liability for them. So therefore, my lord, your initiation of a proceeding under the relevant section of the State Finance Corporation Act cannot be dependent upon an initiation by the workers where they drag you into their proceedings. Your cause of action is when you sell the assets and you find that you're falling short after assuming there is a pari passu charge for other similar finance agencies, your cause of action starts there is my respectful submission, and I rely upon Deepak Bhandari's case for that proposition. So therefore, my lord, a 93 proceeding is completely time barred, is my respectful submission. My lord, when we argued this matter before the bench before, it was heard at length. And my lord, at that point in time, my friend, subject, I will reply, reserve a little time for reply, my lord, after my friend submits. What they took a contention was, just to bring it to the notice of the court, I'm sure my friend will highlight that. They said that the account is alive, and therefore we could issue a notice in 93. They said they have a live account. Now, we fail to understand what they meant by live account, because they claim that they sold the assets in 1984.
Not live account. If the debt is live, that in that judgment,
Yeah, the debt is live. Yeah, as I understand.
the liability, if the liability is
Yeah,
live, then it
Yeah,
can
yeah.
be
When does it
assessed.
die? When does it die? When does it die, and when does it continue to live is the issue, my
It's
lord.
barred against the principal borrower himself, then it is barred against the guarantors also. That is
Absolutely.
the same
Yes,
judgment.
yes, absolutely. And Deepak Bhandari clarifies that in one way, because my lord, a deed of guarantee, if my lord sees the deed of guarantee, sorry. Yes, syndicator, my lord, I am referring to that.
Come from Karnataka.
Yes, absolutely. Channa Virappa, syndicator. We are referring to the citation.
There,
We have.
is there?
I will punish.
Polish.
My lord is right on the point. I'll point out the relevant paragraph. Yes, yes.
That is the proportion here.
Absolutely.
If the debt is barred by time against the principal borrower, then it is barred against guarantor also.
That's all.
Paragraphs.
Paragraphs, my lord, 14, 16, and 17. Syndicate, give me a copy. I'll give it to you.
16, 17.
14, 16, 17. My lord, I reserve some time for rejoinder if there's any, my lord.
Yes, according to you, the debt was barred by time against the principal debtor himself.
Yes,
By the time this notice was issued to.
yes, yes. And my lord, by Deepak Bhandari's case, when you recover your monies by a sale and you find that you're short, my lord will see the guarantee deeds by banks are very widely worded. Right. So, therefore, in Deepak Bhandari's case, they gave the benefit of doubt.
You surrender everything.
Absolutely. And in Deepak Bhandari case, they took that extra mile and said, all right, when you sell, they said, the guarantor said from the demand notice, 3 years, that they should initiate proceeding against the principal debtor and the guarantors. But the Supreme Court said no. After the sale, when there is something short, because they invoke the doctrine of
Guarantor also takes a chance.
Yeah.
Or in this Deepak case, it last after sale 3 years later.
yes, but then you know that you're short.
When it was found short and actually, when it was found short, they have gone factually.
Yes,
When it is demanded and declined, then it becomes.
absolutely against the principal debtor, my lord. But in Deepak Bhandari, what they said, that was the contention taken by.
That case.
My lord, perfect. The exact facts. In Deepak Bhandari's case, the guarantors took the stand, which my lord is suggesting. They said, demand notice was issued in 91. You didn't proceed against us, you proceeded against the principal debtor. You're coming to us after 3 years after the demand notice, and therefore it is time bar was the contention of the guarantors. The Supreme Court read the deed of guarantee, where there is a clause of indemnity. And they said that the indemnity kicks in when they sell the assets, not from the date of notice.
When what is said in your agreement,
In my case, they sold going by Deepak.
your guarantee deed.
Yes, yes.
Is it worded?
It is, my lord, it is worded not as wide as in Deepak Bhandari, but yet, assuming for a moment, they will be taking that a date of demand is issued. It says date when a demand is issued.
They even put a clause that the exoneration of principal borrower does not exonerate them.
Quite
All
right,
these
quite
clauses
right,
are
but not over the limitation law. I mean, that is understandable.
All such clauses.
All such clauses are included, my lord. All such clauses are included. Yes, yes. They include that. They include that. They also include indemnity.
They're trying to say that the moment the amount was found insufficient to, recover,
Yes.
make up that.
Then the guarantors can be proceeded with. You can't issue a demand notice at your whim, my lord. My lord, I think one of the arguments in a rejection of plaintiff case we argued, they said that the cause of action arises when the demand notice is issued. How can a demand notice be a cause of action? The cause of action precedes the demand, therefore you make a demand. My lord, a cause of action precedes a notice.
That notice should be within
3 years. From the date of auction is my respectful submission as per Deepak Bhandari's case, my lord. Even if you stretch the indemnity agreement to the max.
It should be within the period of limitation payable by, so far it relates to the principal borrower. That
Quite right.
notice should be within the period of limitation.
Absolutely. That is what Syndicate Bank says. That is what Syndicate Bank says. And when does that period end? 3 years from the date when you find that there is a shortage after you sell the mortgage assets.
No, after the sale, when the notice was issued to the. principal
93. Sale was in 84.
Notice was issued to the principal borrower.
81. 1981.
84, it was sold.
81 was the notice.
They say that some surplus was found.
84.
Not surplus, some
Shortage.
shortage was found.
When did they say that?
84, thereafter, when did they issue notice?
93.
93. So according to you, by the time they issued notice to the principal borrower itself, it was time.
Absolutely, 9 years.
What is their defense for that?
Their defense when we argued before the previous bench was that it is a continuing guarantee.
Maybe continuing.
The continuing guarantee is defined under the Contract Act. It extends.
Petition is.
Absolutely.
In evidence, they had produced any material to show that in between this period, there was any concession or acceptance.
Nothing at all, my lord. Nothing at all. Nothing at all. Nothing at all. They produce a bank statement which is now.
Because revival of debt once they, accept the.
No, there was nothing. In fact, we never even had a communication.
Not with you, with the principal borrower.
The company, nothing at all. Nothing. Nothing at all.
Acknowledgement.
No, there was not even an acknowledgement of how much they claimed, how they settled the other, nothing at all. And my lord, this is kindly note, my lord, the demand notices of 81, when computerization was not even in force. And they produce a statement, a computerized bank statement in support of this claim.
Statement of accounts, Andre, as on the date of this petition, they might have produced.
How did they cook up that? We don't know.
Even quoting all our judgments were earlier typewritten. Now we have uploaded them.
No, that is okay, my lord. But under the banker's book, absolutely, I don't deny that. Under the Banker's Book Evidence Act, my lord, whatever, I quite accept.
All the old records are also uploaded.
Then there should be a certification by the officer who converted the manual into the computerized that he has compared it and he certifies it.
Who they have exam? Manager?
Manager.
There is sanctioning time girovobru.
No, very different.
And
And even the certification as per the Banker's Book Evidence Act, my lord, knows a special procedure under the Banker's Book Evidence Act. None of it is followed. I mean, I'll reserve 10 minutes in rejoin, my lord, if there's any.
That procedure you said, Bankers Books of Evidence Act?
Section 4 provides for a
It says it has the presumptive value.
presumptive value, rebuttable, but it also says when does it have?
The ordinary course of business.
When does it have? There are certain preconditions to be met with.
What are those preconditions?
My lord will see section 4. Different definition is there. Section. I'll just point out, my lord.
Mode of proof of entries in bankers books.
Yes.
Subject to the provisions of this act, certified copy of an entry in the bankers books shall in all legal proceedings be received as prima facie evidence.
Kindly see 2 capital A.
2
capital A. My lord has the latest act. Yeah.
Conditions, yes.
And then my lord will also see the definition of certified copy in section 2, subsection 8.
Certified copy.
Yes.
2A.
So there are stringent conditions. Obviously, my lord, you can't get the registers, huge registers to court. So this is another way of proving it. But then it should be subject to these conditions. If you can't meet these conditions, then produce the original record.
PA is introduced when?
It was introduced in
2000. In the year 2000.
2000.
Correct.
Yeah.
It is applicable to you. Yours.
Look at eight, certified copy. It is applicable to me because you're producing computer printouts.
Yes, it says certified copy means when the books of a bank are maintained in written form, a copy of an entry in such books together with a certificate written at the foot of such copy that it is a true copy of such entry, that such entry is contained in one of the ordinary books of the bank and was made in the usual ordinary course of business. And such book is still in the custody of the bank and where the copy was obtained by mechanical or other process, which in itself ensured the accuracy of the copy, further certificate to that effect. But where the book from which such copy was prepared has been destroyed in the usual course of bank's business after the date on which the copy had been prepared, a further certificate to that effect. Each such certificate being dated and subscribed by the principal accountant or the manager of the bank.
So my lord, this is only by way of a supplemental argument. But my lord, the main argument is under syndicate bank. My lord sees paragraph 13. I mean, I'll come and rejoin my lord after my friend finishes.
Yes.
15 minutes and rejoin her.
First time, first appeal.
You have stated this in objection. right?
Yes. And very casually it was disposed of without consideration by the trial court judge.
31 proceedings you have stated.
Yes.
The written statement that they have filed.
There, brother was asking.
Yes, evidence was laid.
Had raised and how it was dealt with by the trial court.
Lordship's
So
turn
it is
to,
answered by the trial. on
Very
invitation.
casually, my lord, I'll read out the paragraph.
Which paragraph?
I'll join. You can-
Lordship's turn to the written statement that they have filed.
I'll complete, huh?
Page 8 it seems.
Yes.
Petitioner has also invoked deed of guarantee. The petition filed on 31, their plaintiff filed petition within time. This is in running page 19, ink page 19 ನಲ್ಲಿ ಹೇಳಿದೆ. The petitioner has also invoked deed of guarantee on 22/9/1992. Petition filed on 31/10/1994.
Yes. Is therefore within time. And kindly see my contention in the previous.
When this order was passed, this Valeris case had come. It is 2016.
Yes.
That State Bank case. That is 2006. ಅಲ್ಲಿ ಯಾವ್ದು ಸೈಟ್ ಮಾಡಿರ್ಲಿಲ್ವಾ ಇದನ್ನ?
Illa. Sorry, unfortunately. But the contention was taken. Kindly see ink page 17, last 5 lines. The petitioner demanded the respondents to pay the balance amount, but they failed to repay the amount. Respondents 2 and 3 contention. The petitioner realized the amount of 105 lakhs during the year 1984 itself. And if they wanted further amount, then within 3 years therefrom, the recovery petition should have been filed. There's no question of any further amount being due. So the contention was taken.
Yes.
Lord, your lordship's turn to the written statement that they have filed, my lord. All that they say is the petition is barred by limitation. And they say that in 1984, the property of the company was sold. But they don't refer to that 15/4/1981 notice at all in their written statement. 15/4/1981 legal notice purportedly to have been sent to them. They don't refer to that.
Correct, even if it is sent in 1981 limitation.
Correct. So therefore, Lord, all that they say at para 4, your lordship's turn to the written statement. Lord, respondent submits their directors of measures so and so due to
Para-
heavy losses. Para 4,
The statement of objection.
statement of objections.
With with reference to para 12, the respondent submits ಹಾಗೆ, it starts like that.
Lord,
With reference to para 12, the respondent submits that.
respondent submits, they were the directors of Vivek Textiles anta.
Para 4 reads like this. With reference to para 12, the respondent submits that no.
Alla. Adu kindly turn to the previous page, my lord. Your lordships are,
Demands were raised by.
Illa. Your lordships are reading the 4th page. Kindly turn to the 2nd page. Para 4. ಇಲ್ಲಿ.
Correct. ಅಲ್ಲ ಆಯ್ತು. ಎರಡೆರಡು ಸರಿ ಮಾಡಿದಾರ.
ಅದು
ಧಾರಾವೈಸ್ ರಿಮಾರ್ಕ್ಸ್.
ಪ್ಯಾರಾವೈಸ್ ರಿಮಾರ್ಕ್ಸ್ ಈ ಕಡೆ respondent submits they were the directors of measures Vivek Textiles. Due to heavy losses, they had borrowed monies from the petitioner. They had borrowed an amount of
ಆಯ್ತು, that is good.
petitioner had sanctioned a loan of 24 lakhs. Admittedly, petitioner auctioned the immovable properties which were mortgaged, which the petitioner themselves purchased for an amount of 81 lakhs on 15/11/84. Thereafter, petitioner sold the unit which was purchased by it to Gemini Dyeing and Printing Mills for a sum of 105 lakhs. But it is denied that only an amount of 24.69 lakhs was appropriated by the petitioner. In fact, the petitioners themselves in writ petition number so and so filed by the respondent, in which the petitioner was the fifth, has admitted that they have received an amount of 38 lakhs 85,570. Hence, when in the year 1984 itself, they realized an amount of 38 lakhs 85,570. There is no question of any further amount being due. Further, petitioner's own statement made in this petition and before the Honorable High Court of Karnataka is contradictory, which clearly shows petitioner has filed a false claim only to harass the respondents herein. Further, as they sold the unit for 105 lakhs, they were in surplus of the amount which were not returned to these respondents, nor was it accounted for. Lord, your lordship, see, after I sold this property, Lord, for 105 lakhs, Lord, amounts were appropriated between KSI, IIDC and KSFC. Lord, what we have got is just around 24.69 lakhs. Therefore, my lord, further amounts were due. Now, my lord, the core question, my learned friend says that after the property was sold in 1984, if there was still dues, you should have filed the petition within 3 years from the date of 15/11/1984 when the property was sold. This is the point which my learned friend is canvassing. My lord, your lordship may kindly see, as far as a continuing guarantee is concerned, my lord, it's an undisputed fact that they have executed a continuing guarantee. Lordship kindly turn to the continuing guarantee.
Page? Execution guarantee deed is exhibit?
Lord, guarantee deed is exhibit P1,
Original deed of guarantee.
exhibit P1, 20th day of May
77.
1977 is date, the execution of the guarantee deed. Para 14 of the guarantee deed. Guarantee herein contained shall be a continuing one for all amounts advanced, including the interim payments or the amounts. My lord, I will pause here for a minute.
Where are you reading?
Lord, para 14, my lord. Para 14, my lord, recital of the guarantee deed.
One second.
Guarantee herein, the lordship.
This is just 47 years old document. So handle ಮಾಡ್ಬೇಕಾದ್ರೆ we have to be careful. Yes. Para 14.
14. Guarantee herein contained shall be a continuing one for all amounts advanced. My lord, now I pause, my lord. Kindly turn to that Chanvirapa's judgment, my lord. The head note. Continuing guarantee, providing that guarantors agree to pay on demand, limitation period for claim under such guarantee, event from which it begins to run. Articles in Limitation Act 1963 applicable. Possible meanings of word on demand explained. Necessity of account into which borrowed money was being deposited to be a live account. Lord, here the question is the continuing guarantee. So long, Lord, it will continue to be in existence, be in full force until and unless the borrower company or the guarantors, my lord, settle the account. Lord, settle the account, the dues of the corporation have to be settled. So long as the dues are not settled, it is a live account. Lord, now kindly.
So the live account, what the Supreme
Yes,
Court
my
said there is, if it is live against the principal borrower, it is live against the guarantor also.
Correct. My lord, now I want to rely on, my lord, passing on to compilations. ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ ನಿಮ್ಗೆ? ಕೊಟ್ಟಿಲ್ವಾ?
No, which paragraph you referred in this syndicate banks?
Para 17.
No, here
He,
it was,
the
here,
head note.
he showed only head note.
Head note, head note. I did not want to trouble your lordship reading the entire judgment.
No, it doesn't say even that head note does not say that merely because they have executed the guarantee agreement, it can be it can be recovered.
All I
at
am
any
saying
time.
is, so long as the account is live, it is not
What
settled.
is the meaning of so long as the account is live?
So long as the account is live means it has not been settled.
No,
Dues
no.
have not been
They have
cleared.
not said like that in that judgment. They say the account is live until.
Lord, the interpretation of a live account is
That-
that the amounts have to be settled in respect of the loan account. That is the interpretation, my
has
lord,
not
that we
said
have
like
to
that.
give.
If I read it correctly, it says account liability is live until the liability against the principal borrower is not time barred. That is the definition, interpretation there. Hello, on paragraph.
The editor, what is, you read the relevant paragraph.
Even there also it is said.
Para 17 clearly explains.
Para 17.
1/7.
No, because we have read this in some other context.
Yes, yes. Para
Lord,
17 very clear.
that is why, my lord, I was
In view of para
persuading
17
your
life
lordship
account and its definition. In view, we have taken, it is necessary to consider the meaning of the words live account used and referred to in Samuel's case. Suffice it to say that interpretation by the courts below placed on the words live account, that they refer to an account which is operational
your lordship.
and not dormant may not be sound. This court itself had indicated that live account means an account that is not settled. The use of the term settled gives an indication that live account refers to an account where the balance has not been struck by an account stated or account settled. We may in this we have referred to the following observations. They have said in this statement, so long it is live against the principal
Yes,
borrower.
my lord, kindly turn to para 5.3, my lord, of the judgment. The guarantee bonds have been executed. Your lordship got it. 5.3 para
5.3
of the Chenvirappa's judgment.
that is about the facts it seems.
Illa 5.3. Page 513.
5.3, yes.
Yes, the guarantee bonds have been executed in the standard form of the bank. The relevant portions of the guarantee bond dated 10/8/85, the bonds are similarly worded or extracted below, so and so. Now kindly come to the H, my lord, 5.3 H, notwithstanding the last two lines. Notwithstanding the borrower's accounts or accounts with syndicate bank may be brought to credit or the credit given to the borrower fully exhausted or exceeded, or howsoever the said financial accommodation varied or changed from time to time, notwithstanding any payments from time to time or any settlement of account, this guarantee shall be a continuing guarantee for the payment of ultimate balance to become due to syndicate by the borrower, not exceeding so and so, as aforesaid. Notwithstanding the discontinuance of this guarantee as to one or more of the guarantors or the death of any one of them, the guarantee is to remain a continuing guarantee as to the other or others or the representatives and estate of the deceased, and where there is more than one guarantor, their liability under these presents be construed as joint and several. Any account settled or stated by or between syndicate and the borrower or admitted by him or on his behalf may be adduced by syndicate and shall in that case be accepted by the guarantors and each of them and their respective representatives as conclusive evidence that the balance or amount thereby appearing is due from to syndicate. Margarita Lalita Samuel versus Indo Commercial Bank was relied on. Both sides dealt with the question of limitation with reference to a continuing guarantee. In that case, the guarantor sought to avoid liability by contending that every item of an overdraft account was an independent loan and the limitation would start from the date of each loan, and that with reference to such dates, the suit was barred by limitation. While negativing the said contention, this court observed, in our view, it is unnecessary for the purposes of the present case to go into the question of the nature of an overdraft account. The present suit is in substance and truth one, to enforce the guarantee bond executed by the defendant. In order to ascertain the nature of liability of the defendant, it is necessary to refer to the precise terms of the guarantee bond rather than embark into an inquiry as to the nature of an overdraft account. After referring to the terms of the guarantee bond, this court held the guarantee is seen to be a continuing guarantee, and by the undertaking by the defendant is to pay any amount that may be due by the company at the foot of the general balance of its account or any other account whatever. In the case of such a continuing guarantee, so long as the account is a live account in the sense that it is not settled and there is no refusal on the part of the guarantor to carry out the obligation, we do not see how the period of limitation could be said to have commenced running. Lord, so my humble submission, my lord, is so long as the account is not settled, the dues have not been cleared,
Yes.
it has to be taken, my lord, the continuing guarantee will still be enforced, the guarantor is liable to pay.
Failure, denial. When did you issue the notice after sale?
My lord, notice was issued in 93.
Not to this. Sale was in 1984. Correct. When
Yes,
did you-
sale 15/11/84. 15/11/84.
15/11/84.
Houdu.
To respondent number 1, you did not issue notice till 1993 for about 10 years.
Lord, question is not issuing a notice, my lord, will not give me any cause of action. My lord, the enforcing of a guarantee under the terms of the deed.
No. To consider, see, this judgment says if the debt is barred against the principal borrower, then it is barred
Lord, we
against.
are not on that question, my lord, whether it was barred against the principal debtor. I am not on that point. I am on the point of enforcing a guarantee against a guarantor when the time has to start. We are on that point.
Correct, on that point.
So
hold on.
therefore, my lord, my humble submission is, so long, my lord, the Supreme Court has held, so long as the account is live, it is not settled.
Refer to
Lord,
that paragraph.
the- Lord, para 14 of the guarantee deed, my lord, which I,
Not para 14, this judgment you referred, no?
this judgment, my lord, you lord,
Para 5 point ಎಷ್ಟು ಹೇಳಿದ್ರು?
ಹೌದು 5.3 ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಪೇಜ್ 514 ಅಲ್ಲಿ ಎಂಡ್ ಅಲ್ಲಿ the guarantee is seen, I may read, my lord, once again.
Yes.
The guarantee is seen to be a continuing guarantee and the undertaking by the defendant is to pay any amount that may be due by the company at the foot of the general balance of its account or any other account, whatever. In the case of such a continuing guarantee, so long as the account is a live account in the sense that it is not settled and there is no refusal on the part of the guarantor to carry out the obligation, we do not see how the period of limitation could be said to have commenced running.
Right.
So, my lord, my submission is 93 when I issued a notice, my lord, limitation, my lord, started and when he
Ultimately, in that judgment, it is said each should go by the words of the guarantee deed.
What is
ಅಂತ
the
ಎಲ್ಲ.
decision in this judgment? Please read that. This is one of the judgment called out. What is the syndicate?
We follow ಅಂತ ಹೇಳ್ತಾರೆ.
Para 15 onwards.
please, my lord.
We follow it ಅಂತ ಹೇಳ್ತಾರೆ, but in one paragraph it is said that it depends upon the each document ಅಂತ ಹೇಳಿದ್ದಾರೆ.
The respondent, may I read from page para 15? The respondents have tried to contend that when the operation ceased and the accounts became dormant, very cessation of operation of accounts should be treated as a refusal to pay by the principal debtor as also by the guarantors, and therefore limitation would begin to run not when there is a refusal to meet the demand, but when the accounts became dormant. By no logical process, we can hold that the ceasing of operation of accounts by the borrowers for some reason would amount to a demand by the bank on guarantor to pay the amount due in the account or refusal by the principal debtor and the guarantor to pay the amount due in the accounts. In view of the above, we hold that the time began to run not when the operation ceased in the accounts in mid-1986, but on the expiry of 15 days from 12/10/1987, when the demand was made by the bank and there was a refusal to pay by the guarantors. The suit filed within 3 years therefrom is therefore in time. In the view we have taken, it is not necessary to consider the meaning of the words live account used and referred to in Samuel. Suffice it to say that the interpretation by the courts below placed on the words live account and that they refer to an account which is operational and not dormant may not be sound. This court itself had indicated that live account means an account that is not settled. The use of the term settled gives an indication that a live account refers to an account where the balance has not been struck by an account stated or account settled. We may in this behalf refer to the following observations in Bishan versus Girdhari Lal. The essence of an account stated is not the character of the items on one side or the other, but the fact that there are cross items of account and that the parties mutually agree the several amounts of each, and by treating the items so agreed on the one side as discharging the items on the other side pro tanto, go on to agree that the balance only is payable. Such a transaction is in truth bilateral and creates a new debt and a new cause of action. there can be an
So
account.
we asked you whether there was any revival of debt or debt acknowledgement on that.
My lord, here, my lord, question of my lord, acknowledgement will not arise on behalf of guarantors, my lord. It is a,
Principal debtor.
there can be an account stated, although the balance of indebtedness is not throughout in favor of one side, it is irrelevant whether the debt in favor of the final creditor is created at the outset by one large payment or consists of several sums of principal and several sums of interest. Nor is it material whether the only payments made on the other side were simply payments in reduction of such indebtedness or were payments made in respect of other dealings. In any event, items must be ascertained and agreed on each side before the balance can be struck and settled. Some arguments were addressed about the article of limitation that could apply in respect of a suit against the guarantors. Samuel held that in case of a refusal of a guarantor to pay the amount, matter would be governed by Article 115 of the Schedule to the Limitation Act, which corresponds to Article 55 of the Limitation Act 1963. One of the submissions made before us was that the term compensation for breach of contract in Article 55 indicates a claim for unliquidated damages, not a claim for payment of a sum certain. As to what is the difference between a claim for unliquidated damages and a claim for a sum certain or a sum presently due, reference can advantageously be made to the classic statement of law by Justice Chagla in Iron and Hardware India Company versus firm Shamlal and brothers. If Article 55 does not apply, then a claim against a guarantor in such a situation may fall under the residuary Article 113 of the Limitation Act 1963, corresponding to Article 120 of the Old Act. The controversy about the appropriate article applicable when the claim is found to be not exactly for compensation, but ascertained sum due has been referred to as long back as in 1916 in Trikomdas Kaverji Boja versus Gopinath Thakur under the Old Limitation Act. The periods prescribed were different under Articles 115 and 116. The periods prescribed were also different under Articles 115 and 120, but under the 1963 Act, period of limitation is the same, 3 years, both under Article 55 and 113. Having regard to the fact that the period of limitation is 3 years, both under Article 55 and Article 113, and having regard to the binding decision in Samuel, we do not propose to examine the controversy as to whether the appropriate article is 55 or 113. Suffice it to note that even if the article applicable is Article 113, the bank suit is in time. In view of our finding that suit is not barred by time, we allow this appeal, consequently so and so. But therefore, my lord, this judgment did not go into the question of, my lord, the guarantor, my lord, being not liable.
Para 14 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. If the debt is barred by
Para 14, Lord.
14 ಅಲ್ಲಿ.
We have to, however, may I read para 14? We have to, however, enter a caveat here. When a demand is made by the creditor on the guarantor under a guarantee which requires a demand as a condition precedent for the liability of the guarantor, such demand should be for payment of a sum which is legally due and recoverable from the principal debtor. If the debt had already become time barred against the principal debtor, the question of creditor demanding payment thereafter for the first time against the guarantor would not arise. When the demand is made against the guarantor, if the claim is a live claim,
Yes.
thus that is a claim which is not barred against the principal debtor, limitation in respect of the guarantor will run from the date of such demand and refusal, non-compliance, where guarantor becomes liable in pursuance of a demand validly made in time. The creditor can sue the guarantor within 3 years, even if the claim against the principal debtor gets subsequently time barred. To clarify the above, the following illustration may be useful. Let us say creditor makes some advances to a borrower between 10/4/91 and 1/6/91, and the repayment thereof is guaranteed by the guarantor undertaking to pay on demand by the creditor under a continuing guarantee dated 1/4/91. Let us further say a demand is made by the creditor against the guarantor for payment on 1/3/93, though the limitation against the principal debtor may expire on 1/6/94, as the demand was made on 1/3/93 when the claim was live against the principal debtor, the limitation as against the guarantor would be 3 years from 1/3/93. On the other hand, if the creditor does not make a demand at all against the guarantor till 1/6/94, when the claims against the principal debtor get time barred, any demand against the guarantor made thereafter, say, on 15/9/94 would not be valid or enforceable.
Clear illustration that.
Lord,
ಎಸ್ ಸೊ ಇದನ್ನ ಹೇಳುವಾಗ ನೆಕ್ಸ್ಟ್ ಲೈವ್ ಅಕೌಂಟ್ ಅಂದ್ರೆ ಏನು ಅಂತ ಡೆಫಿನೇಷನ್
correct.
ದಟ್ ವಾಸ್ ಡೆಲ್ಟ್ ವಿತ್ ಇನ್ ಪ್ಯಾರಾ 17.
Live in the context, live of a principal. If it is live, your
ಲೈವ್
right
ಅಕೌಂಟ್
to claim lives. If it is dead, your account automatically expired.
ರೈಟ್. ಸೊ ದೇರ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ಇದ್ರಲ್ಲೆಲ್ಲ ಒಂದ್ ಕಡೆ ಹೇಳ್ತಾರೆ ಈಚ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಎಕ್ಸಾಮಿನ್ ಇನ್ ದ ಕಾಂಟೆಕ್ಸ್ಟ್ ಆಫ್ ಈಚ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸಮ್ವೇರ್ ಸೆಗ್ಮೆಂಟ್
Yes, yes.
ಯಾವುದೋ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಅದು ಲೈವ್ ಅಕೌಂಟ್ ಅಂದ್ರೆ ಏನನ್ನೋದು ಪ್ಯಾರಾ 17 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. Yes.
That illustration is very clear on the point, my lord. And I refer to Deepak Bhandari, yeah,
It didn't complete.
I'm sorry.
Lord, my submission would be, my lord, as far as a continuing guarantee is concerned, my lord, the notice that I issued in the year 93 was well within time. Because the accounts were not settled, there was still due in the account. And therefore, the notice that I had issued in 1993 was well within time. Lord, your lordship may kindly see, 15/9/1984, property was sold.
Yes.
Property was sold. The amounts that were realized, my lord, was distributed amongst the three creditors. I received 24.69 lakhs. The amount was still due. My lord, I proceed, my lord, independently against the guarantor. My lord, the liability of the creditor and guarantor, my lord.
That he has not raised at all.
No, my lord, my lord, he has not raised. I am, my lord, persuading your lordships by saying that liability is joint and several. I have issued this notice in the year 93 against the guarantor, invoking the guarantee deed. Lord, therefore, my lord,
His claim was that by that time, the debt was time barred, even against the principal borrower. That is, but he did not raise this, that either he has not taken due diligence against the principal borrower or exoneration of the borrower, principal borrower, by that he is relieved, etc. Anta grounds of the other raised.
Allah, grounds ilde irbodu. But my lord, ultimately it comes to that whether the principal whether, my lord, I had not proceeded against the principal debtor, therefore the debt had become time barred. Ultimately, it boils down to that.
All right, what argument, sir? Now, what are the other judgments you were referring to so many?
Lord, some of the judgments, my lord, which I have.
Your point, governed by Article 137, that they may not be disputing.
Allah,
They are not disputing that Article 137 applies.
Yes, yes, anyway, which way now after the amendment to the 1963 Limitation Act, it's 3 years for both articles.
Whether Article.
Yeah, it doesn't matter.
Now this year 2004, from your synopsis, we can make out that you have referred it, relied on it to say that Article 137 of the Limitation Act applies. Correct?
Idralli, para 4.
No. Let us concentrate on the focal point. Now they are not saying that Article 137 is not applicable. Then why are you citing this year 2004 Karnataka 370?
Para 4, kindly turn to page 22 of the compilation, my lord.
Page 22.
Nextly, your lordship got it, my lord.
Yes.
Page 22. Nextly, Gaule has raised the point of limitation. para 4, he submits that there is a long gap of 12 years from the date of sale transaction and the year of institution of the miscellaneous case. The claim of the respondent corporation is hopelessly barred by limitation is the specific contention of the learned counsel. Such a contention is also repellable because under Article 137, Schedule 2 of the Limitation Act, 3 years period has to be reckoned from the date of accrual of the right to apply. In the instant case, 3 years have not elapsed from the date of issuing of the notice to enforce the guarantee and the institution of the proceedings in question. Lord, so, my lord, here also,
But what we're trying to say is.
I am
this is
trying
not
to
the
say, my lord,
point, he has raised.
93, my lord, 93, the notice was issued invoking the guarantee. Thereafter, my lord, the petition filed within 3 years. Thereafter, my lord, is well within time. That is what I want to say.
Correct. Now he has not raised that point. The point he has raised is that.
Lord, he
this
wants to say,
notice-
my lord, he will ultimately say that
This itself was
19,
time.
correct. He will say that 1984 sale took place. Thereafter, I did not do anything for 9 years. That is his contention. My lord, what I am trying to say is by invoking the guarantee, my lord, in 93,
Correct.
and
This-
thereafter the petition that is filed within 3 years is well within time. That is what I want to say.
this of June 2003, 2003 or 2005, this judgment. What you are relying?
My lord, this
No.
judgment, 27/6/2005,
27,
6/2005.
5. ಅದಾದ್ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಷ್ಟೊಂದು ಕ್ಲಾರಿಫೈ ಮಾಡಿದಾರಲ್ಲ. They don't proceed, I guess. ಅಕೌಂಟ್ ಲೈವ್ ಅಂದ್ರೆ ಏನು ಅಂತಾನೆ ಅದಕ್ಕೆ ಅಕೌಂಟ್ ಲೈವ್ ಅನ್ನೋದಕ್ಕೆ there should be what we are trying to running account. This is not the point raised why the judgment should be cited. Yes. All right, next.
Thereafter, my lord, kindly turn to page 49, my lord. As we have read Chanvirappa's case.
What is this next one? What we are trying to ask you is, give us only the judgments which are very, where the points are raised and.
Your
where
lordship
they
may
are
kindly see in
relevant
the
for
compilation itself, my lord, I have said, one regarding the limitation that has to be taken into account, second judgment, then
Hello,
as regards 31
We record from the date of accrual.
31 proceedings, sir, 31 proceedings,
Adin
not to be
base-
treated as a suit. It is in the form of a execution proceedings anta idu madodike the next citation 1979 SCC 193 Gujarat
19?
State 1979 1 SCC
ಈ
190.
ಮಧ್ಯದಲ್ಲಿ ಒಂದೇನೋ MFA ತಂದಿದ್ದೀರಲ್ಲ, ಯಾವ್ದಕ್ಕೆ ಅದು?
ಹೌದು, ಅದು ರೈಟ್ ಟು ಈಗ ಮಿಸ್ಲೇನಿಯಸ್ ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ ವೆನ್ ಮೈ
ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ಮಾಡಿಲ್ವಲ್ರಿ ಮುಂದೆ ಈ ಸೈಟೇಷನ್ಸ್ಗೆ
ಮಿಲಾರ್ಡ್
ಮುಂದೆ
ಸಾರಿ ಮಿಲಾರ್ಡ್
ಪೇಜ್ ಇಂಡೆಕ್ಸ್ ಮಾಡಿಲ್ವಲ್ಲ ಅದಕ್ಕೆ. ನಾವು ಈಗ ಪ್ರತಿ ಸರಿ ಇಲ್ಲಿ ನೋಡ್ಬೇಕು ಮತ್ತೆ ಇಲ್ಲಿ ನೋಡ್ಬೇಕು. ಒಂದ್ ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ಮುಂದೆ ಇನ್ನೊಂದ್ ಕಾಲಮ್ ಹಾಕಿ ಅದಕ್ಕೆ ಮಾಡ್ಕೊಡಿ ಮುಂದೆ.
ಅಪಾಲಜೀಸ್ ಮಿಲಾರ್ಡ್.
ಅಟ್ಲೀಸ್ಟ್ ಅದ್ರ ಮುಂದೆ ಬರೆದು ಕೊಡಿ ಎಲ್ಲಿಂದ ಎಲ್ಲಿವರೆಗೂ ದೋಸ್ ಪೇಜಸ್ ರನ್ ಫ್ರಮ್. ಒಳಗ್ ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ಮಾಡಿದ್ದೀರಿ ಅದ್ರ ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಬರ್ದಿಲ್ಲ. ನೋಡಿ 5760 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಅಥವಾ ನಿಮ್ದಕ್ಕಷ್ಟೇ ಬರ್ಕೊಂಡಿದೀರಾ?
ನಮ್ದಕ್ಕಷ್ಟೇ ಹಾಕಿದ್ದಾರೆ ಕೊಲಿಗೆ.
ಓಹೋ, ನೋಡಿ ಇಷ್ಟೊಂದು ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್.
ಐ ಆಮ್ ಸಾರಿ ಮಿಲಾರ್ಡ್, ಅಪಾಲಜೀಸ್.
Right, you do that, we'll take it up. ಯಾವಾಗ ಮಾಡ್ತೇವೆ? We'll continue because for particular. ಇದು ಮಾಡ್ಕೊಡಿ, ಯಾವಾಗ ನಾಳೆ ಮಾಡ್ಬೋದಾ? ಹಾ, ಲೇಡಿ ಮಾಡಿಕೊಡ್ಬೋದು. ಫ್ರೈಡೇ ಬೇಡ. We'll list it tomorrow, we'll see. ನಾ 2:30 ಅಂತ ಯಾವ್ದಾರ ಮಾಡಿದೀವ? You come at 2:30 tomorrow.
Tomorrow I have some personal income. I have got two parted matters, my lord.
All right, then.
Friday, my lord.
My lord, may I just, I'm sorry, I will never come in the way of a counsel if there's any, but kindly see, this matter we argued before the bench completely. And kindly see the order of this court on 20th February 2020.
Lord, I am, my lord, why should
okay, I'll leave it.
my
I'll leave it.
refer to that, my lord.
I'll leave it, I'll leave it.
understand
How is it?
What happened
I'll leave it,
before
I'll
the
leave it,
previous
I'll leave
bench? I can't understand this. I am ready to argue, but tomorrow I
Sorry,
am not personally.
I'm sorry.
Kindly have it on Friday.
Whatever date my friend wants.
You didn't have your lunch in the afternoon?
No, I had my lunch, my lord.
Right.
but, referring to the previous
Any
bench,
date,
we are
any time my friend wants to argue.
No, no. Tomorrow is saying some.
No problem.
Tomorrow, day after, my lord, two parted.
But our request is very
Yes.
material relevant ಇರೋದಷ್ಟೇ ಮಾಡಿ.
Friday, my lord.
For on it. Hard in part for further hearing this one for.
2:30,
PH initiation ಮಾಡ್ಕೊಡು ಅಂತ ಹೇಳ್ರಿ ನಿಮ್ course.
ಆಯ್ತು ಮಾಡಿ.
on that day at 2:30 PM.
2:30 ಬೇಡ. ಯಾಕಂದ್ರೆ criminal appeals ಇರುತ್ತೆ.
All right, all right.
Take up.
I'm
your-
grateful.
Because this is also very old matter. No?
Yes, it is an old matter, my lord.
This is before the trial court 94, huh?
Absolutely.
The kind leave of this honorable court, seal number 26, please.
We are trying to give it a closure, my lord.
ಅದು ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ whether had submitted any synopsis
We will, my lord, we will.
ಮಾಡಿದ್ರೆ
Yeah.
Admissions and
I will.
brief ಆಗಿ ಒಂದು
Please.
synopsis ಇದೆ. Yes.
Seal number 26, my lords. Kindly have it next week. I represent the respondent. ನಾಳೆ list continue ಆದ್ರೆ ಸ್ವಲ್ಪ inconvenience ಇದೆ on 2 days, so
When do you want it?
next week.
Yeah. Who is there on the other side? Like,
I represent the
there.
respondent.
There. As
ಇಲ್ಲ, they won't appear.
list in the next week. All
Please, oblige.
Serial number 32.
ಎಲ್ಲಾನು ಒಂದೊಂದಾಗಿ ಕರೆದು
32, madam.
We'll call all the matters.
32.
18, PD Surana, pastor matter.
Tomorrow ಅವ್ರು ಏನ್ ಹೇಳಿ ನೋಡಿದ್ರ records because it was not matching whatever he was submitting and the records ನೋಡ್ಬಿಟ್ಟು ನಾಳೆ ಅಂತ ಹೇಳಿ ನಾಳೆ ಮತ್ತೆ ಯಾವ್ದೋ ಪಾಠ ಏನು ಹೇಳೇ ಇಲ್ಲ ಅಂತ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೇಯಿಂಗ್ ನಾಳೆ ಹಾಕೋದು ನಾಳೆ ರಿಪೀಟ್ ಅನ್ಲೆಸ್ ಟುಮಾರೋ
Number
35, my lords, serial number 35.
wait, we are going number wise because so
Number
many people
20.
are waiting today unusually even
Sona
if
Vargun.
serial number
20.
for the response next week 2016 ಇದ್ದ ಇದು list in the next week case not reached list in the next week
Seal number 21, Mithun GA, V Ravindra.
next week I'll request you list in the next week settlement ನೀವು ಸೆಟಲ್ ಮಾಡ್ಬೇಕು ನಾವು ಡೈಲಿ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ ಅದು ಏನು ವಾಟ್ ಇಸ್ ದ ಡಿಫರೆನ್ಸ್
5 lakhs ಒಂದಿದೆ ಇನ್ನೊಂಚೂರು ಒಡವೆ ಕೊಡಿ ಅಂತ ಇದ್ದಾರೆ ಒಡವೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಇನ್ನೊಂಚೂರು ಮಾತಾಡಿದ್ರು
ಆಯ್ತು ಒಂದು ಡೇಟ್ ಹೇಳಿ ಹಾಗಾದ್ರೆ ಅವತ್ತು ಯು ಕೀಪ್ ದ ಪಾರ್ಟೀಸ್ ಆಲ್ಸೋ ಪ್ರೆಸೆಂಟ್ 21 both counsel 1 second submit that the matter is likely to be settled the party shall be kept present on 15 at 15 list on 15
Number 22, VR Balraj.
ಮುಗಿಸಿದ್ರೆ ನೀವು ಅದನ್ನ ನೋಡಿ ಏನಾದ್ರೂ ಮೈನರ್ ಡಿಫರೆನ್ಸ್ ಇದ್ರೆ ಮಾಡಿ ಮುಗಿಸಿ
I represent respondent in this matter. Kindly have this matter on 10th, madam. To report.
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ಸ್ ಡೇ ಅಂತ ಇಲ್ವಾ as requested by response counsel list on 10
Great.
Number 23, Andhra TNK.
Appearance form.
ಎರಡು ಕನೆಕ್ಟೆಡ್ ಇತ್ತು 23
Appellant.
appellant as requested list ಯಾವಾಗ ಬೇಕು next week ನೋಡ್ತಾರೆ ಇಯರ್ ವೈಸ್ ನೋಡಿ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ
Seal number 24, Praveen Kumar GR.
Appellant, your lordship.
Respondent, your lordship. Next week, your lordship.
Next week.
list in the next week ಇವೆಲ್ಲ there are many matters ಈ 24 ಒಂದು ಮಾಡಿದ್ರೆ 3 matters ಇದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ
Seal number
we can
25,
mention next week
25, Anian Joseph.
non-filing of acknowledgement for having paid cost of rupees 200 to HCLSC. Who had to pay the cost here? Respondent Vidya Chandra Singh notice respond held sufficient. ಯಾರು ಕೊಡ್ಬೇಕಿತ್ತು ಕಾಸ್ಟ್ ಇದರಲ್ಲಿ and why costs were imposed? ಅವೆಲ್ಲ ಕೆಳಗಿನ ಮೆನು ನಾನ್ ಫೈಲಿಂಗ್ ಎಟ್ಸಿಟ್ರಾ ಅಂತ ಇದೆ ವಾಪಸ್ ಇದ್ರಲ್ಲಿ ಬರ್ಬೇಕಲ್ಲ ಇಲ್ಲ ನಾವೇ ಇಲ್ಲಿ ಏನ್ ಕಾಸ್ಟ್ ಏನು ಹಾಕಿಲ್ವಲ್ಲ ಯಾವ್ದು 28/6/2023 ಅಲ್ಲಿ ಹಾಕಿದ್ದ 28/6/2023. Thirteen 74 days delay for the cost synopsis. ಇಲ್ಲಿ ಆರ್ಡರ್ ಡೇಟ್ 28/6/2023 ಅಂತ ಹೇಳ್ತಾರೆ. ಅದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ ಕಾಸ್ಟ್ ರಿಜಿಸ್ಟರ್ ಬರ್ದಿದ್ ತಪ್ಪಿದೆ ಅದು. ಕರೆಕ್ಟ್ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರು ಅಂತ ಮಾಡಿದೀವಿ. ಅಪ್ಲೋಡ್ ಒನ್ ಮೋರ್ ಅಪರ್ಚುನಿಟಿ. ಇಲ್ಲ ಒಂದು ರಿಜಿಸ್ಟರ್ ಬರ್ದಿದ್ದು 28/6/2023 ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿದ್ರು ಅಂತ ಬರೀತಾರೆ. But no cost were imposed on that day. ಸ್ವಲ್ಪ ಇದ್ರಲ್ಲಿ ಚೆಕ್ ಮಾಡ್ರಿ ಇವರು ರಿಟರ್ನ್ ದಟ್ ಆನ್ 28/6/2023 ಕಾಸ್ಟ್ ವೇರ್ ಇಂಪೋಸ್ಡ್ ಬಟ್ 28/6/2023 ನೋ ಕಾಸ್ಟ್ ಆರ್ ಇಂಪೋಸ್ಡ್. ನಮ್ ರಿಜಿಸ್ಟರ್ ಬರ್ದಿದ್ದನ್ನು ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಬರ್ದಿರ್ಬೇಕು ಅಷ್ಟೇ. ಎಲ್ಲಿ 28/6 ಯಾವ್ದು ಆರ್ಡರ್ ಇಲ್ಲ. As per registry is not on 28/6/2023 costs were imposed, but no such order is forthcoming on that day. In the order sheet of that day, registration verify and list tomorrow. And ಮೊದಲು ಒಂದು ಬರ್ಕೊಂಡು no representation for the appellant. Yes, next is
number 27. Subhash Reddy. Gayatri Swami.
ಇದರಲ್ಲಿ ಆಯ್ತು ನನ್ನ ಕೇರ್ ಸೆಕ್ಷನ್.
Number 28, KV Narasimhan.
Serial number 28 for respondent.
Pardon?
Respondent, serial number 28.
Representation for
One
appellant agent. Yes.
Serial number 29, KV Satish Chandra. Sri Prakash.
ಒಂದ್ಸರಿ ಕೊಂಡಾಗುತ್ತದೆ ನನ್ನ ಕೇರ್ ಸೆಕ್ಷನ್. Yes.
Serial number 30, Haveri SS. Somshekar ARP.
ರೆಡಿ ಅಂತ ಇದೆ ಇದೆಲ್ಲ ಅಷ್ಟೇ ನನ್ನ ಕೇರ್ ಸೆಕ್ಷನ್.
Serial number 31, Raju CN, KR Ringraju.
ಅಷ್ಟೇ ಇದನ್ನ see.
Serial number 32, Anil Shekhar KS.
Next week. My submission is my respondent number 2 is my agent, I have moved this matter.
Yeah, filed application for.
Why he has taken already time?
I am not taking time now. Court has no.
All right, my submission is.
ನೋಡಿ.
They have to.
ರಿಲೀಸ್ ಆಗಿಲ್ವಾ ಅಮೌಂಟ್?
ಇಲ್ಲ, not.
Kindly have it on day at least day after tomorrow. If he has got any.
Tomorrow I have inconvenience.
Thrice he has taken 2 weeks.
Not tomorrow, any other day.
On 5/5, he remained absent on 18th.
Any other day, not tomorrow, any other day.
ಆಯ್ತು as requested list. Sorry, on day after tomorrow ಅಷ್ಟೇ. Day after tomorrow criminal day ಇಲ್ಲ. ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳೋಣ ಬಿಡಿ. ಕ್ರಿಮಿನಲ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಮತ್ತೆ ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳೋಣ. 9/7 ಅಲ್ಲಿ ನಿಮ್ದು 2018 ರೀಚ್ ಆಗ್ತಿರೋದಿಲ್ಲ.
Serial number 33, Adinarayanappa.
Tomorrow. Respondent.
RCT ನಾಳೆ ಅಷ್ಟೇ ರಿಪೀಟ್ ಟುಮಾರೋ.
Serial number 34, Benjamin VJ. Sunita HC.
ಇದನ್ನೇನು ರಿಪೀಟ್ ಮಾಡೋಣ. ರಿಪೀಟ್ ಟುಮಾರೋ. Yes, next
Serial number 35, RR Desai. Veena J. Kamath.
Respondent wife, my lord, there is some urgency. Even if at the instance of this court, ಈ ವಾರ ಹಾಕಿದ್ರು ಒಳ್ಳೇದಿತ್ತು ಸ್ವಾಮಿ.
ಈ ವಾರ ಆಗೋದಿಲ್ಲ, ಮುಂದಿನ ವಾರ ತಗೊಳ್ಳೋಣ.
Then can it be on 11th, my lords? 8th and 9th I will be inconvenient. Or 10th or 11th.
10th.
10/7. number 36, Nagesh, yes.
Sorry, repeat ಮಾಡಿ.
37, J. Naveen, Prabhakar Lakshman.
Repeat next.
38, Nagaraja, yes. B.T. Mohan.
Repeat ಮಾಡಿ. Next.
39, Kempraju, K.M. Basvaraj.
Repeat. 40.
40, Sudhakar B.
I have some inconvenience tomorrow, next week, my lord.
As requested by the appellant's counsel, list in the next week. Yes.
42, Bindu U.
Repeat ಮಾಡಿ.
43, Naik NR.
In this case, my lord, the 10 lakhs rupees I have deposited, entire amount they have received. That is the 10 lakh was discussed by the predecessor of your lordship. And remaining amount, my lordship, I am not liable to pay because she is having all the board articles with her. Therefore, the confirmation order is required. She has availed the divorce and directed me to pay 15 lakhs rupees as matrimonial.
44, B.V. Ananda.
For the respondent, Your Honor, I want it on 9th, Your Honor, 9th.
Wakalat filed HCLC, no, ಇದು?
Yes,
Requested by response counsel. You want it on 9th?
9th.
9th of when? What is
9th
the-
on Tuesday.
Tuesday, all right, 9th.
Much obliged.
Cell number 45, Siddharth B. Muchandi, Nizam Abbas.
ಯಾರೇ ಇದೆ? Repeat it.
46, K. Ravishankar, Sachin B.S.
Repeat. ಎರಡಿದಾವೆ.
49, Hanmantappa A.
Repeat. Repeat.
50, Hanmantappa.
Repeat.
Sampak Bapat.
Repeat ಮಾಡಿ.
52, Ajit PB. YK Narayan Sharma.
Repeat.
53, Sudhakar.
My lord,
Sri Prakash.
next week,
Next. Requested by the appellant's counsel, list in the next week.
please.
Slowly, madam.
Right. ನಾವು ಇದ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಇವಾಗ ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಒಂದ್ ನಿಮಿಷ 43 ನಾಳೆ. Registration verify and list on tomorrow. ಇದು ನೋಡ್ಕೊಂಡು ಬಿಡ್ತೀನಿ.
ನಮ್ದು ಫ್ರೈಡೆಗೆ ಹಾಕಿದಾರಲ್ಲ, ಫ್ರೈಡೆಗೆ.
ಅಲ್ಲ ಫ್ರೈಡೆ ಅಲ್ಲ ಸರ್, ಥರ್ಸ್ಡೇ.
ಥರ್ಸ್ಡೇಗೆ ಹಾಕಿದಾರ.
47. ಮೇಡಮ್ ಸಿಲ್ ನಂಬರ್ 19 ಏನ್ ಹೇಳಿದ್ರಿ ಹೇಳಿ?
ನಾನು ಫ್ರೈಡೆಗೆ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
ಇಲ್ಲ ಫ್ರೈಡೆ ಮೇಡಮ್.
489.
ಹಾ.
Part for further hearing this one 4.
ಫೋರ್ತ್. ಫ್ರೈಡೇನು ಪಾರ್ಟೆಡ್ ಇತ್ತು.
ಫ್ರೈಡೆ ನಿಮ್ಗೆ ಹೇಳಿಲ್ಲ ಮೇಡಮ್, ಇದನ್ನು ಹಂಗೆ ಸೈನ್ ಇತ್ತೊಳಪ ಇದನ್ನು ಇದು ನೋಟ್ಸ್ ಅಲ್ಲೇ ಇಡಬೇಕು ಇದನ್ನೆಲ್ಲ. ಸೆಲ್ ನಂಬರ್ 18 ನಾನು ರಿಪೀಟ್ ಮಾಡ್ಕೊಂಡು. ಅಯ್ಯೋ ಅದೇನೋ ಆ ಹುಡುಗಿ ಸ್ವಲ್ಪ ಹಂಗೆ, ಅದೇ ಸಂಗೀತ ಬಾಗಿನ ಫ್ರೆಂಡು. ಭಾಷೆನೇ ಹಿಂಗೆ ಅದು ನೋಡಿ ಆರ್ಡರ್ ಡೇಟೆಡ್ 10/6/24. 10/6/24. ಇದು 10/6 ಅಲ್ಲಿ ಇದು ಫಾರ್ 1 more 28/6 ಅಂತ ಹಾಕಿದಾಳೆ. ಅಂದ್ರೆ ಒಂದು 11 consecutive 6 To afford one more choice, time granted ಅಂತ ಹೇಳಿ ಮೇಡಮ್ ತೋರಿಸ್ತೀನಿ ಇಲ್ಲಿ. ಇದು ಕರೆಕ್ಟ್ ನನಗೆ ತೋರಿಸಿದ್ರೆ ಇದು ಹಳೇದ್ ಹಾಕಿರೋದು ಇದು ಟೈಮ್ ಕಂಟೆಡ್ ಅಂತ ಬೇರೆದು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಕರೆಕ್ಟ್ ಆಗೇ ಇದೆ ಅದು ಒಂದ್ಸಲ ತೋರಿಸ್ಬಿಟ್ಟೆ ಬರೀ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ. ಹಾಗಾದ್ರೆ ನಾನು ಈಗ ಕೇಳಿ ಏನು ಬರೆಯೋದ್ ಬೇಡ. ಅವ್ರೇನಾದ್ರು ರಿಪೀಟ್ ಅಂದ್ರೆ ರಿಪೀಟ್, ಇಲ್ಲ ಅಂದ್ರೆ ಪೇಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಏನಾದ್ರು ಡೇಟ್ ಕೊಡ್ತಾರ ಫರ್ದರ್. ಅದೊಂದು ತಗೊಂಡೋಗಿ ಮೇಡಮ್. ಇನ್ನೊಂದು ನಾಳೆ ಬರ್ಬಿಡಿ ಮೇಡಮ್. ನಾಳೆದಲ್ಲ 4774772489 ಬರ್ಬಿಡಿ. ಯಾಕಂದ್ರೆ ಅದನ್ನ ಒಂದ್ಸತಿ ಇದನ್ನ ಹೇಳ್ಕೊಂಡು ಬರ್ತೀನಿ. ನಾನು ಹೋಗೋದು ಬರ್ಬಿಡ್ತೀನಿ. ಬರ್ಬಿಡಿ ಅಷ್ಟೊತ್ತಿಗೆ ನಾನು ನಿಮ್ಗೆ ಇಟ್ಕೊಡ್ತೀನಿ. ಇವ್ರೆ ಬಾತಿ ಇದು ಅವ್ರು ಇದ್ರದ್ದು ಅವ್ರು ಇದು ಸೆಕೆಂಡ್ ಸೆಟ್ ಅಲ್ಲೇ ಇಡು. ಅದೇ 2489 ಇದೆಲ್ಲ ಫೈಲ್ಡಿಂಗ್ ಕೋರ್ಟ್ ಅಂತ ಬರೀಬೇಕು. ಇಲ್ಲಿ ಇಟ್ಬಿಡೋದನ್ನ ಅದ್ ಹಂಗೆ ಲಿಸ್ಟ್ ಆನ್ ಅನ್ಬಿಟ್ಟು ನಾಳೆ ರಿಪೀಟ್ ಹೊಡ್ಬಿಡ್ದು. 2489 ಇದು ಫೈಲ್ಡ್ ಇನ್ ಕೋರ್ಟ್ ಬೈ R1 ಅಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಷ್ಟೇ. R1 ಅದು ರಿಪೀಟ್ ನೆಕ್ಸ್ಟ್ ರೋಸ್ಟ್ ಹೆಂಗೆ